Good morning, Mr. Ramatsekisa. Good morning, Ms. Bowe.
Morning, Chair.
And I assume it's Advocate Serunye. A good morning to you too.
We have Advocate Peter Serunye, and Chair, he has indicated that he will be taking the oath. He's ready to be sworn in.
Thank you. Please place your full names on record.
My name is Peter Serunye.
Do you swear that the evidence you are going to give is the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Advocate Serunye, Commissioners, there should be, for the beginning of this session, there should be one file before you. It's labeled Advocate Peter Serunye Statement and Annexures. We will be making use of the other exhibit files, but I'll indicate when it is time to do so. Advocate.
I don't remember his statement referring to any of the other files. So you want to give us a tough time? No, please continue. Please start, Ms.
Chair, we can always rely on memory, but I'm afraid it might fail me.
Thank you.
Advocate Serunye, there should be a file in front of you containing your statement. Can you confirm that you have that file in front of you?
I do, Commissioners.
And can you confirm your signature at page 21 of that statement?
It is my signature.
And do you confirm that this is a statement that you have prepared for purposes of giving your testimony before the Commission?
I confirm that, Commissioners.
And do you confirm the correctness of this statement?
I do, yes.
Advocate Serunye, for the morning, I'm going to ask you to place the contents of your statement on record. We'll allow you to read through the statement, and there may be a few clarity-seeking questions, but a large part of the engagement will happen once we finish going through your entire statement.
Okay, thank you.
We can proceed at paragraph 1.
Thanks very much. Okay. Yes, I've prepared this affidavit, which reads, I, the undersigned Peter Serunye, do hereby make an oath and state that.
But please don't read your personal number.
Oh, thanks very much, Commissioner. That I'm an adult male Deputy Director of Public Prosecutions, employed by the National Prosecuting Authority of South Africa. I'm presently reassigned to the Investigating Directorate Against Corruption, commonly known as IDEC. The facts set out in this affidavit are, unless the context indicate otherwise, within my personal knowledge and are to the best of my belief, both true and correct. Where I refer to documents, I do so in summary. The documents themselves reflect their full contents and are annexed where indicated. I have been subpoenaed by the Commission to give evidence regarding my involvement in and knowledge of IDEC's criminal investigation into the allegations against Lieutenant General Samuel Dumisani Khumalo and 6 other crime intelligence officials regarding the appointment of Brigadier Mokwele, commonly referred to as the Mokwele matter in brackets, State versus Khumalo and others, and the matter of Major General Lushaba.
Advocate, don't you want to just highlight what you consider to be salient features or points on your employment history rather than reading the whole thing?
Yes, I'll do so.
Please,
yes.
Thank you.
Thank you, yes. Commissioners, in brief, and I refer from the paragraph under the heading Employment History and Experience, I take it that the affidavit has been read. In brief, I joined the Department of Justice in 1995 as a contract prosecutor, and I worked for a year until my position became permanent on the 1st of September in 1996. And I grew in the ranks of prosecution, working in all the courts, district, regional, and the High Court.
And I see that you even appeared before the Supreme Court of Appeal and Constitutional Court.
Indeed, Chair, I had an opportunity to appear twice, at least in the Supreme Court of Appeal, and the two cases went up to the Constitutional Court.
And you are an admitted advocate.
Sorry.
And you are an admitted advocate.
I am an admitted advocate. I was admitted in 2002 in Mabatu High Court.
Yes, yes.
I went through some of the causes that I've reflected in paragraph 6 of the affidavit, and I possess, as indicated in paragraph 7, a B.Juris degree and an LLB degree, both from the University of Vista University in 1994 and 2001.
You are like some of the older ones like me, old school. You have a postgraduate LLB.
Indeed, Chair.
Yeah.
I've also attended several courses as part of my training as a prosecutor, which I list in paragraph 9. In paragraph with the heading, the Investigating Directorate Against Corruption, I set out what the IDEC came about, and I want to believe, Commissioners, paragraph 10, 11, and 12, which deals with the setting up of the formerly ID and now IDEC by the President through a proclamation in 2019, has been dealt with by some of the witnesses. I'll therefore maybe starts from paragraph 13, if it's in order.
Yes, yes.
On 13 October 2021, I was issued with an authorization by then ID Advocate Hermione Granger, the then investigating director of the Investigating Directorate, to exercise powers as set out in section 24(2) of the National Prosecuting Authority Act 32 of 1998, and to appear on behalf of the state in criminal proceedings, appeals and matters arising from criminal proceedings instituted by the Investigating Directorate in all jurisdictional areas and courts within the Republic of South Africa, in respect of any offense envisaged in section 7, subsection 1, read with proclamation 20 of 2019, and section 28, 1, paragraph C of the National Prosecuting Authority Act 32 of 1998, and I attached as Annexure PS1 the authorization. On the very same day, 13 October 2021, together with the rest of the other deputies in the office, I undertook an oath of office before then Judge Ledwaba, Acting President Ledwaba, Deputy Judge President of the Gauteng Division of High Court, Pretoria.
I'm glad you corrected it yourself,
Thank you,
because
Commissioner.
that was my note here.
Thanks very much, Commissioner. Yes. And the oath was to uphold and protect the Constitution and the fundamental rights entrenched therein, and enforce the law of the Republic of South Africa without fear, favor, or prejudice, in accordance with the Constitution and law, as the circumstances of any particular case may require. I've attached to my affidavit the copy of the oath as PS2, Annexure PS2. Paragraph 15, within IDEC, my functions are principally the prosecution and the management and oversight of a group that deals with high-level corruption cases in the public and private sector. The group comprises of senior and junior state advocates, that is prosecutors, and then lead investigators, criminal investigators, financial investigators, as well as chief financial investigators, a data analyst, and a project manager. At the relevant time, IDEC operated through 4 groups, each headed by a deputy director of public prosecutions and a project who would then also be a project owner to cases under such groups. I headed the group dealing with high-level corruption in the public and private sector, as aforesaid. My colleague, who's now on pension, Advocate Low, oversaw cases in the security cluster, largely emanating from the intelligence services and the police. Advocate Anne-Marie Friedman oversaw ESCOM-related matters, and the late Advocate Dobada oversaw the Transnet-related matters. Following Advocate Dobada's passing, his group was taken over by Advocate Vedboy, who was a Deputy Director of Public Prosecution on contract. Each group carried both historical matters and matters generated from the recommendations of the commissions of inquiry. That is the State Capture Commission, commonly known as the Zondo Commission, the Empathy Commission, and the Nugent Commission.
Advocate Serunye, in paragraph 16, where you mentioned that Advocate Low has since retired, who has taken over that group?
It is now Advocate, her surname is also Low. Trying to remember, I can't remember her name now. Her Advocate surname is also Low.
Right, thank you.
Yeah, Talita Low, I think, yes.
Morning. When did Advocate Low retire?
At the end of April this year,
Okay, thank you.
2026.
Thank you.
Paragraph 17, at the time of the Mokwele and Lushaba matters, a significant part of our work was to identify potential cases from the recommendations and evidence of commissions of inquiry that I've earlier listed, the Zondo, Mpati, and Nugent Commission. In my group, once a possible matter was identified from a commission report, we would deliberate as a group, and I would then compile a memorandum, in brackets, an application addressed to the investigating director, motivating for the authorization of an investigation. Maybe just to add, Commissioners, the application or this memorandum, in the said application, I'll then set out the summary of facts as we would have detected them from, say, from the Zondo Commission report. A particular case, I just want to give an example, maybe let's say that deals with Sunday trading. I'll then encourage all my group members to read the particular chapter of the commission, and let's say we identify that particular case. We then summarize the evidence, and which is then going to form part of this application that I'm directing to the ID. And in the said application, I'll also then request the ID, if she finds that to be in order, to authorize the matter, either in terms of section 28, 1A, or 2813. And I also, in the application, ask her to authorize the designation of the officials that I would have listed in the application, financial investigators, data analysts, and so on. And the ID would then consider the application, and if it's approved, we then get a feedback via the project manager. Then we start working on the matter.
Purely out of interest, how would you identify cases that you would end up dealing with? Do you just rake through the record and say, oh, there's another one? You continue, there's another one, and then you deal with those. How exactly would you?
Yeah. Chair, like I indicated in the earlier paragraphs, I was overseeing a group that was dealing with high-level corruption in the public and private sector. So as we
I'm talking about commission matters, not, that's my focus, not your section 27 referrals.
Yeah.
Yeah.
We read through the report. The commission, Judge Zondo made certain recommendations. For example, when the commission would have dealt with the matter, they then make a recommendation whether law enforcement should look into that. There's recommendations which are directly say prosecution should be considered, and we follow those
Also,
type of
it's
cases where recommendations
that would
where
direct you
recommendations were
to,
made.
and then you go to the relevant parts of the report.
That is correct.
Okay, all right, all
Chair.
right.
And then Advocate Sirinya, in terms of the designation, when you give it as part of the application, do you indicate the individuals who will be forming part or who exactly chooses the composition of that team?
That is true, Commissioners, I do. In the application, I include a list of names of people.
And so it would be the DDs in their applications who would designate who would form part of the team?
Indeed, always in each of these cases, there must be a deputy director of public prosecutions who's the project owner, who's heading the group. And I must then have a balance of officials, a lead criminal investigator, a lead financial investigator, and maybe a junior criminal investigator and a junior financial investigator, prosecutors. And depending on the complexity of the case, I might have maybe two senior state advocates and a junior, and try and balance the team like that, including a data analyst and so on. But then I'm requesting the ID to then, and if she finds that to be in order, to approve that. It's not, I'm not making a decision at a time, it's just an application. The ID will then go through that. Sometimes she will then suggest, include chief investigator or maybe include two more prosecutors and so on. Then we change the documents, provide them to her again, then she signs it off.
Whether a Section 27 referral or a commission matter, would a matter ever commence within IDEC without a Deputy Director of Public Prosecutions being a part of the team? Ordinarily.
That shouldn't happen. That shouldn't happen.
Did it? Ordinarily, did it ever happen? Let's not talk about the matters that we are dealing with now. Yeah. Ordinarily, would that ever happen?
It will never happen. There must always be a deputy director, because as we go on with the investigation, there are documents that must be signed by the deputy. There's communication that we must make with outside stakeholders that must go under the signature of the deputy director.
So from inception, deputy is involved.
There must be a deputy
all right.
who's the project owner of the project.
In the application that you submit,
yes.
And you say that because in the nature of an application which is approved by the ID, you say she could make recommendations or suggestions that include others. In your experience, has she gone so far as to specify who by name, not just include another two investigators or a prosecutor? Have you had that kind of experience?
I've never had such an experience, commissioners, but she will suggest, maybe looking at the balance of the team, that you still need another prosecutor, either a junior or a senior, without specifying a name, without recommending, include so-and-so. She will just advise, beef up your team, you still need another data analyst or this or that, but without specifying a name.
Okay. And again, your experience, have you had experience where the ID picks the team for you? Have you had that kind of experience where she specifies these people that she has already spoken to, and you're married to them, so to speak?
I've never had such an experience, commissioners. It has never happened.
Thank you.
Yes.
I'm sure when you say it has never happened, you're not talking about the cases that we're going to be dealing with now.
I mean, in general, it has never...
Because on the face of it, it appears that what Commissioner Baloyi is asking is exactly what happened. That which you say has never happened appears to have happened in this instance.
Indeed, Chair, but
Yeah.
the question, as I understood it, was, in my experience personally,
In
to me,
your-
has
okay.
has the ID ever recommended to me that a particular person or team be, and that has never happened to me.
Okay, all right.
From paragraph 18, depending on the strength and detail of the available material, the memorandum would motivate either for an investigation under section 28(1)A of the Act or for a preparatory investigation in terms of 28(13). Such memoranda were ordinarily prepared and issued in my name as the DDPP responsible for the group. I deal with the oversight structure in brief in paragraph 19.
Advocate Sirinya, before you deal with the oversight structure, just to understand in the drafting process of these applications, whether you are motivating for 28(1) or 28(13), who all is involved in that? Is it you or is the entire team involved in the process of drafting?
It is the whole team. So, not necessarily that, but sometimes I'll sit with, say, a lead criminal investigator or a senior state advocate, but there are instances where I'll sit with the whole team, and because I would have said to them, read here, read those parts, let's deliberate, I'm intending to do the following, and therefore, as a team sitting, I'll also then get advice from other members of the team to say, Didi, maybe here, let's go for a 28(13), or let's go for a 28(1)A.
And in your experience, has there ever been a situation where the ID indicates to you that please draft an application in terms of either 28(1) or 13?
No, it has never happened to me in that sense, but there are instances where, let's say, my memo would ask her to authorize it, the matter in terms of 28(1)A, but after going through what we would have presented before her, I know of one matter where she would have said, no, not a 21(8). She then make notes on the memo. She sort of recommends or does not recommend. When she recommends, she make notes, or if she doesn't recommend, she also make notes saying why. Sometimes you can call me in and say, the evidence is insufficient, maybe at this stage. Maybe I propose you go for a 28(13), but she always make notes on top of that memo so that you understand when I go back to my team, I can also brief them to say, this is the outcome of the application.
In those instances, it would be on the back of you having made an application, not necessarily that she would approach you to say, make an application on her own, as it were.
Indeed, Commissioners, I would have made an application, and she then makes her recommendation. She has never approached me to say, I want you to do an application for this specific matter or for that specific matter. Neither has she ever said to me, include so-and-so in the application and don't include so-and-so in the application.
Right, thank
or
you.
in the matter, at least.
Thank you. You can proceed with the oversight structure.
All right. On paragraph 19.1, the investigating director, Advocate Andrea Johnson, heads the unit. The head of investigations and operations, the position is held by Mr. Matthew Sisoko. He sits at the same level as deputy directors and reports directly to the investigating director. Maybe you can just explain that. We have the ID as the head, and we have the 4 deputies directly underneath the ID. All of us reporting directly to the ID, and Mr. Sisoko is sort of on the same level with us, reporting to the ID. But we also on dotted lines report to him. He calls meetings, and we brief him on the cases because he has to directly report to the ID.
You say in your statement the dotted line reporting is in respect of, I think you said, operational matters. Would that be administrative matters, or what are operational matters? Because you say regarding your work, you report directly to the ID. I just want to have an idea of operational matters.
Yes. Chair, we report to Mr. Sissoko on, we brief him as the investigation, as we're busy with the investigation, we call, we even make reports, quarterly reports, and there's a structure which he's heading, where on a monthly basis we meet and we then present these cases to him with a view that he will then brief the ID on how far the cases are, where we need the resources, we'll inform him. Where we're having challenges, we inform him.
Oh, let me tell you where my confusion is. If you report to him about the progress of the matters, I would have thought that that relates to your work, about which you say you report directly to the ID. Do you see my confusion?
I get that, Chair.
And yet you say there is a distinction in that you report to him on operational matters. That's why I was saying these operational matters, are they perhaps administrative matters, but on what you've just said now, it seems you report to him in relation to your work as well.
True. Like we're duplicating the reporting. What we report to him, to some extent, we also, when we're having management meetings or meetings with the ID where we'll be deliberating on a specific matter, we also raise the same issues with her.
It seems to me there are no bright lines as to the difference in terms of what you report to him and what you do not report to him. There are no.
I'll agree with that, Chair. That's why I'm saying we sort of find ourselves reporting the same issues again to the ID when we meet with her.
Not that it matters for present purpose or in the bigger scheme of things. I don't think. Yeah. All right.
Thank you, Chair.
Please.
Yes.
Can I just, on this same question, I also wanted to understand the difference between the kind of reporting that you do, and more specifically, the purpose that you give reports to the ID as the matter is rolling, and the reports that you give to Mr. Sissoko, what the purpose is. And behind my question, I've sort of tried to give myself an answer that if you want decisions about a course of action that you are thinking of following, for example, we are now ready to get people arrested and presented to court. It seems to me that would be the kind of decision or report that would go to the ID. And then I'm not sure what Mr. Sissoko, the report to Mr. Sissoko would be, its purpose, what does it serve?
Yes. Indeed, Commissioners, what we report to the ID when we're ready with the takedown, those are issues that we'll discuss with the ID. We have a briefing where we take her through the evidence that we have, and decisions will then be made at that level. If she's of the opinion that you're still lacking on this or that, she has a right to advise. With Mr. Sissoko is on a monthly basis. There's this structure where we report, and if we're having problems of resources and so on, we report to him. We ask for those to be provided, and he can then help with those. If it has to be issues that he takes up with Human Resource Department, he does that on our behalf. But I want to believe that the purpose of that is for him to also then, when he reports to the ID, to say this team in relation to this matter, this is where they are, and these are the challenges that they are having, and so on and so on.
And is it a requirement, I want to say prescribed, but that's not quite the word. I think prescribed is too strong. But is it a requirement that on a monthly basis there must be reports? All the teams must report to Mr. Sissoko on a monthly basis?
That happens. It is a requirement. That happens. Project managers are in charge of they are responsible for doing those reports. Our meetings are held, or at least were held monthly, yes, with Mr. Soko, and then we'll then report on these cases.
In those reports, and maybe let me use an example. If you do you report to Mr. Sissoko in a way that he is able and he's allowed to say to you, I don't understand why you are deciding to prosecute this person, why you are deciding to arrest this person from what I have read. Is it that kind of reporting and that kind of engagement with him?
No, it is not, Commissioner. He does not question issues up to that level where he can say why these charges, why not those charges, or why. You know, it's more to report to him about the progress and where we're having challenges. Where it's not about him advising on. I know Mr. Soko used to be a prosecutor many years ago, but the function here for him is not to advise on legal issues or anything. He's more of a CEO in charge of our daily operations. Yes.
Thank you.
Sorry, Advocate Sirunya, I was just trying to be of assistance. Maybe if we look at the operations manual, so that will be in file 10.
I have file 10.
Just to, maybe I may be wrong, what is the OMC? Is this the committee that does
Yes,
the monthly?
It's this committee that is headed by Mr. Soko.
Okay.
Yeah.
Commissioner, so you'll see the definition of OMC is on page 12, but the provision I wanted to draw your attention to is on page 25.
Which heading?
My apologies, on page 24, which deals with the roles in IDAC. It's 3.3. It starts at 3.3.
Head of Investigations and Operations.
Yes, you'll see there, it's one of the duties is to convene the Operations Management Committee, and you'll also see under the topic Deputy Director Public Prosecutions, on page 25, this third from the bottom or second from the top, provide progress report to OMC and ID. Is this
The paragraph?
It's paragraph point 2 on page 25, the one that says provide progress
Yeah,
report
okay.
to OMC and ID. Is that what you're talking about?
Exactly. It is indeed so, Commissioners.
So this reporting structure is prescribed by this operations manual?
Indeed. I see the definition of OMC is Operations Management Committee
Yes.
on page 12.
Okay, thank you. We can then go back.
Yes.
I mean, for completeness, just to be clear, is this operations manual that we're looking at in effect at IDAC, as far as you know?
Indeed, Commissioners, it is. I think it was signed in 2024. Just trying to get the date. By Mr. Sissoko and the ID.
That's at page 10. And this is what guides your day-to-day operations?
This is what guides our day-to-day operations. Every new employee in the IDEC is given this manual to go through what I do in my group. As I welcome the new members, I'll then arrange a meeting. Let's say we have 3, 4, say maybe 2 prosecutors, 2 investigators. We'll have a meeting. I call all the members, and as part of what we're going to deal with in that meeting is to go through the manual, just for the new officials to sort of as an induction to the new
Okay.
officials.
Right, thank you. We can then return to your statement.
Yes.
We are
I
at paragraph
was-
19.2.
At 19.2, as I'm dealing with the structure, beneath the DDPPs are the senior state advocates and then the junior state advocates. And on the investigative side, IDEC drew both on investigators, seconded from the Directorate for Priority Crime Investigation, and on contracted civilians who were hired as financial investigators. They come with experience from different institutions like banks and SARS and so on. And we have criminal investigators, including a chief investigator. Chief investigators, we currently have 2. It's Chief Investigator Perumal and Chief Investigator Boy, Nico Boy. So all the investigators are reporting directly to the 2 chief investigators. On a monthly basis.
So does that mean, because there are 4 groups or teams, does it mean that 2 chief investigators are spread across all 4 teams?
Indeed so, Chair. They're spread within all 4 groups. On a monthly basis, the deputies, chief investigators, and project managers report on each matter through a structure chaired by the head of investigation operations, Mr. Sissoko, as I earlier indicated. The investigating director in turn reports to the National Director of Prosecutions and also to Parliament as and when she's called.
Advocate Sirunye, just on how you allocate, so you indicated that the prosecutors are split into the 4 groups. Does it happen that a prosecutor in Group A working on the security cluster, for example, can then do matters with Group C, who works on recommendations from the Zondo Commission?
We do have that cross-pollination. Before the time of Advocate Johnson, when it was Advocate Kronje, she wanted the groups, when you're designated to a group, you belong to that group throughout. But when Advocate Johnson came, she changed, and she was of the view that people should get experience in dealing with all the cases, type of cases, and therefore no one investigator or prosecutor is permanently based in a group. Where there's a shortage in another group, a person can be designated by that group that requires those services.
And in practical terms, how does that work? Is it only in the instance of shortage, or is there sort of a regularized rotation system?
No, it's not a regularized rotation. It's mainly when the shortages and sometimes when a new matter altogether is being designated, the deputy can choose prosecutors from other groups, especially those I wouldn't have worked with before, just to also give them a chance to deal with the type of cases that I'm dealing with in my group.
And would
But
you...
there's always this core group, that I have, that I would have started with for the last maybe 3-4 years.
And then would you, in an instance where you're working with a prosecutor from another group, would you then notify the DD there that you would be making use of one of their prosecutors?
That is true, Commissioners. Before I include another member from another group, in fact, I have to discuss with their deputy first and to inform them. And we then agree as deputies that, no, you can use the person. He's not having a lot of cases with me currently. Sometimes, as we're discussing in this structure, this OMC structure of Mr. Sissoko, those are some of the issues that we're discussing, to say, there's this other group that needs a data analyst. Is that data analyst available to be designated in that group, or this group requires 1 or 2 more prosecutors, and that is done at that level? But the discussion is held between the deputies. I cannot just take a prosecutor from another group or an investigator without informing the person that they report to. Because in the beginning of the year, our financial year runs from 1 April to 31st of March. What we do is I sign on behalf of the NPA stroke IDEC in contracts with the individual members, say the investigators, prosecutors who are in my group. Therefore, for that specific year, I have to assess their performance. On a quarterly basis, we do performance assessments and so on. So therefore, when we're having a person reporting in this group and in that group, we know that for that specific year, the person has signed a contract with, say, Advocate Friedman, and I'm also having some work that I'm doing with them for Advocate Friedman to know when she's doing assessment, performance assessment with the individual. I have to give her reports on how the person is performing in my group, what work they would have done, and so on. So there is that engagement between deputies.
How does it work when, with new matters that come in? So it's not arising from a report of a commission. We've come to understand that there's an intake process where matters they come in and then they are evaluated whether they fall into your mandate or not. So when such matters come, how do they land with you eventually as a DDPP, responsible for a team?
Yeah. Commissioners, I must say the manual talks to that process. I have, however, in my group, I've never dealt with it, Section 27, the matter which would have came via 27, but that process is dealt with, or at least explained in the manual. One would have expected that once the IDEC was set up, we're going to have a lot of cases being referred, or members of the public reporting cases to the IDEC. And therefore, the manual talks of a secretariat which will receive these cases coming via email or post and so on. And then there's an intake criteria which has to see it to then determine whether these cases belong in terms of jurisdiction in the IDEC and so on, which will compose of Mr. Soko will always sit in the intake criteria according to the manual. There'll then be a deputy and a chief investigator, I think, and it also recommends either senior state advocate or a chief investigator. So it's about 4 people interchanging. It's not a permanent structure, but I think Mr. Soko will always be part of that intake criteria according to the manual.
And have you, in the team that you're responsible for, have you had a situation where the ID approaches your one, I call them juniors, someone not other than you, the head of the team, yes, to look into a matter? Have you had that kind of situation?
I have never had that type of situation, Commissioners, except for this case that we're dealing with, that I'm here for today, where one of the juniors in my group was utilized for these Mukwele Lushaba matters without my knowledge and engagement.
So that's exactly what I wanted to ask about. So I'm going to pause
that
for
is
now.
the only one case. Otherwise,
okay, let me pause my question. We'll discuss it in more detail when we get to the specifics. Thank you.
Thank you.
You can proceed with
Yeah,
paragraph 20.
Paragraph 20, as a matter of practice, the groups do not share the detail of their respective matters with one another, and members sign non-disclosure undertakings. This is to guard against the leaking of information. Every matter is, however, headed by a DPPP who acts as its project owner. If I can just add on to this, on paragraph 20, the signing of non-disclosure forms. This is drilled into each and every employee that comes in, the non-sharing of information. So when a group is dealing with a case, only that group knows the facts, who are the suspect. Documents are only dealt by that specific group. I cannot be involved in the discussions of another group where it is we have met, unless if I am designated. There are cases where two, even more, deputies are designated in one group. We do this because sometimes people go on leave. You have a deputy is on leave and his group wants a Section 28 subpoena that has to go to the bank to be signed and on an urgent basis. Therefore, if I'm available, then I can sign that. But I can only do it if I've been designated to be part of that group. Otherwise, the non-disclosure the requirement comes into place. So we don't share information. That is why the person who occupies an office next door to me can be involved in this case, which, for example, a case that involves my neighbor and I wouldn't know about it because we don't share. Even when we're having our coffee and discussing matters, we don't talk about cases. If I have a problem, if I want to know something, and when we're discussing about the law or issues, we talk in general terms. I'm not going to say, colleagues, please help me. I have this case of so and so, and how do I go about? I can give them a scenario without talking to the names of the suspects in my case, to avoid information being shared amongst.
Advocate Serunye, the last sentence of your paragraph 20. Good morning. I don't think I greeted
Yes.
you. Good
Thank
morning.
you. Morning, Commissioner.
Paragraph 20, the last sentence, you say every matter is headed by a DPP who acts as a project owner.
Indeed.
Are there exceptions to that rule, if it's a rule at all? Because the matter you're talking about next, as I understand your statement, it was not headed by a DDPP.
Yeah. There is no exception to that rule.
Or there should not be.
There
There should
shouldn't
not be exceptions.
There shouldn't be.
So where there are exceptions, what is the problem and what is the reason for that?
The only exception that I know of is with this case, and I cannot explain it. I always believed that each case is going to have or must have a DDPP, because there are functions that a DDPP must do as the investigation unfolds. As I indicated earlier, when we need information from the banks, from cell phone providers, and so on, we serve them with a subpoena. That subpoena can only be signed by a DDPP. And if a group does not have a DDPP, I cannot see how they are going to be able to proceed.
And that's the whole point of a prosecutor-led investigation, that you need a senior prosecutor overseeing and guiding that investigation.
That is true, Commissioner. That is true.
So where that doesn't happen, what is the issue? What is the problem? I'm trying to understand. Because the case you're going to deal with, you're going to give us facts, but I'm more interested in reasons.
Yeah.
When no DDPP is appointed to head or to be a project owner of a matter, what could be the reason?
Commissioner, I find it difficult to explain. Because that shouldn't happen. That shouldn't happen. Otherwise, investigations are going to stall. They are going to find it difficult to get information from service providers. And in such a situation, you also don't have leadership. You don't have anyone guiding and helping the team, and so that they can wrap up. Everybody's going to do as they please. So that's why you need a leader in the form of a DDPP to help direct the team.
It's like a soccer team playing a match without a coach.
Indeed, Commissioner.
It can happen, but it shouldn't happen.
They are going to kick the ball all over without any direction. My involvement in the Mokwele matter at paragraph 21, on the morning of 27 June 2005, I arrived at the office as usual, around about 7:30. On my way to my office, I found colleagues in one of the offices discussing an arrest which IDEC had conducted the previous day, which was the 26th of June 2025. This arrest was on a number of high-ranking police officers.
Just, I'm thinking once an IDEC matter reaches the stage of an arrest, there would surely have been some investigations already.
Indeed, Commissioner, you cannot
Within,
arrest without...
that is investigations within IDEC itself.
That is what has to happen. You cannot arrest without doing investigations. You cannot arrest without coming to a decision that we've done so much work, we are ready, or we still have shortages here and here. So the team must meet and...
But we have enough to arrest.
We have enough to arrest.
Yes.
Yes.
Now, the way you frame it in this, in these two sentences, it appears you are not aware at all that there were any investigations, and not just investigations that ought to have led to the arrests you heard about this morning.
Yes. Chair, what I'm stating there, indeed, is I was not aware, but it's because this case was not in my group. I get to the office, and the office is buzzing with people talking about this big arrest that happened the previous day. That is what drew my attention to that. Everybody's talking about it. And
so it was not in your group?
It was not my case. It was not. I was hearing about it for the first time.
In whose group was it?
I didn't know at the time, and that is what then made me curious as well, because everybody's talking about that case. I wanted to find out, as I'm stating by the next paragraph, I then started asking around, which case are you talking about? Who's the DPPP? I stayed on paragraph 22, commissioners. Consistent with the practice that I described above, I had no prior knowledge of this matter. Out of concern, I inquired which group was responsible for it. No one appeared to know, at least from the people that I was talking to, no one appeared to know which DDPP was responsible, which I found unusual, since every matter is headed by a DPPP as its project owner.
Advocate Sereni, before you move away, was it out of concern at that point, or was it interest? And if it's concern, why were you concerned at that point?
Well, it was more out of interest. Everybody's talking about this case. It's, generals in the police arrested, and naturally, as a leader myself in the structure, that draws me to a point of wanting to know which cases, who are handling this case, which cases, and that is what then leads me to paragraph 3, where as I'm inquiring, I'm then told that Advocate Joy Tlatswayo, who was one of our junior state advocates, and who was at the time reporting to me, or reporting to my group, and who, without belittling her or anything, she was amongst the most junior in the office. I'm told she's the one who's handling this case. I established that she was appearing...
Can I just, before we forget it, from your description or allocation of the 4 streams and the DDPPs that you allocated there, it seems that Advocate Paul Lowe would have been the DDPP responsible for this stream, because I think you said intelligence, he was responsible for that.
Indeed, Commissioner. If things were done in accordance with the manual, yes. Advocate Lowe ought to have been the project owner, the DDPP in the case. But if I remember well, he was also there in the office that morning, and That is why he didn't appear to know anything about this case as well. And that is why, that is what was strange.
Yeah, another kink, as it were, would have been the fact that one of your prosecutors, Advocate Hlajwayo, was the prosecutor. You told us that if someone were to be taken from a deputy by another deputy, there would be a discussion between the deputies. Obviously, from what you say here, nobody had approached you and asked that Advocate Hlajwayo be part of the prosecution in another group or team. So, as I say, so that's another kink or that's another anomaly.
Indeed, Commissioners.
And I also see the name of Mr. Brian Padiachi. Was he not a senior investigator in your team?
Padayashi was not in my team.
He was not in your team.
Yes, I think he was in the security cluster.
Someone else's team.
Yes.
So it looks like
But it was strange that a junior prosecutor was reporting to me is allocated to this case without me having been engaged. Not that it doesn't happen, like I said, I would have expected, say, maybe Advocate Paul Lowe, if he was part of that group, to have discussed the matter with me, to say, we need a prosecutor, we're having a shortage. Do you have a lot of work for Joy? If I said, no, then we agree, they can utilize it.
And was this the right team for, or rather, was this the right case for Mr. Padiachi? Or was he too misplaced, as it were?
He's a senior criminal investigator, Chair. I would believe he was suited to
no,
be part of this.
I'm asking in the context of the different groups. For example, Commissioner Baloyi said this was an intelligence matter which would have fallen under deputy law.
Yes.
So did Mr. Padiachi work under deputy law?
He was working under advocate law.
Oh,
he was in the security cluster, which was headed by advocate law.
That's what I wanted
The
to
only amazing thing, Chair, is that advocate law appeared also not to know about this case because I saw him in the office that morning.
Yes.
He was not properly dressed for court, or at least that he knew about the case.
So when you inquired, what case is this and what have these generals been arrested for? He too did not respond and say this is what happened and this is why they were arrested. He appeared to be in the dark as well.
He appeared to be in the dark like I was. He did not know about the case.
Advocate Sigerunye, ordinarily who allocates matters to junior prosecutors in the IDEC? So take, for example, Advocate Hlajwayo, who ordinarily allocates matters to prosecutors at A level? Is it the ID or is it the DDPPs?
It will be me. It will be me as the DPPP in that group. I would look at the setup of the team to say, I need, say, maybe one or two juniors. Let me go for Advocate Hlajwayo and so and so.
Can Mr. Sissoko allocate a matter to
No,
a junior prosecutor?
That doesn't fall within his mandate.
So ordinarily only a DDPP would allocate a matter to a junior prosecutor?
That is true, Commissioner.
And
Only
if it's a junior prosecutor in your team, you would be the one allocating?
Indeed, so that is so, Commissioner.
I think you were
And in this case, that is why I found myself asking a lot of questions because I didn't know about the case where one of my juniors is involved. And, but I understood that because we signed these non-disclosure forms, maybe that has happened and I was not involved. But it was something didn't sound right. It was a bit strange.
I think you were to start I established that she was appearing, or am I
Yes,
mistaken?
I then established that Advocate Hlajwayo was appearing in court that morning with investigating officer Mr. Brian Padayashi, and that there was no co-prosecutor with her. in court, no senior state advocate, no DDPP, and no chief investigator assisting her. I was concerned that a matter of this magnitude involving the arrest of senior members of the police was being handled without such support and without a DDPP overseeing it. At that moment, yes, I then, together with one of my fellow DDPPs, Advocate Jacinta Vetboy, and Mr. Sibusiso Chikovi, who is the chief financial investigator. These people, I'm mentioning them because they were in this group when we were inquiring and making, and trying to find out who was handling this. We then decided, the three of us, we then decided to approach the head of the unit, the investigating director, Advocate Johnson, to request permission to attend court to assist Advocate Latwayo. On arriving at her office, we found that the investigating director had not yet arrived, and we left a message with her personal assistant, Ms. Innocent Sikukuni. On my way back to my office, Ms. Sikukuni telephoned me to say that she had discussed our request with the investigating director telephonically, and that the investigating director had agreed that we could attend court as requested.
Did you ask or did you find out who and how Ms. Latwayo came to be allocated? Who selected her?
Yes. I only came to know afterwards, commissioners. I asked and I was told, I asked and the information I got was that she was appointed by the ID. And I was told that initially the only prosecutor in the matter was Advocate Ramsemi, Drew Ramsemi, and that Latwayo was then also allocated, or at least designated to the matter around May, so earlier, just shortly before the arrest in this case. In paragraph 26, when we arrived, we were then given permission by the ID to go and assist in court. When we arrived at court, we found Advocate Latwayo in the company of the investigating officer, Mr. Padayashe, and evidently overwhelmed. The court was about to commence, and the J15, which is the administrative form to which the charge sheet is attached, had not been completed, there being some 7 accused involved in the matter. Advocate Vetboy obtained the necessary J15. I remember she literally rushed to the clerk of the court, brought a blank form. I then took the docket from Mr. Padayashe. I then started reading out the names of the accused as they appeared in the docket to Ms. Vetboy, who was then, to Advocate Vetboy, who was then completing the J15, which was then handed to the clerk to register the matter on the book. Our assistants enabled Advocate Latwayo to consult with the defense legal representatives. The courtroom was full of police officers, family members of the accused, and members of the press. Advocate Vetboy and Shikovi obtained seats at the back of the court. As there was nowhere else to sit, I then sat in front next to Advocate Latwayo, and Mr. Padayashe, the investigating officer, was seated directly behind us. I was not the prosecutor in the matter. My colleagues and I attended solely to support Advocate Latwayo. The proceedings commenced before the magistrate, Mr. Madlanga, whom I did not know and was seeing for the first time. Advocate Latwayo conducted the bail proceedings on behalf of the state, indicating that the state was not opposing bail and setting out the reasons. The legal representatives of the accused moved their bail applications by reading their client's supporting affidavit into the record. At various points, Advocate Latwayo experienced difficulty in answering questions from the court and conferred with me and with Mr. Padayashe, who was seated behind us. In the course of dealing with the bail application, Advocate Latwayo asked the court to impose a condition that the witnesses not be contacted or interviewed by the accused. The magistrate indicated that he required a list of the witnesses, as he could not simply warn them, and he appeared not to be satisfied with her response. The magistrate then invited me to address him, observing that I appeared to be from the same office. And maybe just to add here, Commissioners, I remember he precisely said, because they were engaging with Advocate Hlatswayo, and he then looked at me and he said, okay, let the gentleman seated next to you address me. He appears to be from your same office, because now and then Hlatswayo kept on talking to me and at the same time with Mr. Padayash, and that is why the magistrate said, let this gentleman address me. Before doing so, I then asked Padayashi whether a bail statement or affidavit had been prepared.
What is a bail statement? What would you find in there?
Commissioners, this matter, as I understood at the time, fell under Schedule 5 of the Criminal Procedure Act. And Schedule 5 and Schedule 6, these are serious matters. Schedule 5, the accused to be released on bail has to bring an application and satisfy the court that it is in the interest of justice that he be released on bail. What we do as the state, to avoid the investigating officer to testify viva voce in court, he then compiles an affidavit setting out even if the state is not opposing, the reasons why we are not opposing. For example, we would have verified the addresses of the accused. The statement will state, we've checked their criminal records. They don't have criminal records. They are not a flight risk. They are gainfully employed, and all those kind of issues, they'll come into the statement. We either do that by way of an affidavit of the statement, or the IO has to go into the box, and as a prosecutor, will then have to lead him to cover all those aspects.
And you say that's something that happens as a matter of course with Schedule 5?
It has to happen. I know, Commissioner, that there are instances where the state is not opposing, even when the state is not opposing bail, and the prosecutor addresses the court from the bar saying, we're not opposing bail. I know of instances where the courts would have insisted at least on some form of evidence, formal evidence from the state, at least by way of an affidavit from the IO or so. And I do not have case law with me, but I know there's a case or two where the court would have also said, even when the state is not opposing bail, but the court is sitting, the court needs to be assisted by the two parties. And even when the state is not opposing bail, but you, as an officer of the court, you have to address the court, say why you are not, give this information to the court. So if you have compiled an affidavit, it's easier for the court. You read it into the records saying these are our reasons. And when the court evaluates whether or not the accused has met the onus of proving that it's in the interest of justice that he be released on bail, the court has the benefit of both the state and the applicant's evidence. But in this case, the bail application or the statement was not done, which was one of the things that made me realize that this team did not appear to have been ready for this bail application. I would have expected them to, because when we were in court, I then asked Brian, just before addressing the magistrate, I asked him, did you compile an affidavit? Because now I could see the magistrate was going to engage me. So I wanted to speak out of an affidavit, not just give the court information which I was not privy of. But I remember asking him about the issue of the list, and then quickly he said, no, we have other outstanding investigations against some of these people. So that is why we don't want the list of these people to be known, because if we list them, that's going to impact on our outstanding cases. And that is what I then delivered to the court when the court was asking Hlatswayo, why not the list? I'm at the paragraph where the magistrate invites me to address him, and before doing so, I then asked Padayashi whether a bail statement or affidavit had been prepared. It had not. Mr. Padayashi explained that the witnesses had been told that if they were contacted by the accused, they should immediately report to him, so that there was no danger in that regard, and that there was a further ongoing investigation involving the same accused. Such listing of the witnesses could disclose their identities and the existence of that other investigation. This is what I delivered to the court. On that,
Sorry, so where you say in line 1, 2, 3, 4, 5, there's a sentence that starts so that there was no danger in that regard. It's preceded by where Parachi explains to you that witnesses have been told that if they are contacted by accused, they should immediately report it to him. And then you say so that there was no danger in that regard. Can you just explain what you're addressing there?
yeah.
Where you say so that there was no danger in that regard.
Yeah, I think what I wanted to say here was that Padayaj and his team would have discussed with the witness to say, if anyone contacts you, please let us know so that they can take steps. So I'm saying, so that there was no danger in that regard, the quicker they are alerted, the investigating team is alerted, then the danger could be averted.
Okay.
On that basis, at paragraph 31, on that basis, I then addressed the court and requested that the witness not be listed so as not to compromise the other ongoing investigations involving certain of the accused. Out of respect for the court, I could not decline to address the court when the magistrate invited me to do so. At 32, bail was fixed for the accused in the amount of 10,000 rand each, save for accused number 2, Mr. Lushaba, who was not admitted to bail at that stage owing to a separate outstanding matter, and the matter was postponed. Among the conditions imposed by the magistrate was a condition that the accused do not enter the premises of crime intelligence anywhere in the country. Neither the state nor the investigating officer had requested that condition, and the magistrate gave no reasons for imposing it. Of significance is that in the course of granting bail, the magistrate himself remarked that he was not persuaded that the state had a strong case, and indicated that this was among the consideration that moved him to admit the accused to bail. He observed that the matter was not a typical fraud or corruption case. This doubt was expressed by the presiding officer at the very first appearance. It's there on record, Commissioner. The magistrate says it after asking Advocate Hlajwayo some questions. He says, I'm not that convinced that your case is that strong because it's not like the typical cases that we deal with of fraud. And he also says it to the accused when he grants them bail. He says one of the things that I've considered is this issue, and I'm not convinced about the strength of the state case as it stands, based on the address by the prosecutor. The record speaks for itself on that issue. At 34, my involvement then ended after the first appearance.
Can I just ask you, so you stayed in court the whole time until the court rose?
Indeed, Commissioners, I stayed in court until the matter was, the bail application was finalized.
And where was Mr. Padiachi by the time court rose?
Mr. Padayashi was with us up to a certain point, I think just before the judgment, because he had to catch a flight back to Durban, Port Elizabeth. He's based there, he stays there, so I think he comes to the office after every second week. There's an arrangement that they have in the office. So I remember he had to go back, rush to airport to catch a flight. So he kept on saying to us at the time, guys, I'm going to leave you. I'm not going to stay until. So he left at some point. When the magistrate was delivering judgment, he was no longer there, he left.
More specifically, when the debate or discussion about conditions was happening, do you recall whether he was in court or not?
He was still in court, because I also asked him, that's when I asked him, do you have a bail statement? Have you prepared a bail statement? And when Hlajwayo was addressing the court about the conditions, he was still there. I think he left just before the magistrate had started delivering judgment.
Thank you.
Yes.
Advocate Serene, before you move to the 8th to August, When you come back from court and having seen what you've seen that day, from the moment where you were consulting your colleagues to what you've then witnessed in court, did you do a report to either the ID or Mr. Sissoko on the developments of the day? In particular, your concerns?
Yeah. Personally, I did not, because at least at this stage, I did not have enough information that I later got. At least at this stage, in my mind, I'm thinking there's a team that is dealing with this case, but it's strange that only one prosecutor and one investigator are in court, and the DPP that I expected to be involved in this does not seem to know about this case because he's not with them, and I saw him in the office. But, you know, and I could see that they were not ready. There was no bail statement. But after that, my involvement literally ended there. And what we do in the office, when I would have expected Advocate Lachwayo to do the reporting to the ID. That is what we do when come back from court, especially in this type of cases. This was a very big case. I mean, generals in the intelligence service, you know, one would have expected a report to be given to the ID to say this is how we fared, this is what happened, and the case has been postponed to such and such a case. Personally, I did not, at least at this stage, I did not make any report because I was not part of the case. My involvement was to help on that day, and I think I did my level best on that day, and that was the end of it.
Suppose the question is, I understand the report as it relates to what happened in court and where it landed, where bail was granted, conditions and all of that. But in this instance, what you knew that day was that there was no DD, there was no senior prosecutor. They certainly didn't appear to be ready for the bail proceedings. You had to step in as somebody who's completely not involved. This was run by the most junior prosecutor, you say, at the time. It seems to me that beyond the reporting about the progress of the case and what happened in court, there was other issues related to how the matter was being conducted that ought to have been reported.
True, but remember, I'm not, firstly, I'm not designated to the team formally in terms of the relevant provisions of Section 28. And secondly, we have these non-disclosure forms that we complete. So I cannot go beyond trying to find out even about the facts and getting myself involved that much. My request on the day to the ID was to be allowed to go and help in court, and that was granted. So I couldn't go beyond that unless I was designated formally into the case. You know.
But the concern is that you knew that there was no DDPP and there was no senior investigator, and that your junior prosecutor did not have sufficient support. That's why you had to step in at the last minute. Now, what you are saying here is after court, you left that there. So in other words, if there was going to be further appearances or further investigations, she would still be doing that unsupervised without a DDPP overseeing her work.
Commissioner, at the time, yes, but like I said, the name of Advocate Ramsemi also was thrown in. So somehow I know that she's also part of the case. I was told that morning she was off sick.
But she's not a DDPP.
No,
you said in paragraph 20 and I think 26 that the DDPP must head every matter and they are the project owner.
That's true.
So this matter was proceeding without a DDPP and a project owner. Because even if Advocate Ramsamy was assisting Advocate Lachwayo, it would be two junior prosecutors. Was that not a concern for you? For such a big matter, we're talking head of crime intelligence in the country and other generals at SAPS.
Commissioner Kumalo, it was a concern, and that is why I asked to go to court to assist. But I did not think of involving myself beyond that, that point after the bail application was done, because I did not know why is this team so small. I did not know how it came about, but what I know is a case cannot be handled or done in the IDEC without the ID knowing. Therefore, I don't know how this team was composed, but honestly speaking, I didn't want to get myself involved in why was this done, why was not, because I was not part of the team at the
You
time.
give the impression that you did not want to step on the ID's toes. You did not want to ask her difficult questions. So you said, if she made the decision, I will live with it. I won't even question it. That's the impression you are giving me.
And I'll agree to that, Commissioner. Because as the head of the office, you would have made decisions. I can't ask questions on, especially questioning how this team was composed, why not involve me, or why not involving Advocate Paul Lowe, who was overseeing this. At the time, I didn't ask myself many questions on the composition of the team, but it didn't look right to me that a case of this magnitude was, on the day of the arrest, handled by a junior. I didn't take it further than that, but it didn't look right.
Sorry, you say in paragraph 34, your involvement ended after the court appearance. But I don't think you mean end, because in paragraph 35, you say you were called to a meeting on the 8th of August, and at that meeting, the ID informed you that she had decided to include you in the matter. So it was not end forever.
That is correct, Chair.
So there was an intervening period during which you were not involved. That is after the court appearance in June. And then in August, you are brought in by the ID herself.
That is correct, Chair. I'm saying my involvement ended there with the bail application because I was not part of that team. I was not supposed to be part of the team. I went there and helped with the bail application, and my involvement in as far as they ended there.
Yes.
But
Only in
coincidentally, about 2 weeks after, then I'm called for a meeting where I'm formally then involved or designated by the ID into the matter. After the bail application, I did not work on this case. I did not discuss it. I continued with my work. I'm overseeing a group. I'm also having my own cases. I'm doing it. I concentrated on my work. I forgot about this case until on the 8th, when I was called to a meeting by the ID.
The 8th of August.
On the 8th of August, and which is then on paragraph 35, on or about 8 August.
Maybe before you discuss, you go to paragraph 8. Let me ask my question, and again, it goes back to wanting to understand the reporting and role of Mr. Sissoko. You have this experience now on the 27th of June, and you note all these wrong things about it. Isn't that typically something that would have had to go into the discussion? Because part of it sounds like resource allocation, right? Isn't that something that would have typically gone into the reporting to the, is it OMC or something, when you make those monthly reports and get it addressed there? Is that not?
I agree, Commissioner. It's something that ought to have been raised in that structure. I'm not sure if it was at the later stage, but from the date of the bail application when the case was postponed until up to the 8th, I don't remember. I don't think we had an OMC. But these are type of issues that are dealt with in the OMC. Resource requirements, where there's shortages, and even these challenges that how is the team dealing with such a big case and there's no deputy?
So you say you don't remember whether it was raised or that you had a meeting after that? Is that?
That is correct. Between the 27th, when the case was in court, and the 8th
Yeah.
of August, when I was involved in the case. But then from the moment I was involved, and the commission will see, as I'm calling meetings of this team, I'm also copying Mr. Salk. I'm involving him in the matter.
And where is Mr. Lowe in all of this by the time you get called on the 8th of August and you are now told this is your matter? Where is he?
He was never involved in the case at all, Commissioner. He was not part of this case at all.
Ever?
Even though the type of case resided in the group that he was overseeing, but he was never involved. He was not designated in this case.
Okay, thank you. And do you know why? Did you ever get an explanation, even informally, why you are the one that's been called on the 8th of August and he's not involved?
I did not ask why, but as I'm going through my statement, Commissioner, you'll see that I take it when I was called in, maybe it might have been the ID got, like I left a message with a PA, and she then gave a go ahead.
Okay.
Maybe because I helped on the first day. Let me. I nearly said Somar. Let me proceed with Sirunye because he helped on that day. I think
You could have said Somar. We've
Yes.
had worse.
Yes. So I believe she involved me and not him because I went to help on the first day. And because when she called me on the 8th, she said, I've decided to involve a DDPP in the case, and I want you to be part of it.
Okay, thank you. All right.
Just to correct you on the intervening period, you said that after the court appearance, you were not involved until the 8th of August 2025, when you were called to a meeting and told that you would be included in the matter. The court appearance was on 27 June.
27 June.
Yes, 2025.
I'm very sorry,
You said,
Commissioner.
you said the intervening period was 2 weeks, so it was over a month.
It was
and-
over a month.
Yeah.
I'm thinking the appearance was on the 27th of July. It was actually on the 27th of June.
Yes, all
Yes,
right.
that is correct.
And just to add an important fact, it may or may not be relevant. Between the court appearance and the 8th of August, 6 July happened.
Indeed, Commissioner, the address to the nation by the general, is he a general? Mr. Mkwanazi, that happened. And that was in July. Yes. That happened, and I must say, I remember watching, I was home that Sunday, I remember watching the press conference as he was briefing, and then he mentioned this case. And I thought, how come? I didn't really, I thought, for the moment that I was in court and left the court, much as I didn't know what happened before, I didn't see anything sinister that when he mentioned the case and how it was handled, and that to be honest, I doubted his remarks at the time. To put it bluntly, I doubted his remarks at the time about this case, and for the longest of time I did. And until now, recently, in the last maybe 2-3 weeks of the evidence that we had in this commission, that's when I started realizing maybe, and I said it to one of our colleagues even this morning when we were having tea, that it appears I sort of found myself in an offside position, or at least handled a ball with my hands. In fact, I sort of feel a little bit angry if I think about it, that it feels like I was set up, not only me, but Hlachwayo as well. I think junior as she was, I don't think she was supposed to have been involved in this case. And looking at it now, it appears to me she was set up.
But I think you are being unfair to yourself. You are still going to come to this later in your statement. You have placed before us an annexure in which you actually questioned the merits of the case, and you prepared quite a lengthy document raising a number of concerns that you had about the merits of the case itself. Of course, I'm sure that what you are talking about now is possible impropriety with regard to why the case was investigated in the first place. I'm sure that's what you are talking about. But it's not as if you just gobbled up everything, every and anything that was placed in front of you.
Indeed, Commissioner.
Chair, I see the time, and we are about to go into his involvement. It might be an opportune time to take the tea adjournment.
Let's adjourn and resume at 11:30. Yes, Ms. Boy.
Thank you, Chair. Chair, for the next couple of paragraphs, the witness goes into their involvement in the two matters, and you will note that there's a few annexures where he would have emailed the team or the ID regarding challenges that he had in relation to the matters. We do go into some detail on those at a later part in the statement. So he will read through those paragraphs and we'll go into detail on the content of those concerns a little later, not much later, a little later in the statement. Advocate Sirunye, we are now at the 8th of August 2025 when you were called into a meeting with the ID to get involved formally into the matter.
Thank you. Yes. On 8th of August 2025, the investigating director convened a short meeting and informed me that she had decided to include me in the matter. That meeting was attended by myself and Advocate Drew Ramsemi and the ID. It was only the three of us. She asked me to oversee the two matters, the Lushaba matter and the Kumalo and others, in brackets Mokwele matter, with Advocate Dushanta Ramsemi as remaining the lead prosecutor in the Lushaba matter and Advocate Lachwayo remaining the lead in the Mokwele matter. She further asked me to attend to an anticipated bail amendment application under Section 63 of the Criminal Procedure Act in circumstances where Senior Counsel Advocate Mshololo was said to be coming on board, and she wished a senior person to deal with the matter. Yes.
Is Advocate Mshololo senior counsel? Or do you mean a senior junior?
No, yes. I don't know if she's a senior counsel, but in the words of Advocate Johnson, she said, Sirunye, I've heard that Advocate Mshololo is coming on board to represent the accused in the Section 63 bail amendment application. I therefore want somebody senior in my office so that they can match her. But I think at the time she was of the view that Lachwayo couldn't,
No, I'm raising it because senior counsel is a term of art and...
where defense, senior defense...
Yeah, and I think even though I don't really follow the proceedings in the case where she's appearing, I think her robes are the robes of junior counsel.
I appreciate that,
All right,
Commissioner. Yes.
Please continue.
Before you go on to the next paragraph, on this bail issue, because the issue was raised with Ms. Johnson, was it your now that you're on board from August, at this point, did you come to understand that Ms. Johnson knew that the bail condition that was imposed was not asked for?
Commissioner, I did not know at the time. Like I indicated earlier, I would have expected the prosecutor, Advocate Lachwayo, after the bail application, to give a report to Advocate Johnson. Therefore, I did not know how much she knew of what happened in court on that day and what she did not know. But as she's saying to me in that meeting, I'm bringing you in to oversee the two teams, the two cases, but also to attend to the Section 63 bail amendment. That is the specific instruction I'm getting to attend to the 63 amendment. My role was going to be that, but I didn't know how much she knew and whether the condition had been asked for or not. I think.
Thank you.
But as she's saying to me, Counsel, as she's saying to me, prepare for the bail amendment application. My understanding at the time would be in whatever application is coming up, I must have a look into that, prepare for that thoroughly, since there's somebody senior also defending the accused in that application.
Advocate Sirunye, in this meeting, were you being asked to take overall oversight of the matter? I know you specifically mentioned that you were asked to take over the bail amendment application, but did this extend to complete oversight of the two matters?
Indeed, it extended to overseeing the two cases, the Mokwele/Khumalo matter and the Lushaba matter. But with the two colleagues remaining as lead prosecutors, Advocate Ramsemi to lead the Lushaba case and Hlashwayo to lead the Khumalo-Mokwele matter. So I was coming in as a supervisor. Remember now it's clear to me there's no DDPP appointed into the matter, so I'm coming in after the fact as a DDPP to oversee the two cases.
Now, you had expressed a concern earlier that when you found out that it was Advocate Hlashwayo who was lead on the matter, that she was junior, this was a big matter involving generals and all of that. Did you express this view in that meeting when you were being told that she would remain as the lead prosecutor in this matter?
No, I did not raise it, commissioners. It was a short meeting. Sirwinya decided to include you as a DDPP on this matter to oversee it. I didn't. It was a very short meeting, being told what to do, and it was the end of the meeting.
So you considered it more of an instruction and less of a consultation?
It was an instruction more than anything.
Okay, thank you. You can continue.
Right. After this meeting at 36, because of the instruction to oversee the case, I then proceeded to request the docket and the Section 27 referral to familiarize myself with the two matters, because now I'm told these matters came via a 27 referral. So I remember talking to the investigating officers and to the prosecutors to say, please give me the docket. I want to start reading these dockets. This would have been in preparation, especially for the impending Section 63 bail amendment. On 16, I think the docket were given to the dockets were given to me on the 13th of August. I'm continuing to read from the statement, line 2. On 16 August 2025, which, commissioners, was a Saturday, I decided, let me go to the office. I want to read these dockets and so that I can prepare thoroughly for the application. I read the docket for the first time. When I'm saying docket here, I'm referring to the Mokwele/Khumalo docket. It consisted of 4 volumes. Having done so, I then issued a trial preparation note to the team. I read it and finished it that Saturday. And I issued a trial preparation note to the team, together with an attachment setting out a series of questions and concerns. I then forwarded the email to Ms. Kukuni, who's the personal assistant of the ID. And this email and attachment attached to my affidavit as PS3. I deal with the substance of those concerns, below. The investigating team...
Sir, you asked for the Section 27 referral. Did you receive it?
It was never given to me, Commissioner Baloyi. It was not given to me. I asked for it. I spoke with Mr. Brian Parayashe on about 3-4 occasions. And every time when I was asking for that, he couldn't give it to me. I don't think he had it, because he would say, okay, Advocate Peter, I'll come back to you about it. And up to about 31st of October, I was still asking for, I'm saying 31st of October because I remember when I'm checking my emails, I can see on that day I raised the issue again with Mr. Sisoko. I said the accused have asked for further particulars, and one of the issues that they are raising there is they want to be provided with a Section 27 referral. I'm still looking for this document. Do you perhaps have it? I was then raising the issue with Mr. Sisoko. It was on 31 October. So from August, I was looking for that document, but no one could give it to me. I spoke to the prosecutors. I was getting, Hlashwayo did not know about it at all. She said she hasn't seen it. Advocate Ramsemi said she saw it, I think in the earlier part of the case when they were starting the investigations, but it appears either it was lost or disappeared. I remember she couldn't also give me a copy of that. She said she gave it back to the ID, But it appears the ID was also looking for it from her, so I don't know whether it was lost,
Did she?
at least up to that stage.
Yes. Ms. Ramsame, when you ask her or when you discuss with her the Section 27 and you ask for it, did she express anything about its contents, the one that she has seen? Did she express any concerns whatsoever relating to the Section 27 and the charges?
No, she did not. She did not.
Thank you.
Thank you.
Advocate Serunye, several times now you keep referring to Ms. Ramsamy as true. When we read the transcript 2 months from now, we're going to have a problem. So I'm going to suggest that you use the surname. I know you are used to
Yes.
how you speak to her in the office, but just for our benefit.
I'm very sorry about that, Commissioner. Yes.
Just before you continue, for completeness, Commissioner Baloyi, the email in referenced is at page 101, and that would have been sent on the 31st of October to Mr. Sissoko, where Mr. Advocate Serunye was indicating that one of the accused is seeking further particulars and needed to see the Section 27 referral. Is that what you were referring to?
Indeed, it's on which annexure?
It's annexure 10.1 at page 101 of the annexures.
Indeed, Commissioners, on annexure 10.1, on the 31st of October at 12:20, I sent an email to Mr. Sissoko. I copied the project manager, Mr. Tsepo Tlale, Advocate Ramsemi, Advocate Tlachwayo, Mr. Padayashe, and Chief Daylan Perumal, with the subject Human and others. Good afternoon, Mr. Sissoko. We are in the process of answering the request for further particulars received from General Lushaba, accused 2. The defense wants to know how the IDEC got involved in the investigation of this matter, whether it was a Section 28 or 27 or 28 referral, and who referred it to the IDEC. In brackets, proof of such referral is needed. Do we have a Section 27 referral in this matter? And if so, where do we get a copy of same? Was it by way of a letter, as we hear from the evidence presented at the ad hoc committee, or by way of an affidavit? And I must say, Commissioners, I did not receive a response to this email from Mr. Sissoko and or from any of the colleagues who are copied on the email.
This is October, but you say you asked for it immediately after you had been brought on board, so this would have been in August already.
From the moment I was brought in on 8 August, I started asking for these documents and the docket, and by 31 October, I'm still looking for that Section 27.
Did you ever ask for it from the ID, Advocate Johnson, directly?
I did not ask it from the ID chair, but what happened is, as I was asking the investigating officers, I think somebody informed her that I'm asking this many questions about the Section 27, and I think I'm dealing with it on the affidavit. There's a stage where the ID called us to a meeting, me, Advocate Ramsey, and Advocate Tlachwayo. It was also a very short meeting. It was about during lunchtime. And when we got into the boardroom, she was already seated there. She looked very angry, I must say. And immediately when we sat down and she addressed me, the meeting was about her addressing me. And she said, Sirunya, here you are looking for a 27. You're asking many questions. Don't you believe my investigators? And she said, I have seen the 27. The ID has seen the 27. What more do you want? And I said, but ID, I'm the designated DDPP in the case. And I'm told this case came via referral. I want to see this document. And the accused are also asking for it as part of the disclosure or application for further particulars. And she said, no, guys, go back and work. The ID has seen this document. Okay. So that was the end of the meeting.
Chair, Commissioners, this is explained at paragraph 63 of the statement.
Perhaps let's not go there, let's come back here.
Yes.
Yes.
Advocate Serunye, you can proceed.
Thank you. At 37, remember now, on the 16th of August, the Saturday, 16th August, I sent an email to the team members with an attachment having a number of queries that I was raising. And at 37, paragraph 37, the investigating team then responded to my questions. And I also in turn replied. My questions and their responses were in blue to my email, annexed as PS4, and my reply is on 17 August 2025, annexed as PS5. In the course of discharging my responsibilities for the matter, and in an attempt to address the difficulties with the charge sheet described below, I settled an amended charge sheet. The amended charge sheet reduced the matter to 2 counts, including a count of conspiracy under Section 21 of the Prevention and Combating of Corrupt Activities Act 12/2004, commonly referred to as PRECA, and I attached in my affidavit as PS6 the charge sheet which I settled.
Before you proceed, maybe Ms. Bowe, are you planning to come back to these annexures and deal with them? I mean, I'm looking at annexure PS3. What is attached seems to be an important document that the witness is speaking to. I'm assuming the following. What's the
Commissioner
intention?
Baloyi, at the section that deals, at page 13, you'll see there's a section that deals with the concerns regarding the Mukweli matter. It will be followed by another section dealing with the concerns raised around the charge sheet, and then concerns around the Lushaba matter. It is the contents of those annexures.
Okay, thank you.
Advocate Serunye, you can continue.
Paragraph 39. In or about September 2025, during a postponement held in the magistrate's chambers, the accused were brought closer to the table. I must say, the court building was under, there was some construction going on in the building at the time, and most of the courts were waterlogged, and therefore we couldn't sit in the courts. And Mr. Madlanga called us to his office, and that is where the matter was then postponed in his office. And on line 2, I then recognized accused number 4 on that day. I recognized accused number 4. Accused number 4 is Mr. Lekalakala. I recognized accused number 4 as a person known to me. We come from the same township and had played soccer together, a fact I had not previously appreciated. I consider that this personal association precluded my continued involvement in the matter, and I submitted a memorandum to the investigating director requesting to be recused from the matter. Commissioners, at the time when I was compiling the affidavit and signed it with the evidence leaders, I couldn't locate the said memorandum. I have, however, managed to locate it, and I gave a copy to the advocates this morning, the memo that I prepared and forwarded to the ID. I don't remember getting a signed memo from the ID, so I gave them the memo that I prepared, which I gave to one of our admin personnel to hand over to the ID. I have, however, at the time, I only annexed as PS7 an email communication, which I sent to the head of investigations and operations, which she was confirming that my memo was submitted to the ID. Maybe just to explain here, I wrote a memo, sent it to one of our PAs at the time, Ms. Dikeledi, I don't remember her surname. She then took it to Mr. Sisoko. So when I was preparing, at a later stage, about 3 days or so, I then sent an email to Mr. Soko because I was not getting any feedback from the ID. I asked if my memo asking him to be recused from the matter had been submitted to the ID. And Mr. Soko confirmed in that email, PS7, that yes, I have submitted your memo to the ID, and she's attending to an ESCOM meeting. She said she'll deal with the matter when she comes back. At paragraph, yeah.
Just one moment. Commissioners, the document that was just handed up is the email and the original memo prepared by Advocate Serunye. We've marked it Annexure 7.1 because it's associated with that paragraph. And the email the witness was referring to Mr. Sissoko can be found at page 74 of the annexures. It is the email at the bottom wherein he was asking, my apologies, his email, the original email is on page 75, so we'll have to work up. You'll see there's an email from P. Serunye to Sinyani, wherein he indicates that he handed over a memo addressed to ID and Mr. Sissoko, notifying them of his recusal, and he explains there how he knows the accused. And then Mr. Sissoko responds on the next page, the previous page, at page 74, where he confirms that the memo had been brought to his attention and he had brought the memo to the ID's attention, but that she was attending a meeting. Yes, you can continue.
Can I quickly read the memo into the record, Council?
Yes.
That is Annexure 7.1. Okay. I wrote this memo then on the 16th of September. I then emailed it to, as per page 1 of the badge. You'll see I then emailed it to the admin personnel, Sinyani, Manchidi, with the subject recusal from the matter of State versus General Kumalo and others. Attachments, it appears I wrote that email on top of I wrote the memo on top of another document. That is why the attachment appears with the subject Estina request to NDPP. So I worked on top of another memo. Right. On page 1, the memo is directed to Advocate Johnson, Investigating Director, and to Mr. Sissoko, Head of Operations and Investigations, from Advocate P. Serunye, Deputy Director of Public Prosecutions. Subject, recusal as prosecutor in the matter of State versus General Kumalo and others. The memo is dated 16 September 2025, paragraph A, purpose 1. The purpose of this memorandum is to inform the Investigating Director and IDEC Head of Operations and Investigations of my recusal from the aforesaid matter. Background. About 4 weeks ago, the ID formally authorized me to be part of the prosecution team in the matter of State versus General Kumalo and others. The matter was already on the court roll, having been first enrolled on 27 July 2025. And it seems on the email I'm repeating the same mistake of date of 27 July. It actually should read 27 June 2025. In August, the matter was remanded to 8 September 2025 for a formal application in terms of Section 63 of the CPA Act, brought by accused 1, 3, 4, and 7. On 8 September 2025, I presented the state's case, assisted by Advocate Joy Tlachwayo. The application commenced on that day, but not finalized. The matter was remanded to 15 September 2025 for continuation. On 15 September 2025, the matter could not proceed due to the fact that the Magistrate Court building was waterlogged and some of the courtrooms did not have electricity. The matter was then postponed in Chief Magistrate's office, in chambers. The accused were called into the said office and stood behind us, in bracket us referring to the lawyers, facing towards the magistrate. Accused 4 was standing closest to me. When I turned back to look at the accused, I then noticed, for the first time since the first appearance, that accused 4 is the person that is known to me. Accused 4 and I grew up together in the township in Mabopane. We actually played soccer together for many years, albeit for different teams. For all intents and purposes, accused 4, in brackets, Josias, as we used to call him, and I are homeboys. Between yesterday and this morning, I have verified that accused 4 is the same person I grew up with. Thus, I have formally decided to inform IDEC management and recuse myself from handling any case in which Mr. Josias Lekalakala and his family members, in brackets and associates, are accused persons. I have already disclosed this fact to my fellow IDEC managers in an earlier management meeting held this morning. Conclusion, to avoid any negative perceptions and in the interest of justice, I'm formally recusing myself from this matter and any matter that may involve family members and or associates of Mr. J. Lekalakala. On 29 September 2025, I'm formally going to recuse myself in court before the magistrate since I was still addressing the court when the matter was adjourned on the last occasion. I did not recognize Mr. Lekalakala in court on the 3 previous occasions. Otherwise, I would not have been part of the prosecution team right from the onset. Whilst I was part of the case, I prosecuted it to the best of my ability, and the record of the proceedings will bear testimony to that fact. I just do not want any wrong perceptions to be created by my continued prosecution of somebody that I grew up with. My name and integrity mean a lot to me, so are the interests of justice. This memo, you'll see it was dated 16 and addressed to Mr. Soko and Advocate Johnson. As I indicated, Commissioners, I tried to locate the signed copy, I couldn't find it, but it is backed up by the email PS7, where Mr. Soko confirms that the memo was brought to my attention, referring to himself, Mr. Soko, and I have also brought it to the attention of the ID. However, because she's attending Menko, and I was also on leave yesterday, we are only going to discuss it tomorrow when she's in the office. But what followed on this, if I go back to my affidavit, on paragraph 40, approximately 2 weeks after I had submitted this memo, 2 weeks later, the investigating directorate informed me, the investigating director informed me that she had considered my request and granted it, but asked that I first complete the Section 63 bail application before withdrawing from the matter. I remember that day it was me and the ID and Mr. Soko. I was called into her office and she said, I received your memo and it's only fair that you recuse yourself from the case because you cannot prosecute a person that you know and his colleagues and associates. But she said, but because the bail amendment application has already commenced and it was almost halfway, please finalize that and then you can then formally withdraw from the matter. And that is how then I proceeded, at least with that application. On or about 14
Advocate
October.
Serunye, do you know if anyone then replaced you as the DD after your recusal was accepted?
Yes. Advocate Manilal, his name is Santos Manilal, replaced me. It's him and a number of prosecutors, I think 2 or 3 other prosecutors, Advocate Isaac Duploy, and Advocate Bastian Thienasen. I think that's the surname. I'm sorry if I'm not pronouncing his surname properly. But they were only, yes, they came on board. I don't know at what stage, but as that period I proceeded to finalize the 63 hour and the bail appeal that followed later. But I know that they were later then involved with Advocate Santos Manilal being the DDPP and project owner of this case. When I ceased to be the prosecutor in the case, I think so was Advocate Ramsemi and Advocate Tlachwayo. So the team led by Advocate Manilal took over the 2 cases. And I think they're still the prosecutors.
You say the team without, it's a new team without, new in that it now doesn't have Advocate Ramsame and Advocate Tlachwayo.
That is correct, Commissioners.
Okay.
The team of Advocate Manilal took over the two cases. And Advocate Ramsemi ceased to be the prosecutor in the Lushaba case. So did Advocate Tlachwayo.
Okay.
I don't know at what stage they were told to no longer be part of the case, but I know for a fact they are no longer part of the 2 cases.
All right. Maybe just correct my my assumption, or what I thought things meant, when you were setting out the 4 different streams that you have, each one of them led by a DDPP,
Yes.
I assumed that therefore there's only 4 DDPPs in IDEC. You now make a reference to Advocate Manilal
That's correct.
as a DDPP.
Yes.
So does that mean you have more than just the 4, and where do they fit in these different streams that you have?
No. Commissioner Baloyi, at the time when the streams were set up, Advocate Manilal was still a senior state advocate. He was not yet a DDPP. And he was reporting to one of the DDPPs, Advocate Vetboy. And he only later became a DDPP. I think he went for interviews at some point for the position and was then appointed formally as a DDPP and became part of the DDPPs. And at that stage, then it would have been me and Advocate Manilal, Low, and Advocate Vetboy, even though Vetboy, her position was on contract, which ended last year in December 2025. And there was Advocate Annemari Friedman. So at some point we were 5 with the appointment of Advocate Manilal as a DDPP. We then became 5.
So when Advocate Manilal gets appointed, you say he gets promoted, he becomes a DDPP.
Yes.
When he gets appointed to replace you in these matters, DDPP law is again overlooked. He's also again not part of it. He's not the default.
He's like, yeah, that is correct, even though the case fell
Falls under his team, his stream.
under his stream.
Okay. Thank you.
Thank you. On about 14 October 2025, I'm reading from paragraph 41, when the matter was due to proceed, the magistrate recused himself on the basis that he had been subpoenaed by the commission. I was of the view that the reason given was not legally sound, and after consulting the team and the investigating director, it's supposed to mean we, because I was not doing it for myself, but for the team, I launched an application to review the recusal. We consulted with the ID, we informed her about the recusal, and that the magistrate, the reasons that he gave were not in line with the established principle of recusal with reference to the decided cases, and therefore the unit then decided we shouldn't leave it lying. I must say, Commissioners, that it came as a surprise to both me and Advocate Mshololo, who were defending on the day, that before we started, the magistrate just said, I want to address the 2 of you. I've been subpoenaed by the commission, and as a result, he was recusing himself. He did not give us an opportunity to address him on what he was anticipating to do, and that's one of the reasons why we then took up his decision on review to say, in line with decided cases, at least you ought to have had us engage us, but in any event, the reasons that he was giving were falling short of the established principles, and that is why we took the matter up on review.
But that same consideration that he didn't give you the opportunity to address him when he decided to recuse himself, why was that not your consideration on the bail issue? Because in the bail issue, he didn't give the accused. We later learned in the appeal that the accused were not given the opportunity to address him on that condition. I'm not probing at this stage, it's because you've touched on it, but it is a subject of interest that I would like to hear you on, not necessarily now in full.
Yes.
But it's something that I would like to engage you on.
I understand that. Can I quickly just take out a copy of my book here just to make... Commissioner Baloyi, when The reason for that was, and we looked at the provisions of Section 60 of the Criminal Procedure Act. Especially at 60 subsection 12, if I'm not mistaken, I want to go there. Section 60, subsection 12, the court may make the release of an accused on bail subject to conditions which, in the court's opinion, are in the interest of justice. And Section 60 says the magistrate must weigh up the facts presented before him and the evidence before him. And at the time, even though neither of the parties had addressed him on this specific issue or condition, but our understanding was that he has the powers in terms of Section 60, subsection 12, to impose any conditions which, in his opinion, were in the interest of justice, allowing him to release the accused on bail. We objected to the appeal on those grounds, but when one reads the record of the matter at the High Court on appeal, and the presiding judge took me on that, and I had to concede, commissioners, that yes, much as I didn't know much about the case on the day of the bail application, I was seated there, but I remember that my fellow prosecutor, Advocate Tlatswayo, was not engaged by the magistrate, neither were the defense, before the magistrate decided on this condition. And for that, that's the first point. But secondly, the magistrate did not give reasons for imposing this condition. And I think those two factors are what swayed the decision in favor of the defense. The High Court saying, when reasons are not given, it's difficult for a party to the proceedings to know why a decision was made against them, and there's a constitutional case to that effect. And furthermore, the fact that you are not engaged to address the court on that was also wrong, and that led to the conditions being set aside. On hindsight, yes, we ought not to have opposed it on those bases, but at the time, looking at the Act, it says there's nothing wrong that the magistrate did. He has the powers in terms of 6012 to impose any conditions. Had he given reasons, had he engaged us to address him, that condition would have stood.
Okay. We'll come back to it, Mr. Srinye, and because Ms. Johnson did testify to this, specific questions were asked of her about this, and she had certain answers and explanations. So I would like to hear your views about it, but we'll get to it.
Thanks, Commissioner.
Thanks, Ms. Paul.
Thank you.
Thank you.
Paragraph 42, the accused thereafter abandoned the Section 63 application. That is now, after the magistrate had recused himself, the chief magistrate was trying to arrange another magistrate to take over the 63 application. And the accused then, because of that delay, they then brought a Section 65 bail appeal. Section 65 of the Criminal Procedure Act bail appeal. We again had a discussion, discussed with our boss, and we're given a go-ahead to oppose the application. And both matters served before the High Court, and the judgments are attached as PS8. The judgment for the bail appeal and the order for the recusal is PS9. In the bail appeal, PS8, the High Court agreed that the presiding magistrate's decision to impose the decision without engaging the parties and giving reasons was wrong in law and therefore ought to be set aside. On PS9, in relation to the recusal of the magistrate, the High Court ordered in our favor to say, yes, the magistrate ought not to have recused himself for those reasons given, not engaging you, and the reason given is also not in line with your rugby union matter. The bail appeal succeeded.
Sirunye, just before you proceed with the next paragraph, in practical terms, you would have had a conversation about the bail amendment application, the 63. Did you have a similar consultation with the ID regarding now the bail appeal? And did she give positive permission or consent for you to proceed with appealing, opposing the appeal?
We did, Commissioners, and we informed the ID, and then she gave us permission to go ahead with the opposition on the Section 65.
And when you do that, does she have sight of any of the affidavits that are filed, particularly in opposition?
She does, Commissioners, and I must say everything that we were doing, we were sending to the ID. The Section 63 bail amendment application, all the affidavits of the accused were sent to the ID, and our responding affidavit of Mr. Brian Badayashi was sent to the ID, and the defense then asked for a postponement in that Section 63 bail amendment application. They then, on the next date, submitted an affidavit by General Masemola in support of their application, indicating that he had lifted their relocation to other offices. And that affidavit as well was given to the ID. I remember sending an email to the ID asking her that we want to, after receiving this affidavit of General Masemola, we want to respond. Now, how do we do it? Do we subpoena information from General Masemola, or do we serve them with a 28? My question to her was, do we do it by way of a 28 or by way of a letter under your signature being the ID? And she sends me an email to say, serve a 28, which is what we did, and we got further information, which then allowed us to prepare additional affidavits of 2 other officials, which affidavits we then also handed in support of our opposition. So she was kept abreast at all times of what was happening.
And do you recall whether Mr. Parayachi's affidavit in opposition dealt with that specific bail condition related to whether or not you sought that condition to begin with?
What's the question again?
Do you recall whether Mr. Parayachi's affidavit in opposition set out that or indicated that this bail condition was never sought or anything related to that?
You mean the affidavit which was filed
in opposition?
In opposition
of the bail appeal.
I cannot recall, but if I check on my emails, maybe those can juggle my mind.
All right, thank you.
Yes.
You can proceed to paragraph 43.
Yes, the bail appeal succeeded while I contended that the magistrate was in law entitled to impose the condition. Okay, while I contended that the magistrate was in law entitled to impose the condition, I was constrained to concede that he had failed to give any reasons for imposing the crime intelligence entry condition. And it was on that basis, that is the failure to furnish reasons, that the condition was set aside as irregular. The review of the magistrate recusal also succeeded, the court holding that the reasons he had given for recusing himself were not in accordance with established principles. At 44, having completed the Section 65 bail appeal and the review, I had no further involvement in the matter. Paragraph reading my concerns regarding the Mokwele matter. Once I was officially involved in the Mokwele matter, Advocate Tlashwayo and Ramsemi came to me to voice their concerns about the lack of evidence in the Mokwele matter. This is as way back now as 8 August when I became involved. Since there had been no DDPP on the matter before my involvement, I could understand why they felt that they could not address these issues directly with Advocate Johnson due to the power dynamic. Having read the docket on 16 August 2025, I was not satisfied that the corruption charge was sustainable on the available evidence and current formulation of the charge sheet. And as I said, and I said so in writing at the time, my concerns were not the product of hindsight. I recorded them contemporaneously. At the time, 16 August, that Saturday, I produced those queries, and I raised a number of questions. I remember one of my questions to them is, why were these generals arrested? I couldn't understand. Or why are they charged with corruption?
Before we deal with your specific concerns, just one aspect here where you say that since there had been no DDPP on this matter before my involvement, I could understand why they felt they could not address these issues directly with Advocate Johnson due to power dynamics. What do you mean by power dynamics?
Yeah. Look, the two colleagues are juniors, and it's not easy for, it would not have been easy for them to go straight to the ID to raise issues. I'm talking about issues that they were raising with me. They had a lot of complaints that the investigators were not listening to them. They were not carrying out the instructions that, as they were delivering to them. It appeared to me, in fact, the relationship was not that good between the investigators, especially Brian Parayashi and Advocate Ramsemi. They were not in speaking terms when I came into the team. So I tried to put them together. In some of my emails, I'm saying to them, look, we're playing for the same team. Let's have meetings. Let's talk. Let's iron out whatever problems that we're having. So they couldn't. The two juniors couldn't approach Advocate Johnson, and that is why maybe they felt at ease to come to me and make all those complaints, relate them to me. Not that it was easy for me as well to approach Advocate Johnson. I respect her a lot. I have known her for many years, and I view her as my senior, and therefore I couldn't just barge into her office and say, but what's happening here? Why did you arrest these people? Why this? Why? That is why I put it in an email. I raised all my queries in an email, and I forwarded it to my colleagues. Then I forwarded to her via her PA. And it was not only this one email. You'll see, I think I sent about 2 or 3 where I was saying there's a problem with this case. The way it was investigated, it was rushed. I remember I sent an email directly to her, and I said, it appears this case was rushed, if anything. There might be a case of fraud or there, but the way the investigations were done were just not on with me.
Just before you continue to your specific concerns, when you say that it was difficult to approach Advocate Johnson, was it purely because of her seniority, or was there something in her management style that made it difficult to approach her?
Yeah. Look, I don't want to sound otherwise now, but yes, management style as well as in, she could be unpredictable at times, you know, and you know, she's a very good manager, make no mistake. For as long as she was in the IDEC, that organization, and even now, I mean, we headless as it is for the last week. She resigned last week, Monday, but the organization is continues running itself. It's like a steam train which is on the track. It's all because of the good work that she's put in. You know, the discipline is there amongst the colleagues. So she's done so much work that even when we're not having an acting head or permanent head, the organization can continue to run itself with the help of, obviously, the the CEO, Mr. Sissoko, and the three deputies that are there. So I think it was more because of fear that how is she going to react, when we take these issues to her, which was also the same, for me, at the level of a DDPP. Not that I couldn't raise issues with her, but you don't know how it's going to end. I referred earlier to a meeting where she was angry with me for raising the issue of a Section 27. So she told me straight in front of the two juniors, why are you making an issue about this? Go and work. Why? I've seen the document. Why do you keep on questioning or second guessing your investigators? So that is what I refer to here.
So in a sense that she, on the one hand, like you said, she's a good manager, but on the other, if you were raising concerns and questioning her decisions, she didn't take kindly.
She didn't take kindly to that, and yes, and she'll tell you straight. So
Were there many instances of this, or was this the only instance? The one instance relating to the Section 27 referral?
To me, Chair, it was only that one instance of the 27. Like I said, I've known Advocate Johnson for many years, and we've had, even though we never worked in the same office, but we've always had a very cordial and good relationship when we met in conferences and so on. And I've known her to be a very good prosecutor, hard worker, and when she came in as a manager at IDEC, the management was, for me, of a very high level.
Thank you.
Yes.
Thank you.
At 46, in my first trial preparation note, I raised, among others, the following questions to the team, but all these are covered in my email. 46.1.
Perhaps, as opposed to reading the summary, we can go to the actual annexure. If we can go to PS3,
Okay.
you'll see it starts with the email,
With the email.
that you sent to Ms. Sekukuni, who is the PA to the ID, where you brought this memo to her attention. And then below that would have been the email you sent to the team members, wherein you gave them Saturday homework while you went and watched a nice game, I see. And then the next page, on page 25, would be where you deal with your concerns. Can we go there?
Yes, Council, you'll see, I agree. You'll see at page 24, it's my email. Actually, the first email will be the last one.
Yes.
You'll see I sent it at 2:51 on the Saturday to the team members, Advocate Tlajwayo, Advocate Ramsemi, Mr. Brian Padayashe, Chief Investigator Daylan Perumal, Investigator Charles Ills, Investigator Patrick Mlambo, and I also copied the project manager, Mr. Sepotlale. I reference the subject as trial preparation, note 1. Colleagues, here is your Saturday homework. I'm knocking off now to watch Pirates and Sundowns, PS. It was 2:51, I've been in the office since in the morning.
Can I just
Yes.
ask a question? What's the difference between a project owner and a project manager? Because we've encountered Mr. Tlale's name before as a project manager.
Yes. The difference, Commissioner Baloyi, is Mr. Tlale is one of the 4 project managers that we have. They are involved right from the beginning of the case. They prepare our monthly reports. They are also a link between us and HR in terms of where we need resources, and they also prepare some documents, some 28s when I prepare a memo or an application, and once it's settled, they are the ones that forward same to the office of the ID, and when we receive a report back, they do a lot of work in the team. They help with the preparing for the budget of the team. When we're traveling, they are the ones who prepare memos for traveling, and when we need resources like computers and memory sticks. So they manage the whole project in that sense.
So we're in I think we've encountered Mr. Tlale and we've had a discussion about him where his name appears I think in a summons, and it says inquiries.
Yes.
My direct question to you is, does he make the decision, I want a summons, and then he prepares the application, or his is an administrative
No,
function?
it's more of an administrative function.
Okay.
The commissioner, he doesn't make, that decision lies solely with the DDPP.
Okay.
On what type of investigations, on investigation do we go, after consulting the team.
Yes.
Whether we go at 2813 or 2818. Project managers do not make those
Thank you.
decisions. Yes.
Thank you.
I'm copying him because he must know what we're busy with, what we're doing. He keeps the file of this matter. So that is why I wanted him also to know that investigations are still outstanding in this matter. And when we're doing a case plan, he must file those. Everything that we do, the project manager must know. So I sent them this email, and the email had an attachment containing queries, and later the very same day at 3:58, I forwarded it to Ms. Innocent Sikukuni. You'll see the message to Ms. Sikukuni has an attachment document 1.docs. The email, the document, that is my document, is now on page 25 with the heading, Dear Team, 1, I have just finished reading the first docket, Brooklyn Cars, in bracket, General Kumalo and others. 2, starting from Monday, I want to sit with the prosecutors, Drew and Joy, to start working on refining the charge sheet, to have it ready for the bail condition amendment application on 22 August and for disclosure. 3, as part of our preparation for the case, the response to the application for further particulars, in bracket, which I'm sure we are going to be served with in due course, and preparation for the trial, I want to know the following, in brackets, the questions are directed to all the team members, I was saying. 3.1, why were the accused charged with corruption? 3.2, who corrupted whom? 3, do we have evidence in the docket to prove allegations of corruption against any of the accused? If so, what evidence is that? 3.4, do we agree that in terms of PRECA, the Corruption Act, the giving and or accepting of a gratification should be for a certain aim or objective? PRECA uses the word, in inverted commas, in order to act personally or by influencing another person so to act in a manner described in Roman figures 1 to 4. 5, that means a person gives another a gratification and the other one accepts or receives in order to act in an unlawful manner as out in Roman figure 1 to 4. 3.6, now following paragraphs 3.4 and 3.5 above, why did these generals in the SAPS go out of their way, rig the appointment process, risk their jobs, and flout the National Instruction 11 of 2017 to appoint a 29-year-old inexperienced civilian to the rank of brigadier in crime intelligence? I'm asking the question, who is this young lady, in bracket Mokwele, for whom 6 generals in the SAPS are risking losing their jobs for? What did the generals stand to gain or expect to gain, in bracket quid pro quo, by giving her gratification, which is the position or the job? What did they stand to gain? I don't have that evidence in the docket. 3.8, what are we saying? Are we saying the generals gave Mokwele a position, stroke a job in crime intelligence in order for Mokwele to do the following? To do what? I'm asking them. What did Mokwele have to do in terms of Roman figure 1 to 4 of PRECA? 3.10, did she give or promise to give any quid pro quo to the generals? In law, she does not have to, but there must at least be an understanding between Mokwele and the generals that the job is given to her for a particular unlawful reason, in brackets, in order for her to act unlawfully as set out in Roman figure 1 to 4. She was just a young lady occupying an ordinary position at BMW at the time. I cannot see that there was anything she could offer to these generals, in brackets, except giving them cash as a thank you, or if she was having a relationship with one of the male panel members, stroke generals. I'm trying to find out why are they giving him a job which, according to the state, she was not deserving to get, and what did she do in return, or what was expected from her? 12, did the team subpoena the bank accounts of the generals and Mokwele to ascertain if she did not make any payments to them for giving her a job? If not, why not? 3.13, were the cell phone records of the generals and Mokwele obtained and analyzed for any communication relating to the application for the post, preparation for interviews, or discussions about payments? If not, why not? 3.14, were computers that were used by the generals during the period in question seized and or mirror imaged to look for communication between them and Mokwele, or, in brackets, or anyone related or associated with Mokwele, prior to or during and after the interview process? If not, why was this not done? 3.15, did the team investigate any possible family relations between Mokwele and any of the generals that formed part of the panel? Paragraph 4, colleagues, the appointment of this young lady to such a position does not make sense and is suspicious, but suspicion alone is not enough. There is a reason why she had to be appointed, and that reason is our answer. It is the quid pro quo. We must look for it, I'm saying. Paragraph 5, otherwise we remain with fraud regarding the flaunting of processes to appoint her. Yes, her shortlisting and eventual appointment was fraudulent because she was inexperienced, in brackets, which was one of the requirements for the position. Many other applicants were disqualified for lack of managerial experience. How did she make it to the top 5 and eventually top 3? 6, she also made misrepresentations in her CV, in brackets, I'm saying fraud. The investigator should follow up the validity of the project management certificate at Stellenbosch University. 7, she also claims to have been top of her class in her first year studies for MBA. She does not say where she was registered for the MBA and whether she eventually completed it. I must say later, with the investigation, it became clear that she had finished the MBA. So that information was secured after I've raised all these questions. But when she submitted the application, she only completed it after submitting it, I think a month after, in May 2024, whereas the application was in
But let me just correct you there, because in her application on page 265, that very issue you are raising, she did say that she's still busy with the MBA and she will only complete it. If you look at page 66, bottom of the page, it is expected. So at the time of submission, she did not have it, and she said so in her CV. And in fact, in her job application on page 263, the only 3 qualifications she lists as being relevant to her application. In other words, she says, I have this many other qualifications, but they are not necessary for this application, because what the job requirements, what the job description requires is these 3. And then she lists all 3 of them on page 263 of file 2. She says BTech industrial engineering, and then she says the national diploma in mechatronics engineering, mechatronics. So she was saying to SAPS, for the purposes of my application, you need only look at these 2, because that's what the advert requires. I have these other things, but they are not relevant to the application. So she made that very clear. There should have been no reason to go look for things that she's not relying on for the purposes of the application. They are mentioned only in her CV because she gives a full description of what she's doing and what she's all about.
I agree, Commissioner Kumalo, and I can say that those were later clarified. The fact that she has a project management certificate It was clarified, and affidavit was obtained from Stellenbosch University to that effect,
There
confirming that she
wasn't
does.
even a need to do that because she was not relying on that qualification to apply for this position.
Yes,
It's a by the way that is mentioned in the CV to say, by the way, I've done these other things, but for the purposes of my application for this position, I am only relying on my BTEC and my diploma. That's all.
I agree, Commissioner. It's just that when the markings were done for the interview, one of the and I think it also comes up in the email where I'm saying, but also she was given more scores by the panel for educational qualifications compared to Van Vuren and Bapela. And SACA only confirms her matric, diploma, and degree in engineering. I'll wait for your input. SEPO arrange a meeting. Indeed, for purposes of the application of this position, those qualifications were not even relevant. But the fact that when the panel members are scoring, they consider and the educational qualifications of applicants comparing one to another, we needed to satisfy ourselves that she has those, in case they were taken into consideration when the panel was marking.
Yes, but you can't say then she committed fraud. I mean, if the panel takes additional things into consideration, the applicant can be accused of fraud.
No,
Because
she
what
can't.
the applicant has put forward is what is required, and those have been verified.
True, I agree with what the Commissioner is saying, and I don't think there was any misrepresentation that was alleged in the charge sheet regarding the project management and the MBA, because as Commissioner is saying, indeed, in her application, she says that the MBA is going to be finalized in future. In fact, it was only finalized a month after the application was submitted.
And this thing here in paragraph 6, that she also made misrepresentations in her CV, I mean, that is not correct.
Commissioner Kumal, perhaps because we also tried to get clarity on this, perhaps explain what you meant by misrepresentations amounting to fraud in her CV.
Right. I'm calling it fraud, Commissioners, because she says in her CV, I've been a middle manager in BMW since, I think she says 2016 or 2017, from the year she started working. And we obtained affidavits, or at least at the time when I read the documents, there were affidavits from BMW, from human resource official, and from a person to whom Mukweli was reporting. Both of them say Mukweli was never a manager in BMW. She was not a supervisor in BMW, and therefore, for her to claim in the application that she was a middle manager amounted to a misrepresentation.
Advocate
Not-
Seronia,
Yes, Commissioner.
what you say in paragraph 6 and what you are being asked are two different things. You say in paragraph 6, she also made misrepresentations in her CV, in brackets fraud. The investigator should follow up on the validity of the project management certificate. But you confirm that that was done. So that's not the issue. And then the CV itself is on file 2, page 265. I have been through this CV. And what you are saying is simply not in this CV, unless you can point to me
Get me the thing.
where that misrepresentation, which amounts to fraud, is set out there. File 2 on page 265. And it's a short CV, it's only 3 pages, so it's not very long.
Commissioner, I'm looking at the CV and maybe in relation to where she says middle manager, it's not coming out of the CV, but out of the application itself.
Yes.
But what she says on the CV, which is a mispresentation, is on page 267, on the last page of the CV, under accomplishment, where she says that she saved over 1 million in IT security project cost by training and equipping the internal maintenance team to carry out some of the project work.
Advocate Serune, let's agree that 267 where you are reading, it deals with successes achieved in the current role. Because she says, I successfully implemented first robotic process, I saved the company 1 million in IT security, I saved 500,000 in annual maintenance, I reduced the electronic tools management.
Yeah.
That's all she says. And in fact, the affidavit from the BMW manager says, well, I can't confirm these things because maybe other people can. That's what he says. But looking at the CV as it stands, you can't say this is misrepresentation, this is fraud. I think for now, let's just accept that unless you can show that what is stated there, those are not accomplishments and that is false. There is no fraud there.
That, Commissioner, that is what I'm saying,
Yes.
that if BMW cannot confirm that,
Yes.
that she saved them 1 million, as she's stating in here, in the account, then she's making a presentation. And if I'm a panel member and I'm reading this CV, it's very impressive that we're looking for a manager. If we can get a person who can save a company so much money, then probably this is one person that I can shortlist. But BMW says now that information.
I think what I wanted to do was to show you that in the CV, the misrepresentation that is mentioned in the memo is not in the CV. I know where the problem could be on the issue of whether she has appropriate management experience.
Yeah.
But that is a different topic, and maybe we will deal with that later on. For now, continue with the rest of your memo, because I was not probing you, but I just wanted to point out to you that the MBA issue, what she said in the CV is actually correct.
True.
And all the qualifications that she listed in her job application and her CV have actually been verified. And you've confirmed that.
I do,
Yes.
Commissioner.
So
Yes.
where there might have been a question mark is on whether she has appropriate management experience. But that's an issue for interpretation, because it's a term that is defined in another document, and even the way it is defined is a bit vague. But the CV as it stands, the qualifications are there, and there's no issue with them.
I agree. With regard to the qualifications, I agree. And like I said, those were verified, Commissioner. The issue of her being a manager, like I'm saying, if we have witnesses from BMW saying she was never a manager with us, that's the only information that we're working from. I cannot say, well, I must interpret her CV or her application otherwise. If BMW says she was not a manager and she says she was a manager, then to me it's a misrepresentation. I was going to call those two, if I was doing the trial of this case, I was going to call those two witnesses from BMW, human resource and immediate supervisor, who would have said to the court, she was never a manager with us. And therefore, how is she then shortlisted if one looks at the requirement of 3-year managerial experience in the field of the post? That is what, to me, at least at that time.
Yeah. No, and that
appeared to be
is a fair question to ask, but I will deal with it with you when we get to the national instruction.
Thanks, Commissioner.
So I have a slightly different question, but maybe before I I ask you my question, let me say in tongue-in-cheek, that if you called those two BMW witnesses, I would have asked, is this an IDEC matter after all? I say that tongue-in-cheek. My question is, your memo seems to me at least, to cover or to raise questions that I would expect a prosecutor to ask before there is an arrest, before there is charging and people are made to appear in court. You seem to be asking basic questions. Am I correct in that observation?
You are 100% correct, Commissioner Baloyi. These questions, the team ought to have asked themselves these questions. When I come in 2 months after the arrest, I was not supposed to be asking these questions, especially if a person is charged with, that's what I'm saying, why did you charge them with corruption? Because I'm looking for the evidence of corruption in the 4 volumes in the docket. I can't find any evidence of corruption. The question that I'm asking, the team ought to have asked itself before making a decision that we are now ready, we're going to arrest. They should have asked themselves, are we going to be able to prove a gratification? Are we going to be able to prove that Ms. Mokwele received a gratification? And the intention element which the authors, Stayman and them, say, in order to denotes the intention element. That is why I keep on asking, in order to do what? She does not have to do anything to say, oh yeah, no, she gave them 500 rand or this or that, but the understanding between the parties that we're giving you this, we are corrupting you basically, and she's receiving on that understanding. These are questions that the team should have asked themselves. And the commissioners will see as we go on in one of my other memos, even if that had happened, I'm raising another question later, but your charge sheet is defective in a sense that you're charging them with section 4 of PRECA, which says, for subsection 1, paragraph A, a person, a public officer who is, so it talks to a public officer who is given a gratification and who accepts or receives or promises or agrees to accept a gratification from, paragraph B, a person, from another person. Therefore, the reading of PRECA will tell you that the way they drafted their charge sheet, it was vice versa. They are saying the generals gave to a civilian, the generals being public officials. If one were to stick to the language of section 4, it ought to have been the other way around. The civilian should have been the one who was giving gratification to the generals, not the other way around. Because the generals are referred to in 4.1a. They should receive, not give. And this civilian should give, not receive. But in their charge sheet, they were having it the other way around. So these are issues that ought to have been looked at, and maybe the charge sheet also interrogated. But in relation to this is about evidence. Do you have enough evidence to go through your intended charge of corruption? My view at the time, Commissioner Baloyi, was that no. They should have been asked right from the beginning. But then you arrest. After arrest, it's only when you start investigating. Now, somebody can say, okay, what if Sirunya did not come on 8 August? I wouldn't have asked these questions. Were you going to go on with that evidence that you had at the time? Was that sufficient? Would you have convinced the court that you have a prima facie case of corruption?
Colonel Parachi thought so, that there was enough to persuade a court that she would have committed a crime in the future, therefore she's guilty of an offense, an unknown crime. So someone in your office thought that there was a good case here, including of state capture.
Yeah. No, I don't agree with that. Definitely, it shows, if you read this as an independent person who comes after the fact, it tells you immediately there was a lot of investigation still outstanding, and you couldn't have arrested go through the processes, bail application stuff, and then only do the investigations after. Especially, commissioners, that we're dealing with a high-profile case, or at least a case that involves the high-ranking officials in government. You don't just arrest people, put them into the court system, only to postpone for investigations. And these cases, we prepare them over a period of time. It's like in the lower courts where we receive decision dockets. I must prepare it in such a way that there's at least a prima facie case. When I put it on the court roll, the one thing that I must do is to postpone to seek a trial date. If the defense says give us copies of the docket, to postpone for disclosure, but not to put a case on the court roll, which we have worked on. This case, I understand, started in December or November of 2024, and by June of 2025, they put it on the roll. For that 6 months, these issues ought to have been covered. You don't put it on the roll only to postpone it for investigation.
Is it fair to say that your memorandum, the questions that you're raising, suggests that your view at this point was that you don't even have a prima facie case yet, at this point?
Clearly, there isn't a prima facie case. When I asked them, for the first question, why are the accused charged with corruption? Who corrupted who? I can't see it. There's no corruption. Who corrupted who here? So there's no prima facie case, not even on the lowest standard of corruption. There isn't.
Did the ID engage you about this memorandum where you're saying we don't even seem to have a prima facie case? Did she come back to you and tell you, no, you're wrong, we do, and these are the reasons?
But now, Commissioner, I was never engaged by the ID on this memo. At least the investigating officers tried to respond to some of my questions.
Yes.
But what they did basically was just to recite what the Act says, and not to deal with the questions.
Thank you.
You were actually playing devil's advocate because this is engagement between you and your colleagues. It wasn't you forming a conclusion one way or the other. You were simply saying to them, let's cover all the tracks. Let's make sure we've investigated this, we've investigated that. And I think all your questions, to be honest, are fair questions to ask if you are given a docket for the first time and you look at it. And then you say something very important somewhere in your statement, because you say even the arrest warrant should not have been issued on these facts.
Indeed, Commissioners, on these facts, there was no case. It couldn't have been. And maybe on the issue of the warrant, Commissioner Kumalo, when I first read the docket, because the statement applying for the warrant forms part of the docket, I remember having a discussion with Advocate Lachwa and asking her how did the magistrate authorize this? And I remember she told me on the first occasion when Brian Barayashi went to court to ask for a warrant, the magistrate turned him away, saying a statement.
So the one that was issued was the second one?
It was the second one to try.
There was one where the magistrate refused to grant the warrant, to issue the
There's
warrant.
one where, there must be one where the magistrate refused to issue a warrant, because the magistrate was not convinced that there was a case. The magistrate who sits and does this, so the magistrate sent him back, and he went and compiled another one, went back, succeeded with the second one. But still, when I looked at the second one,
But why do you say it looks more like heads of argument than an affidavit?
it's because when I read it, it's like a person is trying to, it's like an argument. He's trying to justify why we want to have a warrant issued. But if you have
Chair said it has more conclusions than facts. That's how Chair put it. Is
which
that
I
also
agree
your
with.
view?
Which I agree with, Commissioners. If you have a case, you have a case. You're not going to struggle with drafting an affidavit up to apply for a warrant. And as a prosecutor, you're not going to struggle to draft a charge sheet. If you have a case, you have a case. And I always say to the juniors that come in as part of training, I say, you will see, when you struggle to draft your charge sheet, you must know that there's something wrong with your evidence. If a person stole an item at OK on the 4th of August 2026, your charge sheet reads theft on such and such a day at or near OK Central, this person stole this item, you even describe it worth so much. But if you're struggling to put it into words, what did the person steal, where, when, then it tells you you have a problem, which is what I was encountering as I was writing this email. Who corrupted who, how? There was no evidence to support all that.
After your recusal, you may not necessarily have details, but I'm interested to know whether your questions, I know there was a response, but whether the substance of the issues that you were raising, to your knowledge as we sit here now, was the substance of your questions ever answered cogently?
Chair, they were not. And maybe that is why I wrote a second, or at least in the third trial preparation note. They were not. And I was saying to the evidence leaders as we were preparing this affidavit, and I said, well, I recused myself at least a month and a half after getting it, but if I had gone on and those questions were not answered, I would have withdrawn this case. I would not have prosecuted this case on the basis of the evidence available at the time, unless if all of these questions were answered. I would not have proved a case in any event, even if I went on trial, at least with the available evidence. So I asked questions and I made a follow-up, and I think I sent a third trial note where I got the response was confirmation of Ms. Mukwele's qualifications and one or two other things, but by and large, my questions remained unanswered.
Yes. I'll make a comment that I've made repeatedly during the testimony of the IDEC witnesses. We are not asking these questions so as to pronounce on whether the generals or the officers are guilty or not. But we are asking questions that may touch on whether there was a case at all, because for us at issue is whether charging the generals at all was improper. So questions of whether there was a case to start off with may be relevant to that question, which is relevant to what we are about. Now, I thought I should just again, for those who may be asking themselves, but are they a court that's going to answer the question of guilt or not? So I thought I should just again repeat that comment. It's probably for the third time that I'm making that comment. Let me ask another question. When you sent your email with your several queries on the 16th of August 2025, just before you went to watch Pirates and Sundowns, you also copied the Advocate Johnson's PA, or you sent her separately. And your cover email to which you attach the queries, you say FYI, which means for your information. Here's what I want to understand. On internal IDEC processes, what would your intention have been? Would this have been for the information of the PA only, Ms. Sikukune, or did you believe that she would not hog this, but that she would forward it to her boss, Advocate Johnson? And if your response is the latter, why did you not say this is for the information of Advocate Johnson? Then that way there would be no question that this would end at Advocate Johnson's desk.
Thanks, Chair. Chair, that is how we communicate with the ID. She's receiving, I would want to believe, numerous emails on a daily basis, and therefore the practice then is we send to her PA, who then sends emails to her. But if there's something urgent, she has said that to me on a number of occasions. It was on a private matter when I was off sick, and then I sent the email to Sekhukhune. They said, no, Peter, when it's that urgent in the morning and you're not feeling well, please send it directly to me. You can copy Ino, but also send it to me. So if it's urgent, then you even call her, say, ID, I've sent you an email, please check. But when I send it to Ms. Sekhukhune, I'm sending it to her to forward it to the ID. That was the practice, or that is the practice in the office, and I'm sure that she gave her this email. I did not receive any response from the ID on this one, but on the other emails where I did something similar, the ID would have responded to me to show that Ms. Sekhukhune forwarded to her.
All right. That was going to be my next question as to what your experience is with regard to feedback. Would you get feedback that would indicate that Advocate Johnson would have received something that was sent to the PA saying for your information and saying this to the PA? You've answered my question. Thank you.
Before you move on,
Yes.
the role of the prosecutor, and you can clarify for me which prosecutor, because there's a junior, you've got a senior, you've got you, the DD, yes. But then there's also the prosecutor at the NPA, as we've understood, they get to approve something. When it comes to the warrant, applying for a warrant of arrest, what are the approvals level? Who finally says something that enables, let's say, a Colonel Pariachi to go to a magistrate and eventually get their J50?
Commissioner Baloyi, what happens is when the team that's working on a case comes to a point where they have the view that they are ready to enroll, they make a presentation to the ID, and with the CEO, head of operations, Mr. Soko, sitting in. So it is at that level where decisions are taken to apply for a warrant. I must be honest, I don't expect, and I've never seen the ID reading to a point of reading the IO statement. I don't expect her to do that. But in these memorandums that are sent to her, prosecutors would have summarized the evidence in the docket. This is 820, it is the affidavit of Brian Parayashi, which says the following in brief. Therefore, but in the actual engagements with the ID, they must say to her, we are ready, these are the charges that we want to proceed on. Our application for a warrant is ready. Here it is, ID. Our bail statement is ready in case you're going to oppose bail or not, but we've drafted that, and those decisions are then taken. Go ahead, or no, I'm of the view that you still have to do 1, 2, 3.
So it's the internal, the IDEC internal prosecutors that look at this application and the affidavits before Mr. Pariachi takes it to court, takes it to a magistrate who approves the J50. What I'm trying to understand, and it's been a question of concern, at least for me, but where were the lawyers? Maybe Colonel Pariachi can be excused because he's an investigator, but there must be some meaning to prosecution-led investigations, and so you say to us, Colonel Pariachi went to the magistrate the first time and he was turned back, right? Then the question is, well, does it mean the lawyers in there, the prosecutors, had never looked at his work before he went to the magistrate? So I asked the question to try and understand how it works, because it is an important question. What is the role of the prosecutors in what turned out to be a big mess in process.
Indeed, Commissioner Baloy, the prosecutors are there to do exactly that, to advise on legal issues, to read these affidavits. The affidavit would have been drafted by the investigating officer. But before he goes to the court to ask for a warrant to be issued, internally, the team looks into the affidavit. Each member of that team has a copy of the docket. They read the docket, they discuss these things. And the prosecutors are there exactly for that purpose, to advise on those issues. And the other thing is, once they agree that you are going to arrest, then the investigative officer Padayashe would have drafted a warrant, a J50 warrant. That warrant is first authorized by the internal prosecutor to.
In this case, the internal prosecutor, you were not there at the time. In this case, the internal prosecutors would have been either or both Ms. Tlachwayo and Ms. Ramsamy.
And Ms. Ramsamy.
Yes.
One of them would have then authorized that warrant. And for one to authorize the warrant, you therefore have to read first this affidavit.
Yes.
And to say, yes, we have a case, I agree with this. And the warrant also states the charges, I agree with the charges. Then the prosecutor authorizes that. Then the IO, Mr. Parayashi, takes his affidavit and the warrant, the J50, he goes to the magistrate to ask for a warrant to be issued.
Okay.
There's always a magistrate who's on standby, who's dealing with these issues. The magistrate will also do the same, go through the statement. If there's a charge sheet attached, go through the charge sheet. And if he's convinced that there's a prima facie case, and then issue a warrant.
Thank you. Thank you.
Let us take the lunch adjournment. Let's adjourn and resume at 2:10.
Good afternoon. We're about to resume. Kindly switch off your phones or put them on silence. Thank you.
Yes, Ms. Bowe.
Thank you, Chair. Commissioners, the engagement before we took the lunch adjournment, most of the answers are covered in aspects of the statement, and so I'm not sure if we should rehash those. Paragraph 47 in particular, you'll see the witness dealt with why he was sending that and even confirms that he wanted that this verification and outstanding investigations ought to have been done before the arrest and not after. At paragraph 48, he explains why the charges of corruption didn't make sense, in particular that to contend that a future corrupt act would be purely speculation, as observed by the commission, would be fortune telling. So all of that was covered in the engagement prior to the break. Paragraph 49 is where he deals with the investigation team's response, and this is where I propose we start so that we can note the response that was given and then take it from there.
Thank you. Advocate Serunye, I'm sure you agree with it, that we skip and go on to paragraph 49. Is that fine?
It is in order, Commissioners. I agree.
Thank you.
Chair.
Thank you. 49 then.
Thanks very much. And from paragraph 49, now after they've responded to my email now, I'm saying a number of the assertions advanced by the investigating team in response to my questions did not appear in the docket. By way of example, the responses referred to Ms. Mokwele's father, said to be a suspended brigadier in the Directorate for Priority Crime Investigation, who had attempted to corrupt investigators, and to a theory concerning the capture of a sensitive intelligence resource. I could find no evidential foundation for these assertions in the docket, and their relevance to the charges was not apparent.
Advocate Serunye, can you just stop there for a second? Commissioners, the response that we're referring to there is at page 29. It's annexure PS4. Again, we'll have to work up from page 30, actually. So you'll see at page 30, the email there is from Advocate Serunye to the team. What follows thereafter is a response by Mr. Perumal, where he attaches his comments in text. You will see the comments if you go to page 31. The blue would be the additions. Is that correct, Advocate Serunye?
Indeed, the blue is the answers
Yes.
of Mr. Perumal.
And you testified earlier that for the most of it, what they did was to recite provisions of the legislation and didn't answer substantively to the questions that you had posed.
Correct, Chair and Commissioners.
And the example you were making is at page 36 in the response. And that is in respect of 3.7. Is that correct?
That is correct, Chair and Commissioners. That is where they are saying something about the father of Ms. Mokwele having been a brigadier in the force, but this is not supported by any evidence, and doesn't really take the case any further.
And I noticed that there are no answers to some of the questions.
I agree, Chair. Some of the questions were not answered.
And the remaining that were answered, they indicated that some of those subpoenas would still need to be issued. Is that correct?
That is correct, Chair.
Commissioners, that should deal with the response.
No, you've got question 3.6, so the answer to 3.6 at page 35.
Yes. Advocate Surinye, there you had asked why the generals would have gone out of their way to rig the process. So it seems that there was an explanation covered there in relation to the use or abuse or capture of TSS.
Indeed. But this, in brief, their response to my question was as follows: that Senior Investigator B. Padayashe, Colonels Bapela, Van Vieren, and General Khan will explain what TSS is. It is the most valuable intelligence resource, and accused one, in brackets, who did not need to chair post for a brigadier, as a Major General could have chaired the panel. Accused one had a desire to ensure full control over TSS, need to know of its operations. He clearly did not have any confidence in any of the vastly skilled and experienced colonels of the crime intelligence, capture of the section TSS. If you read that response, clearly it's not answering the question I was asking about why these generals in the SAPS would go out of their way to rig the appointment process and risk their jobs to flaunt the National Instruction 11 of 2017 to appoint Ms. Mukwele. Their response talks of the intelligence resource, TSS being, it doesn't really answer the question. It's irrelevant.
Then 3.3, and I just want to understand what you understood there. You've got that question, do we have evidence in the docket to prove allegations of corruption? And then the answer is yes. But I'm more interested to understand what you understood this to mean, which is, if you read in that 3.3, that answer, the second line from the bottom, it says they acted in an incomplete, biased, dishonest manner designed to achieve an unjustified result. And then this is the part. Accused one needed to ensure control over TSS. And then in brackets, you have KZN Colonel. And then post withdrawn, re-advertised by accused one. In brackets, you have Khan, it says. And then accused one moved to advertise. Solicits accused 5. There's a Van Vieren again mentioned, and Bapela Van Vieren. What did you understand these names here to mean? And maybe let me be more direct. Where it refers to General Khan, what did you understand that answer to be?
Thanks, Commissioner Baloy. He says there that the initial advertisement, which was placed by General Khan, had been withdrawn, and the post was then re-advertised externally to allow civilians to apply. But that still does not answer my question on what is the evidence in the docket that proves allegation of corruption against any of the accused. And by the way, the withdrawal of that advert, I don't know what relevance the withdrawal has to the advert being done the second time around and being advertised internally and externally to allow civilians to apply, because there is nothing wrong in doing that. We don't know what the results of the first advertisement were, if the SAPS managed, from the people that they managed to interview, they could identify potential suitors to the post. We don't therefore know why they didn't go through to appoint people and then re-advertised. And therefore to want to bring the fact that the first one which was drafted by General Khan, was withdrawn, and I don't know what's the relevance of that, honestly, to the question, what is the evidence of corruption in the docket? And TSS, a colonel in KZN, I don't know who they refer to there and what the relevance of this is. It's like a person having their own theory to say, this is why they did it. They did it for this particular purpose. Or maybe they had information, other information which is not in the docket, and which they are not telling me. But for that, I cannot understand with this one paragraph what message they're trying to portray to me. It appears as they were investigating this case, there's this other information in the background which is not given to me or to the prosecutors, or at least not forming part of the docket. And that is not going to help to prove our case, honestly.
Okay. Lastly from me on this, at question 6, the answer to your question 6, where you ask, where you say she also made misrepresentations in her CV, fraud in brackets, the investigators should follow up on the validity. And then the answer from Mr. Perumal is section 28 to be authorized urgently. NB concluded on 26 December, and then he goes on to say Boxing Day, and he underlines it. What were you made to understand was the urgency here, was urgent about this matter? That's the first question. The second question is, did you consider it an urgent matter that needed to be brought to trial very quickly?
Commissioner Baloyi, I don't know what the agency was about, and like I said, my impression after reading all these documents was that the matter was rushed to court, and it was done so when it was not ready to be enrolled. I don't know why it had to be done the way it was done. We talk about these things in the office. We have training, we have a manual that guides us on how to do our work. Like I said earlier, we don't arrest people only to place the matter on the roll and postpone for further investigations, which is what happened here. I don't know exactly what was the motivation for this agency or rushing this case to court.
Thank you. Thanks, Ms. Bell.
Thank you. Then, Advocate Serunye,
Sorry,
if we
Counsel,
can...
maybe just to add, I've worked on a number of these matters in the ITEC, and I must say, looking at the history of this case, where the authorization was done in December of 2024, and the arrest is done in June, say 6 to 7 months. This is one of, I've never seen a case be done so quick, where in December authorization and in June, this was done so hastily. If investigations were completed and it was ready, I would have said, well, the investigators did a very good job in this. But they rushed it to court, and clearly it was not ready. I don't know why.
Is your point that there may have been something to the urgency, because normally you wouldn't be able to investigate a complex matter that quickly?
In 6 months,
And
it's
it's
impossible.
also very clear from the docket that the investigations weren't complete.
In 6 months, it's impossible. I didn't know or suspect anything at the time, but things did not look right. But knowing what I know now, what I've heard in the commission, it clearly shows that there were other things happening in the background which really led to all of this. I wish I could, at the time, have the ability to see into the future. Then I would not have involved myself in this. Maybe I would have quit it more. Maybe I would have acted further. But unfortunately enough, just a normal human being who don't have those powers. Only seeing things now as they're coming out here.
Maybe another statistic, and to ask you to comment really, is that you may not be aware of, if you are not, is that the investigation in terms of 28-1 was authorized, I think, the 28th or the 30th of May in 2025, and the arrests were in June already. How does that compare with your experience from investigation to now we go to court in terms of timeline?
Thanks, Commissioner Baloyi. Yes, I think I was listening on the news. I've heard that. That can only mean one thing, that as at May, when the 28 was authorized, the investigations were so advanced to a point that one could say it's actually ready for court. That is why when they authorized the investigation in May, then the next month, the arrest follows. I don't know if between the date of the authorization in May and 27 June, if there's any investigations that were done and how many statements were obtained in between that period. I doubt if there's any. It appears the moment they authorized the investigation, for them the case was ready for court. It was just an issue of drafting affidavits for warrant of arrest and doing the consultation between the DPP and the IDEC and to get the matter to court.
Thank you.
Advocate Surinya, you can then move on to paragraph 50. I think you've dealt with the first part of it. What you hadn't dealt with is your request that an HR expert assess all the applications.
Yes. Thanks, Council. I'm at paragraph 50. Now, with all these questions that I'm having in being new into the matter, I wanted investigations to be covered. And my affidavit reads, as regards the qualifications relied upon, SAQA confirmed only Ms. Mokwele's matric, diploma and engineering degree. Her project management certificate and her MBA were not verified at the time. Verification was only obtained belatedly after the arrest and after my repeated prompting. In addition, no HR expert had been engaged to assess the full body of some 76 applications so as to determine whether the disqualification of other candidates and Ms. Mokwele's progression to the shortlist and appointment had been proper. Determination of that nature could not be made without such expertise. I raised this in one of the queries that please take all the 76 applications that you received, appoint an HR expert. You are not HR experts. You cannot say this one was favored over this one received more scores compared to, you don't know how the scores were done, why a particular candidate would have been given, especially now the last three candidates. Only an expert, HR expert in that field can be able to do that investigation for you and compile a proper report. And from there on, we know we have, if the HR picks up, if the expert picks up mistakes or favoritism, he will say so. But you as investigators do not have that capability to say this one was favored over that one. You don't know why they scored 68, 69% and Van Vuren got 48%.
Advocate Serenia, I think you've dealt with this earlier, but just maybe clarify which qualifications were verified before and which ones were verified belatedly, as you say in paragraph 50.
Yes, thanks, Commissioner. The affidavit we got from SAQA confirmed the matric and the diploma and the, I think it's an engineering degree. Yes. And these two that I had questioned about, these certificates that I questioned about, the project management and the MBA were verified.
They were also verified, but after you became
after I had asked those questions. Yes. On that email of mine, I'm saying, please verify, because I can see that in her CV or application, she's raising the issue of an MBA and a project management. MBA, one of those, like we dealt with it earlier, she clearly states, I'm still in the process of finalizing this. I think it was only finalized a month after her application was in April and it was finalized in May. But on her CV, she states it.
And the importance of that is that would have been before the interviews, even before the appointment.
That's true,
She
Commissioner.
would have had the MBA before the October appointment.
That is correct, Commissioner, yes. When she said for interviews already, the MBA was completed.
She had already obtained MBA when she sat for interviews and when she was appointed.
That is correct.
Yes.
Commissioner, yes.
And Advocate Surinya, was an HR expert ever appointed or engaged as you suggested, to
It
your
was-
knowledge?
It was not done, Council. The appointment, or at least efforts to appoint an HR were not followed up, were not made. I'm not sure now as the matter stands now, because I'm no longer part of it, but this was not done.
Now,
Ordinarily, would you prepare a charge sheet which contains a charge on such an issue, this HR aspect, let's say, even before you consult with an HR expert?
I would not, Commissioner Baloyi, because what I'm going to allege in that charge sheet would be information that is not verified. So at least if I have an affidavit and a report of an expert and I consult with them, and I'm satisfied that the expert gives me more information, then I can allege those issues on the charge sheet. But before that, I can't. Otherwise, I'm just speculating, and information comes afterwards that no, there was nothing wrong with what you are alleging, like it happened with some of these things.
Thank you.
It's like if I were to give an example about, say, in a murder case where allegations are that the deceased was shot with a fire, or the deceased was shot with a firearm, people find the body lying there, and they assume the person has been killed by being shot with a firearm. But still, the post-mortem has to be done. Experts have to check, is this wound consistent with an injury that can be caused by a bullet, and then make their report and say, this injury is consistent with a bullet wound. And only then can I, as a prosecutor, with certainty say, this body, the person was killed with a firearm. But otherwise, I can make a mistake. We can assume that the injury was caused by a firearm, only to find that it was a stab wound or a person fell on top of a rock, and so on. So these aspects are important in that sense.
Advocate Sirunye, at paragraph 51, you deal with your response. I just wanted to note on the 17th of August, you responded twice. The first response is at page 29, PS4 at the top. You'll see there that was your first response.
Indeed, Commissioners.
Would you like to put that on record?
That response was after receiving the response to my first trial note, who was asking questions. After receiving the blue note, you see, I'm sort of frustrated by that, and I'm saying to the two juniors, Advocate Tlachwayo and Advocate Seremsemi, that I'm asking questions. Instead of providing me with answers, I'm provided with a citation of PRECA. I know what section 1, 2, 3, and 24 of PRECA say. I do not want to sound critical, but reference to section 24 is misguided and misunderstood. Section 24 would be relevant if the generals were the ones that had received gratification from Mokwele, who was seeking to obtain employment from the public body. The law must be applied to the facts. What I want to know are the facts. It does not help to hide around the fact that the awarding of the position opposed to Mokwele was a gratification. The fundamental question is, why are we saying it was a gratification? In brackets, in the context of the case, that is on the facts before us, why are we saying it's a gratification? Therefore, it doesn't help me to cite what section 1 of PRECA says, that a gratification includes employment. I know that. Why are you saying, in this case, this appointment of Ms. Mokwele is a gratification? They don't provide me with the evidence.
And this response was just to the two junior prosecutors.
Yes.
You then do a second response, which is at page 52. And that response is then to the whole team.
Yeah.
I don't propose that we go through the entire response. A summary of it is at page 50, at paragraph 51. So then we can take it from there.
Before you do that, Did you get a response from your junior prosecutors at to the email at page 29, Ms. Ramsameh and Ms. Hlachwayo?
I did not get any response, Commissioner Balodi.
Thank you.
Yes. And Council, on page 52, after sending the email to Advocate Hlachwayo and Advocate Ramsameh, I then responded to the email, the blue explanation. You'll see the first person that I'm sending a message to is the one that I would have received the email from, being Chief Perumal, and the rest of the investigators, but again to the prosecutors. In brief, saying to them, my email and inputs received.
Advocate Sirunye, my proposal was
Yeah.
for us to look at your summary that you've done in the statement.
Okay.
So at
It's
paragraph
on page-
51,
Paragraph
page
51, thanks.
15,
Okay, yes.
you'll see in short.
Correct. In a nutshell, that email I'm repeating here by page 51 of my affidavit, rather paragraph 51 of my affidavit, where I'm saying, in my reply of 17 August 2025, I set out my analysis of section 4 of PRECA. In short, section 4, subsection 1, paragraph A contemplates a public officer who accepts gratification from another person, and section 4.1b contemplates a person who gives gratification to a public officer. On the state's own allegation, the position was the other way around. It was alleged that the generals, in brackets, who were public officers, gave the gratification in the form of employment to the civilian, Ms. Mokwele, without it being shown that what Ms. Mokwele was thereby to do. That allegation does not fit the wording of section 4. I further explained that the presumption in section 24 did not assist on the available facts, since it would have been available only had Ms. Mokwele been the giver of the gratification to the generals. I concluded that the corruption charge, as it stood, was defective and did not comply with the definitional elements of PRECA, and was liable to be challenged in terms of section 85 of the Criminal Procedure Act. I remained of the view that if corruption were indeed present, its existence depended upon establishing a motive or quid pro quo through further investigation. The bank statements, cell phone records, and computer data of those concerned, and any family or other relationship between them, and that, absent such a motive, a charge of corruption could not properly be sustained. This work had not been done before the arrests were effected. Taken together, the questions I raised remain unanswered on the material in the docket. The significance of this is twofold. First, it demonstrated that the arrest had been premature. As I put it in my correspondence at the time, the matter had been rushed to court when it was not ready. Second, and more fundamentally, the nature of the unanswered questions demonstrated that the preliminary investigation had not been properly conducted. Alternatively, that there was no case. These were not peripheral queries. They went to whether the essential elements of the offense charged could be established at all. I also raised the question as to the basis upon which the matter fell within IDEC's mandate. I record for completeness that I considered a matter of this seriousness involving senior officers in the intelligence environment to be one that could be appropriately be handled within the IDEC space, whatever difficulties attended the matter in which it had in fact been investigated and prosecuted.
I want you to go to PS 11 on page 102.
I'm there, Commissioner.
Are you there, Advocate Serun?
Yes.
It's an email that you sent to your colleagues on the 26th of August, 2025. Do you see that?
I see that, Commissioner.
And the very first question you ask after the greetings, but this relates only to the Lushaba matter, as I see, it doesn't relate to both of them. But you ask the main questions, colleagues, does this case fall under the mandate of IDEC?
Indeed, Commissioner.
So this is maybe 2 weeks after you came into possession of the dockets. You were already concerned about IDEC's mandate.
Indeed, Commissioner.
Now, going back to the Mokwele/Khumalo matter, once you discount the corruption, which you say, as far as you're concerned, based on your understanding of PRECA,
Yes.
it just wasn't there. So if you remove corruption and you leave whatever that remains, would that fall within the mandate of IDEC?
Definitely not, Commissioner Khumalo, because if I discount the corruption, then let's say what I'm left with is fraud, and that will be the fraud against the civilian.
Yeah.
Because in that case, then the generals would have been my witnesses, that is the persons to whom the representations were made. And it's clearly a lower court matter, a regional court, maybe district court even. It
And
clearly did not
you
belong.
can't have it both ways. You can't say they colluded and then they were defrauded.
Yes. If I'm ending up with a fraud, they are victims. They've been defrauded as well. They've been representations made to them.
Yeah.
Then I cannot charge them with her. But if the investigations which I wanted them to do, where I'm asking questions, on your theory, if there's corruption, then there's collusion. If things did not happen this way and happen that way, if the national instructions were breached, then we're talking collusion. If I were to say, yeah, but these high-ranking officials in the intelligence unit, could they not pick up, if there was fraud, could they not pick up this fraud? And if I come to the conclusion that they closed their eyes to it, then that means they colluded with her. That is why then the collusion. But that would have been if the evidence points to that. But on your initial question, if I ended up only with fraud, then clearly doesn't belong in the IDEC space. It was not, even the magistrate questioned it on the first appearance. He said, this is not that kind of fraud or corruption that I deal with on a daily basis.
And you would have had to send it to an HR person, as you say. An HR person would have had to assess whether, is this a misrepresentation, or is it a simple case of people interpreting a provision differently? The reason why I'm asking you this, maybe we should deal with it now so that we don't come back to it. If you go to file 2, on page 179, I know you had it next to you there.
Yes, I did. On page
179.
179. I'm there, Commissioner.
The first bullet that you see on page 179 says, must have a minimum period of 3 years appropriate managerial experience, and this is the important part, in the field of the post. So not just any managerial experience in the field of the post. And then when you go to page 60 of your statement, your annexures on page 60.
Is that paragraph 60?
Paragraph 17.
17.
60, page 60.
Okay.
It is PS 6.
Yes, I'm going there.
And then paragraph 17.
I'm looking at 17,
Yes.
Commissioner.
So the definition of appropriate managerial experience, it comes from clause 2 of the National Instruction 11 of 2017.
Sure.
And it defines that as experience at a level higher than the supervisor. That's all it says. It doesn't say you must have been a manager at your job, because if you were a manager at your job, then you would have to say, at my employment, I was a manager. So if you go back to 178, if an advocate had applied for this position, for example, and it was an advocate who's been practicing for 20 years at the bar, the education qualification would be there, LLB. And then when it comes to this requirement, he would have to tell you, because there are no managers at the bar, I can tell you that. But I would have to then explain to you why my experience is an appropriate experience at a level that justifies appointment. And I assume it's the same if somebody was a prosecutor for 25 years. They may not have been managers at NPA, but because they meet the educational requirements, now what you want to know is, do you have the appropriate managerial experience for the role? Not that you must be a manager at your job.
True.
Now, I don't know if you have file 3 with you.
I have it.
On page 908.
I'm on that page.
If you start on 907, what you have is the job description of Ms. Mokwele at BMW.
That is correct.
On 907.
That is correct.
And then it describes the role, maintenance and fastening planner. And then there's the job description, job valuation, PZP3. If you go to 908,
I'm on page 10.
there is then the description of the role, and halfway down the page, you will see that role of the described function, please check where appropriate. Do you see that?
I see that.
And then there's a tick, she's an employee, and then project management and functional leadership. So that is since 2007, that is the role.
Yes.
And then if you go to the next page, 909, it sets out the key responsibilities of this person. It's a lot of them,
Yes.
it's about 16. Now, all of them are leadership in nature because they're about directing, they're about leading, they're about controlling, they're about being responsible, they're about being responsible, they're about being responsible. Do you see all of those?
I see that, Commissioner.
So they are not about, no, somebody will tell you what to do and you will do it. This function requires that she be responsible for all those things.
Yes.
So it was her responsibility to make sure that the people below her, whether they report directly to her or indirectly, make sure that those things happen.
Indeed.
And then one has to interpret whether that qualifies as appropriate management experience. And as you say, an HR person should have done this. But what IDEC people did was they went and obtained a 4 July 2025 affidavit from Mr. Simon at BMW. But the question they asked is the wrong question because their question was, is Ms. Mokwele
Was she
a
a
manager at BMW? But that's not what the role requires.
Yes.
As you quoted the instruction on page 60 of your, it's appropriate experience at a level above the supervisor. That's all you are required to show.
True.
But those are HR matters that somebody who's steeped in HR is better placed to deal with, including, for example, the public service, the PSC, the Public Service Commission. It's not for IDEC investigators to say, you are a manager or you are not a manager.
I fully concur with you, Commissioner Kumalo. That is why I said to them, get an HR expert and take all the 76 applications, look at them. It's not up to us to say this one qualified, this one not. Yes, there are those that, on the face of it, when you look at the application, the person would have been disqualified because they don't have the necessary qualification, or the application was received late. Those
And
are
then
straightforward.
it becomes a matter of interpretation if you go back to 909, whether somebody who has done that for, let's say, from 2017 to 2024, that's about 7 years,
Yes,
more or less, yeah.
Yeah.
So you can say, does that then qualify as appropriate managerial experience as defined in the national instruction? So that's how one should deal with it.
I concur, Commissioner.
And quite rightly, you said, we are not qualified to do this. Get an HR person to analyze these things and give us an answer. And you say that was not done.
It was not done, Commissioners. It was not done.
Thank you.
And I agree with what you're saying, Commissioner, that looking at the functions, it's a question of interpretation. Some of these responsible for valuation of statistical data, and these are not
Chair,
functions that you can give.
Chair has just directed me on 909.
909, yes.
One of those bullet points, I think it's number 5. It says leads special projects and technical related project teams.
Yes,
That's a leadership role.
it is. Indeed, it is, Commissioner.
Advocate Balwa is referring me to another one, so it's the same one. Oh, it says from all departments and levels, including management. Do you see that?
Yeah, I see that, Commissioner. In fact, the majority of them, Commissioner, if you look at the being responsible to initiate and follow up on corrective actions, time and cost-wise. Most of these management-related.
So
And
most of the functions she was performing at BMW for a period of 7 years are of a management nature, although she did not occupy the official title or official position of manager.
I agree.
Because when you direct, control, and oversee, whatever your role is, you are managing. You are responsible for projects, you are responsible for people, you are responsible for ensuring that things get done.
Indeed, Commissioner.
So the question asked of the BMW person was a wrong question, because what he was asked was she a manager at BMW?
Yeah.
But that's not what the advert requires, and that's not what the national instruction requires.
Indeed, Commissioner. And I think maybe to add on what Commissioner is saying, they also underplay this role where, and I think it's common cause between her and Mr. Seyman, that she was having about 15 people that she was supervising, or at least teaching. It cannot be, that task cannot be given to the most junior of your officers.
Yeah.
Or even if you do, but that comes with a lot of responsibility, that you trust the person and they're imparting knowledge and skill. It's also a management function.
The mistake they made was not to show Mr. Simon the national instruction and to say to Mr. Simon, please tell us what Ms. Mokwele was doing at BMW. Is it experience at a level higher than the supervisor? And what were those functions? What they went there to ask was she in senior management for 7 years? That's a wrong question.
True.
And to then go to court and say she must be arrested for fraud because she doesn't have 7 years senior management experience. Before we even get to the charge sheet, just asking the court to authorize arrests on those facts, that is problematic.
I concur, Commissioner Kumali. These are things that it goes back to my earlier position that the investigation was rushed, or at least the arrest was rushed. These are issues that ought to have been dealt with and determined before arresting.
And to your credit, once you saw the docket, you asked these questions.
I did, Commissioner, because a lot didn't make sense, really, and I was worried that people have already been arrested, and not just not that any person has to be arrested, but the most senior people in the police, and at a very sensitive unit for that matter.
Mrs. Strunya, you may well have answered in your way you started in this discussion with Commissioner Kumalo, but I just want to be clear about the position that you express in paragraph 54 of the statement. You raised a question on whether this matter fell within IDEC's mandate. But then you go on to say that you considered a matter of this seriousness involving senior officers in the intelligence environment to be one that can be appropriately handled within the IDEC space. That's a bit confusing for me. What are you conveying? What are you saying in paragraph 54?
Yes. Commissioner Baloyi, as seen on the other email with the Lushaba matter, I questioned whether this fell within the IDEC mandate. When one reads the docket right from the onset, you're seeing offenses, fraud, but then you go deeper into the merits. You don't have evidence. But that is why the first question is, does this really belong here? But if you were to follow these queries or find evidence of, let's say if they followed the queries or even before I asked, they did an investigation and they found evidence of corruption, then I would have said, then that's where it comes up to say that if you look at the role and rank of the officers, maybe I don't expect the district and regional courts to can handle a matter of that nature. But the problem is there was no evidence to back it up, to say this case belongs here. The allegations are serious when you hear of them, but once you start reading the docket, you don't find evidence to back those allegations. So if there was evidence of rigging of the applications and the unlawful appointment of a person who was going to occupy a position paying her over R1 million a year, and there was collusion with the police, definitely it would have met the criteria of the IDEC. That is what I'm trying to say in the thing. But the problem is that there's no evidence. Even if one were to say we're transferring it to the lower courts were still going to sit with the same problem of, but where's the evidence to prove all these allegations?
Is another way, I'm just trying to understand what you were saying here, is another way of what you're saying in paragraph 54, that if the allegation of, because this case is about gratification, that's how they formulated it.
It's true.
Are you conveying in 54 that if we can make out a case for gratification considering that it involves these senior officials, the matter would fall within the mandate of the IDEC? Is that what you're saying?
That is the message I'm trying to convey, Commissioner Baloyi, that it would have been meeting this requirement of corruption involving high-level persons to a point that it then falls within the mandate of the IDEC.
Okay.
But it didn't come close to that. At least with the evidence, I would have expected right from the onset the person who read the docket or those, after compiling the evidence, once they said and presented, a decision ought to have been taken there and there to say, look, let's refer this matter to the lower court. If there's evidence of prosecuting somebody with anything, because it doesn't also help to refer the matter to the lower court to say, deal with this problem for us. There's no evidence. See what, if we can make a decision ourselves at IDEC to say, there's a case or there's no case. If there's no case, we close it. We make our report. Why are we saying there's no case, and we file the documents. If there is a case, then we prosecute. But there was, for me, there was no evidence backing up those allegations.
Now, Ms. Johnson was asked more than once whether the way things developed
Yes.
up to the point where these generals and brigadiers are arrested and then presented to court, and they're getting these postponements, ongoing postponements, whether no one in the office of the lawyers, an office which has many lawyers, whether no one ever raised concerns about the strength, whether firstly, whether this matter falls within ADEC's mandate, but two, the problems that we were discussing with her. You've discussed some of them with Commissioner Kumalo. What is gratification? Ms. Mukwele seems to have met the requirements. How do you have a charge of corruption under PRECA gratification when you say that she would have done something in the future which is unknown? All of those were discussed with her. And then she was asked more than once, does this mean no one in your office ever raised concerns about this case, the merits of this case and the mandate of IDEC? And she firmly said, no, no one ever did, none of the lawyers. What do you say to that?
With respect to Advocate Johnson, I did. I raised, I think earlier we read one of my emails where I referred these queries to her. And it was not only that one email, but there's two, maybe even three others that I referred to her, where even with the Lushaba case. The Lushaba case is worse. That's why I'm saying. So I did. I don't know if maybe
So she was not being truthful.
Maybe she did not have my email communications to her, but I did. I raised my.
Do you have reason to doubt? Do you have reason to doubt that she received your emails and your memos? Is
No,
there a
she
reason that
received them.
She received
That
them.
I can confirm, because once I send an email, Innocence, and there's one email, for example, where she responds to me, when I'm asking her, should we serve at 28, or is this office, referring to her office, going to write a letter to the National Commissioner? I send it to Innocentia, but the ID then responds to me, say, serve at 28. So, and when I send an email, and this is the practice in the office, to the PA, if you see that you're not getting a response, you make a follow-up with the PA. Did you give my email to the ID? Sometimes you go straight to the ID's office, or call, or send the
So
email to her.
in short, she did become aware, she was made aware of concerns about this case, the Lushaba and the Mukwele matters.
She was. I did that personally.
And
I made her aware.
she was not truthful to us if she did say to us, as I say she did,
Yes.
that no one in the office raised concerns about this. She wasn't being truthful.
Commissioner, if that is what she said to this commission,
Then she was not being truthful.
I don't agree with that.
She was not being truthful.
She was not being truthful.
Thank
And I'm
you.
saying that with the utmost respect.
I
for
appreciate,
her.
I understand that. Thank you.
Advocate Serunye, I want us to put away file 2, but before we do that, there is a standalone allegation that a young woman has been parachuted to the rank of brigadier. And I think Mr. O'Sullivan, when he was here, made that allegation, and it's one of the things he wants us to look at. So on 178 still, of file 2.
I have it, Commissioner.
My understanding of item 3.2 is that the moment you get a suitable person from outside and you appoint them as section head, technical support services, what then follows is that they will be given the rank of brigadier. So, and you get that rank because you are appointed to this position, not because you are 43 or 26
That's true.
or 35,
Yes.
or you are male or female. That does not matter. If you meet the minimum requirements, you go through the interviews and you are vetted and you get appointed to this role, you will be given that rank and you will become brigadier.
That is true, Commissioner. The advert was not referring to a specific race or gender or age. In fact, and I'm trying to look at this thing again, I think, if anything, it was trying to promote, I just want to see on the advert, I think it would have, if it's talking to promoting, okay, it's not there, but I think
It's in the national instructions.
it should
I
be in
think
the
what
national
you are looking
instruction.
at is in the national
It should be in the national instruction. I've
Yeah.
seen it somewhere where, in fact, it's encouraging
It's encouraging that you promote females.
that female
and-
persons be considered.
It's in
to-
the
to be-
national instruction.
Indeed, Commissioner. But the fact that she was of a certain age, female, it's not
So
amongst
the
these.
point is simply this: if you meet the requirements and you are appointed to the role, it cannot be a fraud or corruption that you are given this rank of brigadier. It follows as a matter of course, once you have been offered this job and you have accepted it, that you will be given the rank of brigadier.
Indeed, Commissioner. And maybe to add on, the fact that she was competing with experienced colonels and members of the police who have been in the same environment doesn't mean if she performs better than them and she scored higher than them, then that means there's something wrong. We don't know what questions were asked, technical questions were asked, and she might have performed, or she performed. On paper, she performed better than them. Therefore, it doesn't.
Between you and me, and you would know because you are an advocate, there are 30-year-olds who sometimes perform better than me.
Indeed, Commissioner. Indeed.
And I'm sure you've been in matters where somebody a lot less experienced, less junior in terms of years, on the day performs better than you.
It happens. That's the nature of interviews, Commissioner. It's how prepared a person is for the interview. How much did they prepare and how you perform. A person can freeze on the day and another one performs better. It doesn't mean we were supposed to take the cadre because the advertisement was for both internal and external people. Therefore, the fact that a civilian was appointed, there's nothing wrong with that.
I think we can put 3 and 2 away now because we've covered file 2 and 3.
Indeed. So, thanks, Commissioner.
Advocate Srunya, just before we move to the next section on the charge sheet, just to understand, did anyone in the team then respond to your email of the 17th of August? Now, this is the one that was sent to the whole team.
Yes, I think I did get responses from either Mr. Brian Parayashi or one, I remember Mr. Pat Mlamba who would have said, thanks for the advice, we'll do as you raise. The issues that you're raising will follow up on those. And I think he said something along the lines that we're taking one on the chin, Prapita, but then I said, it's not like we're not fighting or anything. It's not in bad faith, but we have to be ready, prepare this matter for court. So yes, I did get a response from promising that investigations are going to be done as I was raising issues.
Okay. And then just to understand your approach in this regard, so at this point, you would have seen the docket, the complete docket. You would have also then given feedback to your team about matters for investigation. The investigators would have also then responded to you, in part not answering, in other respects trying to give you a better explanation. So you are now at a slightly better position. Ordinarily, when do you call it? When do you say, I've looked at the docket, I've given direction on investigations, I've received feedback, this is not getting better? When in the process do you call, assuming that this is an anomaly, ordinarily you wouldn't be here?
If the problem with this is, remember now, from the 16th of September, I'm no longer part of the case. I submitted a memo on 16th of September to recuse myself. So I didn't go all the way with it, but I know that some of these queries still remained, and I cannot say now what is the position with the docket. But if you're asking me if I was still part of the case, because I came afterwards, I raised these questions. I'm not getting positive answers. I raised questions again on the second trial note and maybe on the third. I wouldn't have proceeded with the trial of this matter when there's so much still outstanding. Otherwise, it's going to be an acquittal. You're not even going to jump the 174 stage. The defense was, in fact, I doubt even if we're going to start with it. The defense was going to query the charge sheet right from the onset, and I'm saying it somewhere, Section 85. They would have gone for the squashing of the charge sheet, as it was. If I succeed in that, and then I'm risking starting a trial which has so many gaps. Lead one or two witnesses. Once you close your case, and then there's an application for 174. There's no way that we would have succeeded with that. I wouldn't have proceeded with this trial, or started the trial, if all of these issues were still outstanding, if I was still the prosecutor.
Can I just ask, and again, part of it is to understand what processes were followed here and how that accords with the law. You probably would have heard when Ms. Johnson was testifying, there was a debate at some point or a discussion with her about how Section 2813 was used and its purpose. And the concern being that it appears it was used, it was abused, it was misused, basically. Now, I'm looking here at your email of August 17. Now, we know that by August 17, the matter was already in court because these people, so it seems to me in the way that I've understood your processes, and you can correct me if I'm wrong. At this point, 17 August, your 2813 process happened, and then it was followed by your 28-1A decision to investigate. So you've done your 2813, and you go to 28-1, and then there's a J50, and then people are now presented to court. By all appearances, or from what you're explaining, by that stage we must have completed our investigations. That's why we are in court. And yet, your email of August, your emails, in fact, let me say emails of August, they're still talking about investigating.
Yes.
And I'm looking at your page 53 in particular, the very last paragraph of that email of the 17th of August. Well, maybe before I do the last paragraph, you say that we should therefore not try to convince each other. Before the preceding paragraph, you say, once the alleged conduct committed does not meet the definitional elements of the offense, as I'm finding it to be in this case, that means no crime in brackets, you say corruption has been committed. So we know that at the 17th of August, you held that view and you expressed it. And then in the last paragraph then, you say, having said the above, I'm still of the view that if we investigate further and dig more, we are going to find the evidence of corruption of the generals by Mokwele and not vice versa. Our answer is in the bank statements, cell phone records, and computer data of the generals. There's no way that these people did not communicate prior to advertisement and during/after the interviews. If the generals gave Mokwele a job she did not deserve, it is for the particular reason, and we must find out this reason. Did she bribe them? And then you ask questions. You conclude what was the quid pro quo for the generals to act in the manner they did. Now, in this paragraph, firstly, what I have a difficulty in terms of how I've understood your processes is you are past section 2813 because there's been a decision.
True.
To investigate. You investigated, now you've charged. So you're now in the realm of court. And you, DDP, hold the view that as matters stand, we have nothing. And then in the last paragraph, you say, let's go search. And it seems to me that now what's going to happen with that last paragraph is to meet or satisfy a theory that has been formulated. We have nothing to work with, but our theory is these generals are corrupt. Let's go find something. And you can explain it. And if that's what's happening here, it seems to me that even on your own email, you are participating in an inverted process where what is the stage of things? You are in court. These people are appearing. Why are you saying we don't have a case, but I'm sure if we dig some more, we'll find something? That to me, on the face of it, is deeply problematic, but also your position, it's inconsistent with the position that you take earlier on where you say we don't have a case. And then you say, but I'm sure if we search, we'll find something. That's not like a typical fishing process. Can you just explain how to make sense of your contradictory positions and what I suggest is a fishing expedition that you're suggesting should happen. And it's not simply a fishing expedition, it is in fact an abuse of your investigative/prosecutorial powers.
Thanks, Commissioner. Commissioner, I came into the matter after arrests have been made. These emails, especially that paragraph, I'm still raising questions. I'm still saying, but why are these people arrested? I'm saying to them, investigate, dig some more, investigate, which I said shouldn't happen. We should investigate, finish our investigations. Once we satisfy that we have a good case, this is the prima facie case, then we go to court. In this case, it's vice versa. I'm coming in after the fact. I'm trying to rectify wrong things that have been done by saying, do your job, do what you ought to have done right from the onset. Looking for information is like investigate. I'm asking them, did you look into the cell phones? Did you look into the computers? Did you mirror image computers? So I'm playing that part which ought to have been done right from the beginning. And for me at the time, all this does not make sense. I'm still asking myself, how did this matter get to a point where it did? But do I have powers to say, there and there, we're cutting this off, or should I first satisfy myself that indeed there is no evidence, and then only then call it off? It's a pity we don't have some of the emails where I keep on saying, I'm going to write a report at the later stage to the ID, because I could see that this thing was started wrongly. So I'm not saying dig for something that is not there. I'm saying investigate. Digging for information is investigate. And if you find the quid pro quo, then that's your solution. That's your solution. But otherwise, there's no evidence of corruption here.
Let me ask you this. Was it, and I ask this, I'm not particularly familiar with the NPA Act, and the powers that it gives. Would you have had the authority, considering the Act, as DDPP? You may not have exercised the option if you had it, but is it one of the options that ordinarily are available or within your powers, where if you came in the way you did, you came in late, things had moved along, and you have formed the view that you express, where you say we don't have a case as matters stand, is it within your powers to say, let's stop and go back to the drawing board? I know you say people must go investigate, but I'm asking a bigger question, as in, you have people who are under bail conditions, who have been told they may not go to their offices anywhere in the country. You have people who are appearing in court, being postponed. So there's a disruption to some people's lives. Is it something within your powers that you could have come in and said, hold off, let's stop what we are doing, let's go back to basics and start from scratch, and we are not going to court, whatever we have in court, we are going to, I've heard of, it's not a withdrawal, it's something, removal from the roll, which is not a permanent withdrawal of a matter. Does that kind of power lie in your hands as something that you could have done here?
Yes, Commissioner, and that is why I was asking, we should remember this is maybe 9 days after I've become part of this is actually the second document that I'm writing to them to say, do the following. But like I earlier said to Advocate Bowe, if this had persisted up to a point, if I was still the prosecutor up to a point where the case, I would not have prosecuted this case. At some stage, I was going to call it off. Unfortunately enough, just a month after, I then got off the case. But I couldn't, just on a week or 2 weeks after getting into the case, and say, no, let's withdraw this. But it is after testing what was the basis of starting this whole thing, and I realized there's no evidence. There was no basis for this. I should have done that maybe after consulting with the ID, sit down with her and say, look, this is the position, this is the evidence, I've read this, these are queries I raised, they are still unanswered, there's no evidence. At some point, I was going to get to that point. That's what maybe one is in management for, to raise these issues with the...
So Advocate Manilal, who succeeded you in this position and who has overseen this matter after you recused yourself, and on the assumption that up to when Ms. Johnson was testifying, Advocate Manilal was responsible for this matter as the DDPP. What you're saying is he's got that power. He could at any point, after your many notes and his own observations, he actually does have the power to say, let's stop this, even if it means let's go and redo the work. But let's stop what we have put in motion. He has the statutory power to do that.
He does. Just like I have those powers. He does. But like I said earlier, I don't know at what stage he was appointed. And what I know is, with the evidence of the former ID 2 weeks ago, we got together, me and Manilal and Hlachwayo, and the two other prosecutors who were now part of this. And our decision was, based on what came out after the evidence of the ID, there's no way that this case can be saved or resuscitated. And we then asked for a meeting with one of the deputy directors, national deputy directors, we met with her and we said to her, we know now that the matters are seized with the NDPP, but this is our proposal. And I forgot her surname now. I think it's Advocate Bell. And I know that Manilal thereafter penned a memo to them based on those discussions with Advocate Bell, setting out our views. And then we were overtaken by events where I heard that the NDPP has decided that the cases must be provisionally withdrawn. Yes.
Thank you. Thank you, Ms. Bell.
Are you saying there was an independent review by IDEC, separate from the one by Advocate Mutibi's team?
There was by the old and the new team in IDEC. We did meet.
The IDEC team, separate
the
from,
IDEC team. Yes,
okay.
that's correct,
Yeah.
Commissioner.
No, you don't have to go into the details.
Yes.
I just wanted to be clear that
There was
it
a separate,
two separate
team,
processes.
my team and the team of Manilal. We met and we agreed that it appears we're flogging a dead horse.
And in that kind of decision, at that point, what is the role of the DPP? It's the DPP, I think, from the evidence of Ms. Johnson. She submitted the charge sheet to the DPP. DPP says, I agree with your decision to prosecute. There was that kind of discussion. When you get to this point where you are now reviewing and you finally express the view that this is a dead case, and we know how it has played out, the DPP's role is what there? Do they participate in that discussion? And
Commissioner, the DPP did not participate in that discussion because the DPP is sitting at the provincial office, DPP's office. We are a separate IDEC. I'm not sure if our communication, the memo that was penned down by Advocate Manilal after our discussion, which was forwarded to the NDPP, if the provincial DPP, Gauteng, has been copied, but the DPP was not part of these discussions.
thank you.
The DPP's role would have, I believe, ended when they were doing consultation with the ID, and because the ID wants to prosecute in the DPP's space, there must be that consultation, and I believe it happened in this case, and the DPP would have agreed, but the role of the DPP ended there.
And on the question of now, we are reviewing and we are, if it is a withdrawal, forgive my use of the word withdrawal, I don't use it in its technical sense, but where the decision is made to remove the matter from court, you're saying the DPP, as far as you know, doesn't get to play a role in that. And I ask because from the evidence, once the ID, and you know this better than me, once the ID has made the decision to prosecute or to prefer the charges, that charge sheet was sent to the DPP, and the DPP wrote back and said, yes, I concur, or something to that effect. So that's why I'm asking about, now that you're changing course, does the DPP get to look at this and say, yes, I agree that we really are bad, or they just hear from the client being IDEC?
Yeah. In this case, we did not involve the DPP commissioner, because from what we gathered, the matter was now already in the office of the NDPP. That is why we wrote directly to the NDPP asking for a meeting with them, and we were then allocated Advocate Bell to meet with us, and the discussions took place between us and Advocate Bell, who was representing the office of the NDPP. But I understand what Commissioner Balo is saying.
Yes.
Ideally, the DPP, in a way, ought to have been at least informed. That DPP, in 2025, May or June, we consulted you on this matter, and we informed you, we prosecuted you, you agreed with us, and we have since taken another decision. I want to believe that ought to have been done. But we went straight to the head office.
Yes. And the ID in that kind of situation that you end up finding yourselves, where you, Mr. Manilal, and somebody else are now looking again at this case, what is the role of the ID, if any?
Yeah. Commissioner should be remembered by that stage, that's when the ID was testifying. I think our meeting with the NDPP's office took place either on the Friday or the very first, or last week Monday, when we heard that the ID has resigned.
Okay.
I think that, yeah, so she was no longer, she couldn't take part in those, because in any event she was still testifying in the commission.
Oh, well, I guess my question still remains. Ordinarily, would the ID have to approve your decision, or this is a purely prosecutor's decision that are seized with the matter, and they make that decision?
No, if she was still there, she would have to approve it. We were supposed to sit with her, pitch it to her, show her reasons why, and once she gives that approval, then it can be done. No prosecutor can withdraw the case in the ID on my own, going to court and just withdraw. Even if something happens and I'm in court, say the court maybe is refusing me a postponement, I must let them know. I'm having these challenges. There's nothing I can do. The matter is struck off. But,
Okay.
but it must be authorized.
All right. Thank you.
Advocate Serenia, let's then go back to your statement. You are now dealing with the charge sheet and your efforts to amend that at paragraph 55.
Okay. At 55, yeah, like I said earlier, the charge sheet as it stood at the time, I became involved, did not, in my view, make sense. My principal difficulties with it were the following. First, the corruption counts inverted the giver and the receiver. One count charged accused number 7, Ms. Mokwele, with corruption on the basis that she had agreed or accepted the gratification in the form of an appointment. A further count charged the generals with corruption on the basis that they had given or agreed to give that same gratification, being the appointment, to her. On the ordinary structure of Section 4 of PRECA, the public officer is the party who accepts and the private person is the party who gives. Here, the pleading had the public officers giving employment to a civilian, which is the reverse of the concept, and critically did not identify any unlawful act which Ms. Mokwele was to perform in return. Secondly, a further corruption count appeared to be a repetition of the count against accused number 7 being directed against her in respect of the same gratification. Thirdly, the fraud counts gave rise to a contradiction. One count alleged that Ms. Mokwele had misrepresented in her curriculum vitae, whereas that its contents were true and correct when they were false. A further count alleged a like misrepresentation in her SAPS application form. And a further count alleged that the generals had misrepresented to SAPS and to the public that the selection process had been conducted in accordance with the applicable instruction. The difficulty is that these allegations cast the generals simultaneously as the victims of Ms. Mokwele's misrepresentation and as the perpetrators who had rigged the process in her favor. The same persons cannot be both victim of and the parties to the fraud. If, as the charge sheet alleged, the generals colluded to appoint her, they were not deceived by her. The conduct would not be fraud of that kind, but at most a conspiracy. It was for these reasons that I settled the amended charge sheet referred to above.
But would it not have been fraud against the state, not necessarily the generals?
Indeed, Commissioner,
Assuming that all things were equal, of course.
yes.
And based on the questions that my co-commissioners have put to you, it appears that that was not the case. That is, it was not the case of all things being equal.
Indeed, indeed.
But assuming that all things were equal, is it not so that the fraud would have been committed as against the state and not necessarily the generals?
Indeed, Commissioners, against the state as represented by its officials being the generals. So ideally there would have been witnesses then in the fraud case. My view that the matter was rushed was communicated, I'm reading from paragraph 60. My view that the matter was rushed was communicated to the ID on 25 August 2025. My views are set out in Annexure PS10.
Just one moment before we move on. At paragraph 59, you reference the amended charge sheet, and that's at page 54, PS6 of your annexures. And the charges that you had amended are at page 69 of that charge sheet. Just in relation to this charge sheet, was it ever, what came to be of it? Once you've drafted it and shared it with the team?
It was disclosed. Remember, we were under pressure now from the defense. They had asked for further particulars, asked for a copy of the charge sheet. They were never given a charge sheet, or at least the only charge sheet they had was the one that was used during the bail proceedings. So around September, they are now asking for a final charge sheet, and they were submitting a request for further particulars. So it was disclosed to the defense.
So this would have been the charge sheet that would have gone to trial, if it had? Or the closest, if barring another amendment?
True. If my queries had been answered, if I was the prosecutor, yes. But those who came after me, they have a right, as long as the accused has not pleaded, they have a right to ask for an amendment of the charge sheet. They can always change it. The only problem is if the trial has already started, the accused have pleaded and you have laid evidence. Once you have laid evidence, then you can, the least you can do is to ask for amendments on certain portions. But a prosecutor comes in, they can always, when they are not comfortable with their colleague's charge sheet, ask for the charge sheet to be replaced with a new one, based on their understanding of the case. So I was on PS10 where I penned an email to the ID informing her that my view is that this case was rushed, and that communication is on 25.
Sorry, can I just understand, at page 69, you say this is the amended charge sheet. It has only one count, if I'm reading it correctly.
Thank you. 69 of my affidavit.
Yes.
Yes, that is true, Commissioner.
Okay, because so this is a move from the charge which has 7 counts, because we've been discussing we've discussed with other witnesses, including Colonel Pareachi,
Yes.
on the basis of a charge sheet that has 7 counts. You're saying this is the amended one. This is
the
version
amendment.
2,
That is true, Commissioner.
and it is before the court, and it was disclosed to the parties.
It was disclosed to the
accused.
parties. Yes, to the accused.
Yeah. I see Ms. Powe wants to testify.
No, I don't want to testify. I suppose my confusion is that in the docket, this one isn't there. So we operated on the assumption that this was a proposed amended one, but that never saw it to pass. So this is the first time in testimony that we are learning that this is the one that was actually disclosed. And unless the team that came after produced another, this would have been the one, the operative one.
No, this charge sheet with its preamble starts at, I think it's at page 54. This is the charge sheet that I drafted. And at the time, it's only me and Advocate Hlachwayo the team, and otherwise if I involve the investigating officers on the Mokwele Khumalo charge. This was disclosed to the defense.
And you know
in
that
Sep-
you know that for a fact.
I know
this
that
this
for a
was
fact.
disclosed to the accused.
Indeed, I know that for a fact. In fact, I think I'm the one who sent the email to one of the attorneys who represent accused number 2, who represents Mr. Lushaba of this charge sheet, and thereafter it was then sent to the other attorneys.
Advocate Serunye, if you can just make that email correspondence available to us.
I'll do so.
Let me ask then about this one, that you say in that first paragraph, you set out what is supposed to have been done by the accused, and you say, acting in furtherance of a common purpose, did conspire with one another to give or offer to give gratification to accused 7, for the benefit of accused 7. I'm battling to understand, given your position, your correct position, I thought, that you have taken that, but the way that they are formulating the charges, they formulated the charges is they've inverted the position. It would have been for 7 to give gratification to these other officers, but you seem to have gone ahead anyway unless I don't understand this, you've gone ahead to formulate a charge that says they gave her gratification.
Yeah. Yes.
What?
Commissioner
And
Baloyi.
I'm not asking about the merits of this. I'm asking about, because you would have heard from evidence that, rather when we were engaging with Ms. Johnson, that there was a question of, but why was this done? This which looks so obviously wrong, why was it happening? Commissioner Khumalo went so far as to say there's a third, either he said there's a third hand or a hidden hand, it looks like, because things don't make sense. How this team of investigators and lawyers would do something so obviously wrong on the face of it, and that doesn't make sense. If I read paragraph 1 or understand it correctly, you're repeating that which you've criticized. You can correct me if I'm wrong, but you seem to have repeated that which you criticized by saying they granted gratification to Brigadier Mokwele. And I'm trying to understand, why would you craft a charge like that?
Yes. Okay.
If your position, as I understand it,
Yes.
was that is nonsense to charge her with gratification, or her or them with gratification.
Okay. True. Okay. Thanks, Commissioner. It's not a repetition of this section 4, which they were alleging, and which, in my statement, I'm saying is defective. I drafted this. It's pending the investigation outcome of what the investigation is going to uncover. But my logic in this is, and commissioners will see the misrepresentations that we are alleging on the alternative count of fraud. For example, if one looks at the misrepresentations, the first one on page 70, because I said conspiracy, section 21, they conspired, all 7 of them, alternatively fraud. Our understanding at the time is, if the evidence that we are alleging, that the application of accused number 7, Mokwele, was submitted late because we were going to call a witness who was going to say this application was received on the 26th. Yes, which the closing date is the 25th of April. Her application, it's date stamped the 26th. A witness would have said, it was received a day later. Therefore, without going into the other misrepresentations, if the panel members know and can see that this application has been received a day later after the closing date, why didn't they disqualify her? And by not disqualifying her, they acting in colluding with her, they're conspiring with her to commit what I can only sense at the time that she be given this position. That is how the conspiracy comes in, to say, if all of these representations that I'm alleging here, our understanding at the time that she had said, I'm a metal manager, if what we went through earlier with Commissioner Kumal, if all of those were then found to be true, that the last one, for example, of the representations, where accused 7 meets with one of the panel members, I think it's General Ngube, should be Ngube, a day before the interviews, accused number 7 meets with accused 6, Pindile Ngube, who helps her to apply for security vetting. They then use the Inkwazi system, which we are told is meant for service providers, because she couldn't be loaded onto the prescribed SAPS system, because at the time she did not have a personal number. That is only reserved for police officers. People are already on the system. Now, accused 7 and Ngube then decide, they register her on a thing. So that in itself, a day before the interviews, there is this collusion, and her advertisement, according to us, is received late. And according to us, she does not meet this managerial experience. Well, we can drop that now, but at the time, she was not. Therefore, if you look at all those things and you're asking, how could this panel of generals in the intelligence service not pick up all of those things? And even the fact that one of them was with the applicant a day before, the only thing that one could argue before a court was they were colluding with her to commit an offense under Section 21.
Yeah, I can see, without commenting on the merit of it, I can see how you would list all of those things under your alternative count of fraud. So that's not my issue. My issue is the preca, the main charge. And it gives me a sense that, and I'm seeing this amended charge sheet for the first time, keep that in mind, but it gives me a sense that you have that main charge under preca because you are forcing this case to be under IDEC. It has to be a preca offense. Even if we can't prove it, we lose, but at least we have the alternative. So instead of starting with your alternative, making it the main charge, which I suspect, it much more obviously raises the question, why is this an IDEC matter? You know, why if it's a fraud and you're listing HR matters, because it is HR matters, about meeting the requirements for the position, So I don't understand the preca decision, and with you in particular, because you hold a view about this, and then you go and formulate the main count in the way that it has been formulated. I don't think you believed it. Otherwise, you have to explain all the other notes that you've been writing and the questions that you've been asking about this. Yes. I don't think you believed that this case falls under preca. Then the question becomes, well, what compelled you to make? Was it to make the ID happy? Was it that you don't want to rock the boat because you were brought in when you did and you found things to be what they are? When you have expressed very strongly that we don't have that kind of case. Yeah. Can you just explain that? I appreciate that you you came in, tried to be the voice of reason. And maybe Ms. Ramsame and Ms. Tlachwayo, if she does ever appear, will come and tell us why were they not discussing these things with you once you raised them, and why did they not warn their bosses and their investigators? But you hold a view from the outset after you brought into this matter, and you're consistent about it. And then when you get the opportunity to amend the charge sheet, you could have used the alternative to be the main count. You would have a debate about, but is this an IDEC matter, which is not the debate we're having now.
Yes.
But why do you appear to force a PRECA count in this charge sheet?
Yes. Thanks, Commissioner. I was not forcing it, Commissioner. I was not trying to please them. I speak my mind out. Everybody knows that. I was saying investigations are still outstanding. Cover these things up. But if the little that you have in the docket is believed, if indeed Mukwile's application was received on the 26th, then she ought to have been disqualified, and she was not. And if she's not disqualified, then she's being favored. By whom? By the panel, because the panel seats, they have all those 76 applications, then people are disqualified one by one for not meeting the requirement. But why is this one, which is received a day late, gets to a point where she's shortlisted to top 5 and then to top 3? That if her application was received a day late, it's collusion with the panel members.
Why do you keep saying if, as if there was no evidence when you were drafting this charge?
No.
It was something that you still wanted to be established?
No, Commissioner, it was there. I'm talking about the receiving of the thing late. Her application is date stamped the 26th. I'm saying if I were in a court, addressing the court, and the court were to believe me. But again, the one thing that was not there, one of the issues that I raised in one of my emails was, go and obtain the affidavit of the secretary of the panel, because that's the only person who can talk to when was this application received. And that was done after I had left the case, but I'm told that affidavit is there and the person confirms that the application was received on the 26th. Therefore, she ought to have been disqualified. And that is why I'm saying, if the evidence were to be believed, and that her application was received a day later, she ought not to have made it to top 5 and to top 3 and ultimately to top 1. And that is why the collusion. Section 21 talks of conspiracy to commit the offense of PRECA. Section 4, which was drafted earlier, talks of a public officer being given a gratification by another person. Section 3 is a general offense of corruption, which can be committed by any person. Maybe if they had drafted their indictment in terms of Section 3, much as I was going to ask questions, but where's the evidence? Maybe I was not going to say your charge sheet is defective because it's putting things the other way around. The giver is said to be the receiver and vice versa, if they went for Section 3. But I was still going to ask the questions that I asked. Where's the evidence to prove your corruption? But if I'm going conspiracy because I'm looking at these pieces of evidence that the applicant meets with one of the panel members a day before. They try to put her in the vetting system. They can't do that because she does not have a personal number. They then register her in a system called Inkwazi, which is meant for service providers. What do I call that? Looking at the evidence. She's colluding with one of the panel members, at least Mube. If her application was received late by a day, it ought to have been disqualified. She's colluding with all of them. They conspired to commit corruption based on the evidence that was before me, and that charge made sense in that way.
How was an outsider like her supposed to be vetted then?
Sorry, Commissioner?
How was an outsider like her supposed to be vetted?
On the reading of these national instructions.
Sorry, because you said, for example, because she was not on PESAL,
Yes.
she couldn't use the vetting system used by those applicants who were internal within SAPS, that is. So how was she supposed to be vetted?
Only at the point where, if she had been appointed, the moment she's appointed after passing the interviews and she's appointed, then they give her about 6 months to do the vetting. In that 6 months, now she has a PERSAL number. She can be loaded onto the SAPS vetting system, and then she does the vetting, or she can do a private.
But continue.
Sorry, Komsa. She couldn't use the SAPS vetting system because that you can only do when you have a PERSAL system. Secondly, the use of the Inquasi system, it's fraudulent in itself because it's meant for service providers.
But do you include her in that? Is she supposed to know anything about Inquasi and whatever else if it's not Inquasi? Is she supposed to know that?
I don't think she would have known that, but now she meets with one of the panel members a day before the interviews and taken through this, and she submits an application, and her application is processed. And based on
That's exactly my question. Is she supposed to know that that ought not to have happened? Because if vetting is mentioned and all of this is taking place, and from where she was sitting, that was an attempt to satisfy the vetting requirement, or not?
That's true, Commissioner. I don't think for her as a civilian, she would have known even the difference between the SAPS vetting system and the Inquasi. But here's one of the panel members who's taken her through.
You see, my question does not relate to SAPS members.
Yeah.
It relates to her.
To her.
Should she have known anything about any of this? That's what my question is about.
I doubt that she would have known. But if we argue in the matter in court, it's something different. How did she know that she has to avail herself at the office of Ngube, where she has to be taken to the vetting office for the vetting to be done before the interviews are done? The interviews are going to be done the following day,
Okay.
and they can't do it.
Let's leave it there.
Advocate, you may not know this, but all the shortlisted candidates were given a letter to say they must make themselves available for the purposes of vetting. Yeah. So they were actually being disadvantaged because the advert said you must only do that 6 months after appointment. So whoever said to them, come and do it before the interview, was not benefiting them. They were actually disadvantaging the candidates. Because the advert, it's the one on 178
Yes.
file 2 that I took you to. When you do that, you're not benefiting the candidate. You are actually disadvantaging the candidate because you are subjecting them to a process that the requirements do not provide for. And it applied to, because it's that letter that General Khan even said, well,
True.
I don't know anything about this letter and all of those. But Commissioner Baloi's question remains. You said there is no Preka offense here because after gratification, or rather gratification must be given, and then you said in brackets or in inverted commas, in order to, and you said because the in order to is missing, you cannot sustain a charge under Preka. Now, Commissioner Baloi says, if that was your position, why do you then draft a charge sheet that still includes gratification? Because even if you go to Section 21, all Section 21 says is that you conspire to commit the Preka offenses. So it takes you back to the offenses, which means your gratification must still have that condition that it is in order to do something. So if they had conspired to give her gratification in order for her to do something in return, then that would have been fine. But as charge one stands now, the main count, that in order to part is not there. So why do you still have a gratification offense if the remaining elements of it are missing? Because you can't just say you have conspired to give somebody a gratification, full stop.
Yeah. I understand that, Commissioner. Maybe then, instead of Section 21, one should have raised the Rioters Assemblies Act, conspiracy in that old act. But I'm saying we're coming to the conclusion of conspiracy based on these pieces of evidence that things were not done properly. A person who ought to have been disqualified because the application was received late was not disqualified.
But that's the alternative charge. That's not the main charge. The main charge says you conspired to give a gratification, full stop.
True.
And Commissioner Baloy's point is, you've already said that gratification must be followed by something else. Yeah. So if your main charge does not have that something else, then it contradicts your memo where you said, absent that something else, there is no charge. I get your alternative where you say the alternative count has a potential of all these things.
Yeah.
But forget about the alternative for now. Look only at count one. What is the offense in count one?
Yes, I see that, Commissioner, and what you're raising is important in that there is that debate amongst colleagues that where we're referring to 21, does it take us back, like you rightfully said, does it take us back to, because 21 says any person who A, attempts, B, conspires with any other person, or C,
Look at the last part. Look at the last part.
Yeah, another, to commit an offense in terms of this act is guilty of an offense. To commit an offense in terms of this act.
So it takes you back to the offense.
It takes you back to the act, like you're rightfully saying, maybe a question of interpretation, but the intention at the time is, so on hindsight, when one says, yeah, but Sirunya, still your conspiracy does not fit in.
Yeah. Because look at count one. What is the offense in terms of this act in your count one on page 69? Because remember, it must be in order to commit an offense in terms of this act.
Yes.
Yeah, so what is the offense in terms of this act in your count one?
The act that has to be committed.
Yes, the offense.
Oh, it's contravention of Section 21.
No, but 21 says you commit an offense if you conspire to commit an offense in terms of this act. So it takes you back to offenses in terms of precca. Look at the last part of Section 21.
Yes, I see that, Commissioner, that last portion would then take you back to say if people conspire in terms of this act, they must conspire to commit an offense in terms of this act.
In terms of precca, yes.
Be Section 3, 4.
So where, in the charge, where is that offense?
Well, we didn't cite the offense because I couldn't go back to what I was criticizing. I can't say you conspired to commit Section 3 or 4, which according to me was non-existent.
And it's not as if you were not aware that there had to be this something else. Do you remember your very first query when you raised the many questions?
Yes.
You even said to do what? And then you have ... to show that you expect this something. You yourself, when you raise the queries, do you remember that particular query?
I do.
Did it not relate exactly to this?
It does.
It must have related exactly to this.
I concur. I concur with.
Did you suddenly forget now when you were couching the charge about your own query?
Yes. Commissioners, I agree, and I must say, there's an ongoing debate. Like I'm saying, now that it's being raised, I remember one of the discussions I had with colleagues in the office. We debated this, we argued about this a lot, and maybe I was for this side, and I can see now that, maybe.
Commissioner Baloyi says the reason you put it there as the main count is because you knew that if you started with the alternative count, then IDEC does not have, this does not fall within IDEC's mandate. So you had to put PRECA as the main charge to justify IDEC continuing to prosecute this case.
No, I respectfully disagree, because that will then question my motives, and I come in here with clean hands. I came in to rescue a situation. I've never, since I was involved in this case, involved myself in any shenanigans, and I stand here, I can say with a clean conscience,
You know,
I did my work to the best of my abilities.
A prominent South African once said, "My hands are clean," and we know what happened next.
I do, Commissioner, but for me, listening to the evidence, and like I said earlier, hearing what I've heard here, I wish, and as I was saying to somebody during lunch, I wish I could turn the hands of, back the hands of time, and I wouldn't have gone to court on that day, on the 27th, when there was a bail application on 27th of June, because here I am now, in the middle of something that I did not start. But what I can say is, I realized when I came in that this case was rushed to court. It was not ready. I raised those queries, and I wouldn't have prosecuted a case like this if it was not ready. It's a pity I recused myself before I could make that decision. Otherwise, I would have made it.
I have a generous explanation, attempted explaining what happened with your amended charge sheet. It is, you came in, you found a mess, and you tried to help fix it. And because you knew that they are going for gratification, because that's the more serious charge that would get people in court suspended, and you were trying to fix an unfixable. Is that?
I'll take that, Commissioner. I'll take that.
Thank you. Thank you, Mr.
And indeed, the several questions you ask do show that whatever impropriety there might have been, you were not party to that. Because if you were, you would not have raised the many questions that you raised, and doing so more than once.
I accept that, Commissioner. I quit it. I did not go along with something that was wrong, or at least something that I could see was not prepared thoroughly and ready for court.
Thank you.
And then, Advocate Serunye, in relation to your paragraph 60, which you read into the record prior to the engagement, just to note that you then sent an email to Advocate Johnson directly.
Yes.
On the 25th of August, and that's PS 10 at page 93.
I indeed, Council, I sent an email to the ID. If you look at page 93, PS 10, I sent an email at 11:44 on the 25th of August to Advocate Johnson, copied her PA, Ms. Sikukuni, and Mr. Matthew Sissoko, with subject State vs. Kumalo and others, and then I put an attachment. There's an attachment to that email, trial preparation document 3. I said to the ID, the Kumalo and others matter refers, attached, please find a copy of my trial preparation note 3 addressed to the team. My view is that the enrollment was rushed. However, there's a prima facie case of fraud, in bracket, not corruption, at least not on the available evidence. Still consistent with what I've been saying all along, in terms of the thing.
And then the attachment is at page 95, and you raise substantially the same issues and give directions about particular further investigations and affidavits that should be obtained in order to complete the investigation. Is that so?
That is indeed so, Commissioners.
And was there a response to this correspondence, particularly the email that you sent directly to Advocate Johnson?
I did not get any response to this email.
And did you know if she received it?
I sent it to her email, and this time copied her PA. I'm sure she got it.
And then
She did not respond. I don't have proof of that, but I sent it to her.
But you did not get a non-delivery report either.
No, I did not.
And then in an early engagement with Chair, you mentioned that whenever you are sending correspondence to Advocate Johnson where it's less urgent, you would do so through the PA. Yes. And an example of that would be on page 24, is that correct? Where you send an FYI to her PA.
That's correct.
And that then with this one where you make direct communication with the ID, are we to understand that it's because it was urgent and you wanted to draw these matters to her urgent attention?
Indeed so, and it was now the third document that I'm writing where I'm raising queries. So maybe in my mind, I was thinking, let me also send it directly to her in case she didn't get the others, but I know is very efficient. There's no way that she didn't, but this one I directed it directly to her and copied as well.
You've also copied Mr. Sisoko. Did he engage at all with this email and report? Sorry.
No, he did not. He did not respond to me about it. He did not say anything to me about it.
And then also prior to sending it to the ID, you had sent it to the team. Did you receive a response in that regard?
I sent it to the team. I would have received one of those emails ensuring me that, okay, no, we'll cover the issues that you're raising. I'm sure I must have received, especially from Brian. Brian is one of those people, when you send an email, he does respond.
All right, thank you.
Mr. Parayashi, I must say, sorry.
Then you move on to deal with the...
Sorry, Council, you'll see in that preparation trial note to the ID, if you look at paragraph 16 or point 16, that's where I'm raising the issue of an HR expert. That an HR expert must be appointed to analyze the scoring of the three candidates and provide a report on whether the scoring of the three candidates was fair and or in accordance with the prescribed manner set out in paragraph 6, in brackets evaluation process of the National Instruction 3 of 2005. Okay.
Yes.
Also to point out that in paragraph 5, you say, after receiving input from colleagues and doing further reading on the corruption subject, my initial view still stands. And this initial view you're referring to is that there's no case for corruption.
Is that there's no case of corruption? Indeed, Commissioner.
Okay, thank you.
All right. Advocate Seruni, then we can deal with the procedural irregularities that you questioned. You have dealt with the issue of the charge sheet, and the other thing that you dealt with was paragraph 62, which deals with the referral and your multiple attempts to get a copy of the referral, and that your latest one was done when one of the accused persons requested disclosures or further particulars. And there you referred us to Annexure 10.1. Can you then take it? No, I also think you've actually explained the meeting that was called by Advocate Johnson on the 1st of September, wherein she, I guess, questioned why you're not trusting her investigators and that she herself had seen the 27, and so you should proceed with your work. That's correct.
Indeed, that's correct, Commissioners.
Then I think we can take it from paragraph 64, where you deal with when you were eventually shown the section 27.
Okay. Yeah, just in passing, PS 10.1 is an email which I sent to Mr. Sissoko where I was asking about the 27. We're now in 31 October 2025. If I go back to my affidavit, paragraph 64, some days later, that will be now after the 31st of October, following a management meeting, the chief investigator, Mr. Daniel Perumal, informed me that he had the Section 27 referral and showed me a document in his office. He showed me the document whilst holding it. It was as if he wanted me to see its existence, but not its contents. If I can
what exactly do you mean by that? It was as if you wanted me to see its existence, but not the contents. How did you hold the document? Did you get to read the document? And based on what you are going to say shortly after this sentence, it seems to me that you actually did read the document, because you even estimate the number of pages, and you also suggest that you actually saw the content, because you say it resembled the complainant's statement and basically contained nothing. So you actually read it. So it's in that context that I say I don't understand when you say it was as if you wanted me to see its existence, but not the contents. We know that you actually saw the contents. So what do you mean by this sentence?
Thanks.
Or at least I assume that you saw the contents based on what you say about the number of pages, and also the fact that according to you, this document said nothing.
Thanks, Chair. Yes. If I can demonstrate, we got into his office. I'm seated on the other side of the table, and he's sitting here. He pulled up the statement, and he didn't give it to me to read. He was holding it like closest to him. I had to bend over and read. I think he thought when I see Section 20, because it had a heading, Section 27 referral. I think the names of the person, Fadel Adams. You know, when a person is holding a document like this for you to, but I read it. I read and I could see as I'm reading through that this affidavit, it's similar to the other affidavit of Mr. Adams, which is, there was nothing that stood out for me in that affidavit that.
Did he page it as you were looking at it?
Yes, we paged it through. I paged it. I even went to.
Who paged it? Him or you?
I think I did. I was paging, even though I was still. Then I paged it through, read through.
I thought you were saying he was holding it.
Yes, he was. He was. It's like holding it. Sort of. I can't take it, but I could page through, and read, and. I even saw at the last page where the deponent had signed and the commissioner of oath had signed. I could see one of them signed it in Cape Town. I think it was the deponent. But then it had a stamp, IDEC stamp of Pretoria. I can't remember who commissioned it, but I could see it was commissioned. And that is what, when I left that office, I said to Advocate Latrayo, I finally saw this elusive Section 27. I've read it, but there's nothing, I thought when this report or this affidavit is not given to, at least to me, because I was asking, there's things in there that people didn't want me to see. But when I read it, I thought, it's just the same as the statement of the complaint. There's nothing to me really.
So if he let you page the document, how is it that you say he wanted you to see its existence but not the contents? Because he could only have allowed you to page through the document if he had no problem with you seeing and reading its contents. So I don't quite get what you are saying.
Yeah. I got a sense that he was rushing me. He thought I wanted to, because I've been asking about the 27. He thought I'll just look at, there, it exists, and then leave. But then I wanted to read the contents of this and see what this affidavit was about.
I may be belaboring the point, but if you go to page 19, you even say, on perusing it.
Yes.
Lawyers usually use peruse when they mean that they read a document thoroughly. And you refer to perusing, and yet to suggest that you were almost not given an opportunity to read the document.
No, Chair, I read the document. I read it up to the last page because I wanted to see what was in this affidavit that I've been asking for since August, and no one is giving it to me. But when I finished reading it, I couldn't understand why this thing was being hidden away from me, at least, or from the team, because it was just a normal statement by Mr. Fadel Adams, which was very similar to the one which was in the docket, where he's saying he got the documents underneath the door, and making complaints about a lot of issues that were happening in the intelligence office.
All right, I interrupted you when you were about to read, right at the foot of the page, the last line. He retained the document in his hand.
Yes, last line of that page, he
Page
retained...
page 18.
Yes, he retained the document in his hand, and I was not given a copy. The document comprised only of some 2 or 3 pages. It could be more. I don't remember because it's almost a year ago, and appeared to be a repetition of the complainant's statement containing nothing of substance. On perusing it, I observed what appeared to me to be an inconsistency in the commissioning of the document, in that the place at which it appeared to have been signed did not accord with the place at which it appears to have been commissioned. Like I said earlier, the deponent appeared to have signed the statement in Cape Town, but then there was a Pretoria stamp of IDEC, and then the commissioner of oath would have signed there. And then I raised my concern with Advocate Latwayo immediately afterwards. I told her that she was going to have a problem with the Section 27 referral, because at the time I was under the impression that it was signed by the deponent at one place and commissioned by the Commissioner of Oath in another place,
Advocate Serunye,
based on the stamp.
is Mr. Perumal your junior at IDEC?
No, he's not. In terms of the structure,
Yeah.
He comes after us as deputies.
So you are the DDPP assigned to the case, and you know that the Section 27 is missing. You know that the prosecutor assigned to the case, Ms. Latwayo, has not seen the Section 27. For the first time, Mr. Perumal says to you, it exists, here it is, and you do not insist on getting a copy of it so that you can discuss it with Ms. Latwayo, so that she is empowered when she continues with the prosecution of the case. I just don't get that. I mean, what were you scared of? Was there a reason why you didn't tell him that, listen, I want that document, give it to me now?
Commissioner Kubano, I did not think of making a copy because when I read the statement, there was nothing substantial for me. It was just like the other statements I've seen. So I thought at the time, why were they dilly-dallying from giving me this? Because there's nothing really in this. But we have a very good relationship with Mr. Perumal. I've worked with him many years ago in Kimberley. We did a case together there. So for me and him, he calls me brother. I call him Tony. So I was not scared of him. If I wanted a copy, I would have told him, Tony, please make me a copy of that.
And give Advocate Latwayo a copy, because we are at discovery stage. the accused are asking for the docket, they are entitled to this document, it should be available. You were formulating draft charge sheets or amended charge sheets, and you were at a stage where you knew that the accused would be asking for discovery. You were at a stage where you are raising a concern with Advocate Hlatsha. You're saying she's going to have a problem with the Section 27 referral. Why do you not insist that it be made available to her if you know that she must look at it because there are serious issues with it?
Because, Commissioners, as I said earlier, there was a meeting where the ID called me and the two prosecutors, and I was told to back off from demanding this Section 27. The ID says, I've seen it. Are you not believing my investigators? So I was not going to ask for a copy of that because I got clear instructions. Stay away from this, just do your job and leave the...
So you were scared of the ID. That's why you did not insist that it be made available to the prosecutor.
If one, I cannot dispute that. I didn't want to upset her. She was clear. I have seen the 27. I'm satisfied that it exists. Leave this matter alone. I hear that you've been asking a lot about it. Leave this thing off. So when Mr. Perumal showed it to me that day, we were coming from a meeting, and I did not even demand a copy because I knew I don't have to deal with this document, but at least I've seen it. And again, remember, I was no longer part of the case, in fact, by then. This is now in October. I've since been recused in 16 September. So, but I related the message to Joy. And the other thing is, we were told now, when I was still part of the case, when we're getting requests for further particulars, an email which I have to provide to counsel. One of the, I think that's the attorney for accused number 2, they wanted a copy of this. They said, how did you get this referral? Was it by 28, 27? We want a copy of it as part of the request for further particulars. But we were told the 27 shouldn't be disclosed. The ID said it's an internal document, it shouldn't be disclosed to the defense. And I think that is what we said to them, even in our answer response to request for further particulars. That we can't give it to you, it's an internal document based on what we've been told. But if you look at it, there was no reason really to hide this document. It was just the same as the other statements.
Can I take you to the affidavit we have on record? If you can just have a look at it's file 2, page 512. If you can just look through that one to confirm if that's the affidavit you saw.
Yeah, can you repeat that, please, Counsel?
If you can just look through this affidavit, just to confirm if this is the one that you saw.
In most parts, yes, it appears. I'm looking for. No, it's not.
The only marker
The one
I
that
can
I
see.
the one that I saw,
Okay.
like I said, on the last page, the deponent had signed it. It was clear he had signed it in Cape Town, and the Commissioner of Oath had signed, but there was an IDEC stamp next to it, which was a Pretoria stamp, which is what I couldn't understand. Where was this affidavit commission. So the one I'm looking at now seems to have been commissioned in Cape Town by one.
Maybe to assist you,
Felicia Solomons.
maybe to assist you, I was going to suggest that you're making a mistake, it sounds like, because the one you are referring to, which is signed in Cape Town and deposed in Pretoria, that's an A1 statement.
Yes.
It's not a 27 referral.
That is the one that was shown to me.
Okay.
And it's dated, I think, the 6th of January,
Yes.
2025.
That's the
So-
Pretoria.
The Pretoria,
one.
Cape Town one.
Indeed, Commissioners. That is what was shown to me. It is not this one. And even though it's almost a year ago, the one that I read, I don't remember this paragraph 5, which talks of Minister Bekele. There was no reference to that in the affidavit that I read. I don't think there was reference to that in the affidavit that I read.
Please go
Otherwise-
to file 3, page 683.
In that case, and whilst you are looking, aren't you mistaken when you say that the affidavit that you saw, which had Cape Town and Pretoria, had Section 27 on it? Because on what we have been shown, the affidavit that had Cape Town and Pretoria is dated 6 January 2025, and I think between the tram lines it just says affidavit, with no reference to Section 27. Are you perhaps not mistaken?
I probably make a mistake where I'm saying the heading was Section 27, but it had the names of Fidel Adams, and I'm looking at the one on file 3 now. It
Look at-
appears to be the one that I was shown. That is why even in my affidavit I'm saying it was about 2 or 3 pages, and it had this IDEX stamp on it.
Go to 684, that Pretoria, Cape Town anomaly.
Page 684, I'm
Yeah.
at 684.
Is that what you saw, just
This
below
is what I
Mr.
saw,
Adams's name?
Commissioner Kumar. This is what I saw on the day.
Do you see it says dated and signed to at Pretoria on 6 January 2025? And then it says, in my presence in Cape Town.
Exactly.
Is this what you were shown?
That this is the one that I saw, that Perumal showed me.
But then this is not the Section 27 affidavit that started the whole thing.
Then he showed, this is what I was shown. And that is why I'm saying, after reading what was shown to me, I did not make anything of it because it was not saying much. It was like a 2-3 page statement, which really didn't say much. And I was amazed why has it not been shown to me all along? Because it's not containing, sensitive information that I was not supposed to see or anything. If they've given me this all along, I would have stopped asking for it.
If Mr. Perumal showed you this document and said to you it's a Section 27 referral, he misled you because that this is not the referral. This is a statement that was taken and marked A1 by him.
He would have misled me, Commissioner. That is what I'm saying. After reading what he showed me, it was like I was reading one of the affidavits of Mr. Adams, which I saw in the document. It was similar. So when one says, oh, here's that 27 you've been looking for, I hear you've been asking questions about this. So that maybe I should stop asking questions.
Yeah, I guess the going back to the question that Commissioner Kumalo asked, that you are the DDPP at this point, because at paragraph 63 and 64, you do say that it's after the meeting of the 1st of September, and some days later, you following a meeting, you went to Perumal and said he had the Section 27 and he told you, and he showed it to you. So at this point, it seems like you're still involved with the matter. Because remember, at 63, you say it's on the 1st of September that the ID said to you, why are you asking about the Section 27? And then in 64, you say some days later, I went and I spoke to Perumal. So it suggests you were still involved in the matter, which then the question remains that if at that point you're still involved with the matter, because you're not giving us a date, you just say a few days later, unless you are exact about when you were accused, and then we are able to see that, okay, in September he was not longer involved with the matter. The question remains that as the DDPP, Mr. Perumal is not your superior. You are responsible for this matter. You're going to be making discovery to the accused. You need to prepare how it is that he trumps your request to have the document, because there's a reason you want this document. At the very least, it is so that you can make full disclosure to the accused, but for your prep. So how is it and why does he have the final say when you are now with him? Forget that this is not the 27 that he misled you. Let's assume it was the 27. How do you land at where he makes the final decision effectively that now you're not getting this copy that I have? And why is that okay with you, who is senior to him and in a different function?
Yeah.
Why does it end there?
The only thing I can think of, Commissioner Baloyi, is that he he had the support of the ID. He probably knows that the ID had told me on the first that I must stop asking about questions about this 27 and just continue doing my work. So that is why maybe he's also just showing it to me and not giving me a copy, because he knows that I've been told not to ask questions about it. And because I was following on what the ID would have said to me, that is why maybe I also did not insist on getting a copy. And the other thing the ID said to us, the 27s are not given to the defense. So when we were going to answer requests of further particulars, we're not going to give copies to the defense. The instructions were these are internal documents and they shouldn't be disclosed.
But you knew she's wrong. It's not an internal document. It's a Mr. Fadil Adams document. So it comes from outside into the IDEC. It is what gets a docket opened in the first place, because without it, you would not have opened a docket. So I expect that the prosecutors would know that, but she can't be right, that it's an internal document. She can't be right that it's not to be disclosed. Is that a fair proposition to make? That the prosecutors must know she's wrong?
Yes, but again, Commissioner Baloyi, I couldn't say to my boss, you are wrong. I'm going to disclose it anyway against your instruction. You
may for your reasons that you give not contradict her, but the fact is, as a matter of process, it means there's no full disclosure.
There isn't.
To the accused, and that has consequences. It could be any other document. From where I'm sitting, that if on something like this you have a head who says, no, we're not disclosing that, it's an internal document, and everybody around her knows that what she's saying is not correct, but they comply, then it doesn't give faith that on any other matter, if she says that we are not disclosing, that her prosecutors will not say, well, if I must lose my job, I'm going to lose my job, but my integrity and my responsibility to my profession and to the court is that I make disclosure. That has a sense of discomfort about it. And either she was particularly powerful And so nobody dared to say, but that's breaking the law when we do that. Or she works with prosecutors who are okay to look the other way, which is deeply problematic. And I don't know which is worse. But that's a sense that, that a sense of discomfort
I understand that.
that all of this creates.
I understand that, Commissioners. Yeah, it's difficult to be in a position where I was at the time. I couldn't, I didn't have the guts to say to my boss, you are wrong, I'm going to disclose this, whether you approve it or not. I know there's going to be consequences. Can be disciplined, that can be charged, and so on. Especially that we have signed non-disclosure forms. So it was going to be, you disclose a document which we have told is an internal document, and therefore you're facing up to 15 years imprisonment for this. So it was that. But if you didn't say to me, don't disclose it, it was going to be part of the disclosure. But we were told categorically clear, it's an internal document, you don't disclose it. And it is on those bases that I wouldn't have gone against it.
All right, I've heard your answer, thank you.
Another process-related issue. A witness, I think it was Ms. Ramsamy, said that the Section 27 referral affidavit becomes the A1 statement, but that you may supplement it should that become necessary. Is that your understanding as well?
Chair, that is my understanding, because the Section 27, when it's sent by a complainant, that forms the basis. That's the first document that we receive that says, I've seen or I suspect that such and such an offense has been committed, maybe provide evidence to that, documents, invoices, and that's the first document that we have when we're opening an inquiry file, as we building up our case and investigating. Now, if it's not sufficient, we'll go back and obtain further statements. But now, when it comes to the disclosure stage, why should we then give to the defense all of these other documents, but not this one, which was the basis of why we started this investigation? I would understand if it contains sensitive information on informers and how government operates, like the court says when we're doing normal disclosure. But if it's a statement like this one of Mr. Adams, I don't understand why it had to be kept away from the defense. Because it is a complainant statement. It forms part of basically the inquiry file, and later when a docket is open, it should form part of the docket and be disclosed, like all the other documents.
And also not just as a matter of process, it actually makes practical sense that it should be out there for all those involved in the investigation to see.
Yes.
Why? Because it is the source document for the investigation. Why it should be kept by whoever secretly simply doesn't make sense whatsoever.
Indeed, it doesn't. It didn't make sense even at the time, and I think maybe going forward, this is what, and I know some of the colleagues are listening to this. This is how these are debates we must have in the office. This is, if we have to beef up our manual, we have to do that to be clear on these issues. And if at the end of this commission, if according to your powers, commissioners, you're going to make recommendations, maybe that will also come up in your recommendations on this 27. But it forms part of the inquiry file. It forms part of the docket, and it must be disclosed.
Thank you.
Just to complete the picture, the Section 27 that you were shown, the one that we find in File 2, we know that on the 9th of October 2025, it did not exist because in File 10 on page 402, you don't need to go there. There was a scramble at IDEC offices because people were looking for the Section 27. And Ms. Ramsemi was asked about it, and Mr. Perumal inquired about it. Nobody knew where it was. And they thought she had it, she had kept it since December the previous year. Even when Advocate Johnson went to the ad hoc committee in October or November last year, she could not produce it. She raised various issues, but the simple point is on the 9th of October 2025, Mr. Perumal did not know where the Section 27 was, and everybody in the office was looking for it. And they actually thought it is missing or it has been destroyed.
Yeah. Yes.
There's in fact now controversy about what is the Section 27 affidavit that started this investigation. You have followed that evidence, so more the reason why you would expect, and I hope for my part that those who are listening, your colleagues, they understand from this evidence that we've set through why it's important for the lead prosecutor to have sight of that Section 27.
That's true. I agree, commissioners. I agree. It is very important. And I do not know about the other issue where the document was searched for because the ID had to report at ad hoc. But what I can say, during that period of October 2025, I was also looking for it. And as I've shown through the email that I've sent to Mr. Sok on the 31st of October, I was still asking questions about the existence of this document. So when Perumal showed me the document, it must be after 31 October, because by 31 October, as it appears on PS10, my email to, no, it's not PS10, PS 10.1, my email to Mr. Sisoko on the 31 of October, I'm asking that, do we have a Section 27 referral in this matter? And if so, where do we get a copy of it? And yeah.
Maybe what's confusing about your statement is that paragraph 63, you talk about the 1st of September, and then you say some days after the management meeting. And that seems like you're saying second week of September. But in fact, when you go to your annexure 10.1, it's the 31st of October when you are asking if we have the 27 referral.
Yeah.
So maybe your statement is incorrect where you say some days after the managed meeting, because it looks like it's a month or two after.
It's actually about 2 months after.
2 months after.
Yes.
So maybe we should correct your statement, paragraph 64, to say, or know about the 31st of October 2025.
I'll be glad if that is corrected, Commissioner, so that I don't create a confusion. But obviously, if one looks at the date sequence, it should have been at least on the 31st of October or thereafter.
Or know about.
Yes, or not about. So it couldn't have been, yes. So if paragraph 64, the first line reflects that, to say, my meeting with Chief Perumal happened on or about 31 October, or at least after 31 October.
Advocate Serunye, then you were at paragraph 65.
Yes. At 65, for the reasons already given, it was my view that the arrests were premature and that the matter had been brought to court before the investigation was complete. The verification of Ms. Mokwele's qualifications, the analysis of financial and communication records, and the assessment of the appointment process were all matters that ought to have preceded and not followed the arrest, I'm saying. I then get to the Lushaba matter at paragraph 66.
My apologies,
Sorry.
Advocate Serunye. Chair, may I ask for a short adjournment? I've been sent a note to request a shorter comfort break.
We'll hear from you when we're ready. Let's adjourn.
I'm finishing.
Yes, Ms. Bowe.
Thank you, Chair. At this stage, I've stopped being optimistic, so we are now at the second last subject, which is the Lushaba matter. Advocate Serunye, if you can proceed from paragraph 66.
Thanks very much, Councillor. Under the heading Lushaba matter, on paragraph 66, as set out above, on 8 August 2025, I was also asked to oversee the Lushaba matter, in which Advocate Ramsemi was the lead prosecutor. Having considered the docket, I was of the view that it disclosed no case. In particular, I did not understand why the complainant, General Lushaba, who on the face of the docket was the victim, had been charged. As I understood the matter, it concerned the complainant who had been drugged and robbed after encountering a sex worker, and who then found himself charged. On the material in the docket, there was nothing to sustain a charge against him, and I regarded the matter as untenable. I reported my concerns of views to the team and to the ID, as can be seen on annexures PS 11, 12, and 13. In response to my concerns raised in annexure PS 11 to 13,
Perhaps before you get to the response to the concerns, maybe if you could turn to the annexures, PS 11, which is at page 102, is when you recorded to colleagues asking them who are the suspects and what exactly they had done. You see that?
I do, Commissioner.
And you were also inquiring about whether the charge sheet was ready, and you required the prosecutors to prepare a presentation so that you can then meet and discuss the case.
Indeed.
A much more detailed, that comes after. Then PS 12.
Yes. Maybe before you go to PS 12, Council, the last sentence on that PS 11, I'm then saying to them, I'm going to request Mr. Sissoko to also attend so that he can give feedback to the ID about my views. And I wanted him to be part of the meeting, and I can confirm the meeting was then held.
And Mr. Sissoko was present.
He was present, Commissioner.
Putting aside your characterization of the case and your view that General Lushaba was in fact the victim, please tell us what the charge was and what allegations it was based on.
Yes. Chair, if I remember, he was charged, among others, with defeating the ends of justice. He was charged for fraud, but all that emanated from the fact that he had lost his items. I think his laptop, his wallet, which had his bank cards and a police card, after being dropped off by one of his friends at his home with a certain lady. And it appears the following morning when Mr. Lushaba approaches his friend, and he asked his friend, "Where is my motor vehicle? What happened yesterday?" The friend made a statement. He says, "I could see that there's something wrong with this man because I dropped him off. I drove off with his car. Now he's asking me about his car. He looked disorientated and all that." And that's when they went back to the house and they realized that items were missing. In the docket, there's I think I picked up on the C-clip of the docket on the diary that Lushaba and his friend went to the house opposite his, because there were cameras and they could see this lady jumping over the fence in the middle of the night, having some items. And I see him as a victim in that sense, that he has been drugged and robbed, his items were stolen. And the items were then recovered after intelligence agency, the counterintelligence agency was activated. Fortunately enough, the very same morning, somebody picked them up, apparently called the police officer. Lushaba was then called to the police station and then given these items after he had positively identified them. But the charge sheet says the process of giving him the items was wrong. They should have been sent for forensic analysis of fingerprints and many other things, and therefore that he was a suspect in that sense, together with two 2 or 3 of his colleagues, I think, that he was charged with. I couldn't understand what that charge was, and I think somewhere in one of my emails I'm making that clear that I'm seeing this for the first time in my career.
Was the charge not about an alleged falsified report with regard to what had happened with his, or in connection with his devices?
There were allegations that a statement, that Lushaba's original statement was missing from the docket, and that the statement which was part of the docket was actually made after the fact. But it didn't really make sense. Why would he do that? It's clear he was robbed, and he had reported it how the theft happened. He was not hiding the fact that he had a visitor in the house. Why would he then make a statement, then withdraw it and file another one? All that, really, I felt, I don't understand this type of charges. And I wrote that down. I think I have one of the emails where I was saying, what has this man done? What is the crime that this man committed that warrants him being charged for fraud and defeating the ends of justice when he's actually a victim of what appeared to be a syndicate? Because it comes out from the investigation that this lady and a group of people were doing those kind of things in the local places in around Pretoria, where they were dragging victims and robbing them. It appears the very same lady had a warrant of arrest issued for her in one of the courts for doing the same thing to one of the victims. And you can see General Lushaba's bank card being used the following morning after he had lost it. So somebody was buying liquor all over using the card. So I found it difficult how this man who had lost his items should suddenly then be charged. And it is on that basis that I said in the meeting with Mr. Soko, this one, this is not the case. I don't know how everybody arrives at this. And I then repeated it, and I sent an email to the colleagues, also on PS12, where my wording is a bit strong there, where after the greetings and I'm saying, I first want to hear the prosecutor's presentations. Maybe there's something I'm missing, but my preliminary view is that, if anything, this is a district court matter, defeating the ends of justice, against whoever is alleged to have removed Lushaba's initial complaint and statement in the docket. Thereafter, I'm going to prepare a report setting out my views for the ID's consideration. The magistrate was not even supposed to have authorized the J50 a warrant of arrest for Mr. Lushaba, because the application for same does not even disclose an offense. It's like one is reading heads of arguments, where Brian Barayashi also quotes case law in an application for a warrant. I was seeing that for the first time. I'm closing it by saying I've never seen anything like this, but I'll prepare a report in due course.
Thank you, thank you.
One of the issues here is that the complaint to IDEC actually related to the cover-up. So Mr. Adams was saying there was a cover-up and the lady was actually paid for her silence or to return the things or something like that. What IDEC then did is they went to the underlying docket and they started investigating the docket instead of the complaint that there's a cover-up by crime intelligence. And that's where this whole thing went a bit south.
No, it can't be, Commissioner, because there's a statement in that docket from a police officer, neutral police officer, who says that is the morning following the theft at Lushaba's place, he was contacted by a person. He names that person in the statement. This person says, I've picked up some items next to the garage. And because he knows the police officer is staying nearby, he took those items to the police officer, and this police officer activated crime intelligence because he could see from the card that this is a member's wallet, and this member appears to be a member of CI. and the items were then taken to the police station. And that's how, about a cover-up, there's nothing in the docket about that. The only allegation is that it appears the original affidavit that Lushaba made was removed. But when I read that docket, I don't see anything of that sort. I don't understand why Lushaba would complain and then cause his statement to be removed and be replaced by another statement, which is talking almost the same issues that relates to the robbery at his place.
What we've also heard about this is that General Kumalo is charged in respect of this because he did not discipline. He was part of a cover-up. He did not discipline General Lushaba.
Okay. Commissioner Baloyi, in the docket that I read, the accused are Mr. Lushaba and two other crime intelligence officers, but not Mr. Kumalo. I'm not sure if there's a separate docket of Mr. Kumalo, but I don't know about that. I don't know about that.
Thank you.
Is the charge sheet you're referring to at page 110, where it is General Lushaba and 3 others who are charged?
Oh, yes. At one, yes, that is the charge sheet of this docket I'm referring to.
Okay.
Lushaba and Mr. Mukhashwa, Glenn Hudson, and one Eugene Pidote.
Okay.
These are the accused. And Pidote and Hudson, I think, are members of crime intelligence. Mukhashwa is a police officer at the station. The allegation was that how could he have commissioned Lushaba's affidavit because apparently on that morning he had knocked off. So our investigators could not understand how he would have commissioned Lushaba's affidavit. So I think it is on that basis where they were saying this can't be the original affidavit because Mukhashwa knocked off in the early hours of that morning, 6 o'clock that morning, and he could not have commissioned that affidavit. But
We know that General Lushaba was arrested, is being charged. These other 3, were they also arrested? Do you remember?
Speaking under correction, I think they were a commissioner because I think they were on bail. I remember in one of the appearances, when the matter was postponed, the warning from the magistrate would have been, yes, your bail is extended and on the same condition. I think they were arrested as well, but they were out on bail at the time. I think this case, or the arrest of this case, happened before the General Kumalo and others' arrest. This one came first.
In the series of correspondence noting your concern, this would be the 3rd, that's PS 13, which starts at page 105. And you'll see there you addressed 2 emails, the first being to the team, wherein you note that on the 28th of August you would have had a meeting. And this is the meeting that you referenced earlier where Mr. Sissoko was also in attendance.
Indeed, Commissioner.
And you indicated that even after that discussion, you still were of the view that you do not have a prima facie or a winnable case, and that you'll provide a written report. I see also that this email was also then sent to Ino for the ID's attention. That's at the top.
That is true, Katsal. On the same day, 29 August, on the same day that I sent the email to the team at 7 o'clock in the evening, I sent it 4 minutes after that. I then sent it to Ino with a message, hi Ino, for the IED's attention. And you'll see I was dissecting each and every one of those counts, starting from count 1, showing what I'm picking up on those and up to the last count. Some of them were repetitions. The counts were repetitions of, on other counts it will be a duplication. One person will be charged and then the other one be charged. It was really badly crafted and not supported by evidence, most importantly.
I see that you noted about no, exactly 73 points in relation to the 10 counts. Is it possible for you to give a summary of the key issues that you were raising?
At the most, it was questioning the charges themselves, that the elements of the charges are like, for example, if you look under count 8, at paragraph 55, I'm asking, is count 8 not a duplicate of count 6? Why was count 8 not cited as an alternative? Same thing, count 9 is a duplicate of count 7. Count 10 is a duplicate of count 5. So it was a repetition of issues where it related to duplicate counts. And the evidence itself, for me, it was not, at the least, showing any prima facie case. And that is why in the email itself, I'm saying to them, I think around line 6, thanks for the fruitful and robust discussions in the meeting. I went back home last night, read the docket again, and considered all the views and submissions of the individual team members. I'm sorry to say that I'm still of the view that we do not have a prima facie or winnable case. I'll provide my written report to the ID, Mr. Sissoko, and the team in due course.
And did you provide a report in this regard to the ID and Mr. Sissoko?
Yeah, I did not, commissioners. That's what I'm saying. I was overtaken by, everything was overtaken by events here where this is 29 August, and by 16 September, I then ceased to be part of the case. I did not write the report, but at least the emails I sent them to the ID.
And did the IDs respond, or even any of your colleagues?
No, the ID did not respond to me on the basis of this email. Neither did the colleagues. The colleagues, at least we had a meeting on the 29th. I remember it was a virtual meeting, a very robust one, where I set out, my views, and like all the things that I'm tabling here, I said in the meeting. And I
then
decided.
the subsequent management meetings, was it not discussed? You had been removed as the DDPP, but you still attended management meetings. Was it not discussed at those management meetings?
No, it was not discussed. Like I indicated, in the management meeting, we wouldn't have gone into the merits of cases, because other people sitting in those meetings are not designated to be part of these cases. So if anything, I would discuss separately with Mr. Soko and the relevant people, but not with the other managers that are not designated in the case.
Just on a procedural point, we know that you indicated the new team took over. Is there a handover process when the docket and investigation is moving from one team to another? Because in this instance, these two matters moved to a completely new team, and none of the previous prosecutors were carried over to those new teams.
Yes, ideally, in a normal setup, there should be a handover report. In this case, I'm not sure if Advocate Tlajoayo, who I left in the Mokwele/Khumalo case, did a handover. I'm not sure if Advocate Ramsey did a handover on this one, because when I...
All right, thank you. We can then go back to your statement at paragraph 68, where you deal with the... Oh, my apologies.
Sorry, maybe before you do that, this charge sheet, who would have prepared it? I mean, I ask because in your note where you list the problems with it, you raise quite a number of issues, including somewhere where the charge sheet says accused one gave a gratification to himself, under count 2.
Yes.
You raise those kind of things. Who prepared this? Who would have prepared this charge sheet? Did you get to find out?
Honestly, I do not know who prepared this charge sheet, Commissioner Baloyi. Like I say, the matter was already in court. I do not know who
But
prepared it.
at this point, when you get involved and the matter is in court, Ms. Ramsame you said Ms. Ramsame was responsible for this
She
matter.
was the prosecutor in the case.
So this is the charge sheet that she was working with.
That is
at
correct,
the
which
point.
which
that-
was also disclosed to the defense, I would want to believe, from the date of the first appearance.
Yes. Well, I was saying to the chairperson, gratification seems to be your favorite, the IDEC's favorite fallback or default position. If you don't like someone, you charge them with gratification.
Not like that, Commissioner, but yeah, corruption is a very serious offense that this country is faced with. So I guess we're all trying to root it out, but we follow the evidence as prosecutors and investigators.
Except
at
in
least.
these two cases. I mean, we've had the debate about gratification, whether the charge the charge is properly formulated on your facts, and you've expressed your difficulties with it.
True.
The same discussion was had with the ID, the same discussion was had with Mr. Parayachi and Ms. Ramsame. So at least on these two cases, it seems to have been a default because maybe because nothing else works.
It looks like it, Commissioner Balo, it looks like it, and that is why, like, sitting here, after listening to all the evidence in our work, but it's painful that it appears there were things happening behind our back which we were not privy of, and it appears to me that some of us were used. If you're given instruction, go and oppose a 63, you go in, you think you're doing your work to the best of your abilities, you go and oppose a 65. I mean, I did two cases. Out of this case, I went twice to the High Court with the recusal application and with a 65 bail application, doing what I love, what I've been doing. In next month, it will be exactly 31 years, without knowing that there's other things happening behind the scenes. It's painful, but I didn't know at the time.
Thank you.
Didn't know.
Can we then deal with the response? That's at paragraph 68 of your statement.
Yes, in response to my concerns raised in PS 11 to 13, Chief Perumal indicated in an email that he has had a discussion with Major General Khan, and that is after I've raised the queries. Now, Chief Perumal had a meeting with General Khan and obtained a provisional statement aimed at clarifying some of the queries I was raising regarding the Lushaba incident. The unsigned statement of Major General Khan was attached to Chief Perumal's email. Chief Perumal's response is attached as per PS 14.
And that's at page 136.
Indeed, Commissioners, at page 136 is an email from Chief Perumal on Sunday, the 31st, 2025 at 11:40 to the other investigators, including the prosecutors. Good morning, colleagues. I held a discussion with Major General Khan this morning. He alerted me to his interaction with Lushaba following the so-called housebreaking incident. Please check the affidavit. If necessary, please provide input. If it is fine, Charles, that is Mr. Charles Eels, one of the investigators, Charles can meet General Khan tomorrow to sign it off. The essence of the affidavit is that Lushaba did not want General Khan, who was neutral and in charge of counterintelligence at the time, to be involved or bear knowledge of the incident. The attachment to that email was the affidavit, the unsigned affidavit prepared for the signature of General Khan from page 137 to 139. I read that email, rather that affidavit, and in my response, which I did not attach, I said it's not going to help obtaining this affidavit now. Why was it not obtained 3 years ago? Why is it done after the fact? And eventually this affidavit was never signed off. It's not part of the docket.
Do you know how Chief Perumal came to speak to General Khan regarding this matter?
Regarding this matter. I do not know. I would want to believe because I'm trying to remember if General Khan made a statement in the Lushaba docket. I can't recall now. I can't recall clearly. I don't know why.
Okay.
I know he provided a statement in the Mokwele Kumalo matter, but on this one, I'm not sure. I can't remember.
This is a 2022 incident. In August, I think General Khan says that during August 2022. So this was in 2022.
Yes.
And the statement, obtaining a statement from him is being discussed in August 2025, end of August.
That is correct.
And that's why you
Commissioner
are
Baloyi.
concerned about time
Yes.
that has passed.
And again, in my queries, there's nowhere where I'm saying investigators go to General Khan, obtain an affidavit clarifying the following. I'm querying a number of issues, but nothing about referring them to General Khan. And in his response to me, he comes with the affidavit to say some of your queries can be answered by this. But I read it at the time. It was not helping, and I responded to him to say, even if it's signed off, it's not really helping much. That is why it was never signed off, or it doesn't form part of the docket.
And then at paragraph 70, you say that you then had no further engagement or involvement in the CI matters going forward.
Yes, I had no. I see there's a mistake there. I had no. You should read. I had no further involvement in the CI-related matters moving forward. And in conclusion.
Before you
the
do the
conclusion.
conclusion,
Yes,
sorry,
okay.
before you do the conclusion, this General Lushaba matter, why is it an IDEC matter? As when one considers the mandate of IDEC.
According to me, Commissioner Baloyi, it doesn't fall in that category of cases that must be. And I stated it in one of the emails.
It's on
which I've attached.
102.
That is correct, Commissioner, where I said, to the colleagues, does this case fall under the mandate of the IDEC? I was of the view that this doesn't. And it's one of those cases, even if, like I'm saying, even if you refer it to the other courts, to the lower courts, you're really burdening them with a matter where there's no prima facie case. You rather deal with it there, close it off, write your report, giving your reasons why, so that it's filed and there's a report, not to pass the buck to other people. But as at the time I read it, really it was not meeting our criteria.
Do you ever get a response to that question? Why?
No, this one I didn't get a response to that question, Commissioner.
Thank you.
Advocate Serunye, since your involvement, in fact, pre your official involvement in the two matters, you've noted consistently in your statements that there were a number of irregularities and things that didn't make sense. Yeah. And in fact, when you get the dockets, you note that in both instances, the investigations were wanting. They were not at a stage where suspects ought to have been arrested. Over and above that, you've seen procedural irregularities where your own manuals and operations were not followed. I know you've explained that having heard the evidence before this commission now, you now see that there may have been other issues at play. My question is, you've said to this commission, you have 30 years of experience. IDEC is a specialist organization. It has experienced prosecutors, skilled investigators. Now you look at these two matters and you can see by all accounts There's nothing there. It shouldn't be before IDEC. There's no investigations. Nobody should have been arrested. Nobody should have been charged. Both charge sheets, you say, are defective. At the time that you now see all of this, now you have a full scope of the picture, having studied both dockets, and in fact engaged both the other prosecutors and investigators on your issues that you had. What conclusions did you draw of what was transpiring within IDEC, particularly in relation to these two investigations?
Look, Council, what I could figure out at the time, and I'm saying this based on the fact that on the side I was also getting complaints from the prosecutors, Advocate Hlachwayo and Advocate Ramseni, about how the investigators are not listening to them and how they've been, some of the issues that I've been raising in my emails and in my memos. The two prosecutors also did the same. They showed me a document which they directed to the Office of the ID with a lot of queries. And I think it was around same time of August 2025. So they were also of the view that this matter is not ready, but they were not getting the relationship between, looking at the relationship between the prosecutors and the investigators was not good. I sort of got a sense that this, and I don't want to, because there's some officials there. Mr. Charles Ills was still new in the office. Mr. Pet Mlambo, it's a very nice, good guy. I was starting to work with Mr. Brian Parayashi for the first time. I didn't know him. He appeared to me to be a very committed investigating officer. I don't know, but I mean, they made a lot of mistakes here. It appeared they were rushing this case. I didn't understand then, but if you look at it now, it appears there's some conflicts between these investigators and the investigators in crime intelligence. It looks like, I don't know what that could move. Brian used to work for crime intelligence. I don't know if we are resting because we want, but you can only see these things after the fact. At the time, you don't notice. You realize things are not being done properly. Investigations are not going well. This case has loopholes. The two cases were not supposed to be in court. And you're coming in after the fact. If I was right at the beginning of these investigations, maybe with the help of the prosecutors and we could have driven the investigations better, and if nothing came out of them, closed the files. But now, you come after the fact, you're supposed to, correct things that have been done. You don't realize some of the things at the time. But yeah, there's something that was going on then that I didn't see at the time. I can see it now. There's nothing that I could do at the time.
I guess.
But my emails, are telling the story. I'm questioning and raising these issues, not only with the investigators, but with the ID, with Mr. Soko, that these cases were rushed to court, and I'm raising a lot of issues here.
Do you not think it's worse than rushed to court? In fact, based on all of your memos and emails, it's not only an issue of rushing, that's the least of the concern. The issues you don't have a case, and in the other, you shouldn't even be investigating. So it's far worse than that.
I agree with you, Council.
And then the second thing is, from what you're describing of the investigations and what this commission has heard about the investigations, either they are bad, and maybe this is the norm and this is what you see, and so you didn't quibble too much, or this must have been so bad and such an anomaly that you have to ask yourself, what exactly is at play?
Yes, which is what
because you're also looking at it, my apologies,
Sorry.
from an experienced mindset, and you are not involved throughout. You have the benefit of looking at it and seeing it.
Yes,
And the last thing I'll say is that one of the witnesses we consulted said they chose not to see some of these things. And so I wonder, did you see and not say anything in the sense of saying in harsher terms? Or is it that the environment was such that there wasn't scope to do that? So what you were all doing was just trying to manage within that difficult space?
No. Commissioners, I expressed myself. My emails are saying it. When I don't agree with something, I say it. When I agree or some person does something that's good, I commend them. I express how I feel about things. And I wouldn't have kept quiet. I wouldn't have kept quiet, and that's why I said earlier to the commission, it's a pity I went out quick. Around 16th of September, I asked to be recused and only concentrated on the. I wouldn't have prosecuted these cases, taken them to court for trial, if I remained in the cases and all these queries were not answered. At some point, my reports would have been, these cases might be withdrawn, I would have engaged the ID, but I went out before doing that. But at least there's a trail of my emails where I'm expressing my views about this. These cases were not properly investigated. And in some of them, like in the Lushaba case, I don't even understand what the charges are there.
And then just on internal protocols, what exists for something like this not to transpire? From what you've said and one witness has said, it seems that the only mechanism that exists is you sort of raise these concerns, and a lot of people raise them with Mr. Sissoko as well. But it doesn't seem like there are any internal checks and balances and protocols to ensure that this doesn't happen, or when concerns are raised, they are dealt with effectively.
Yes. Thanks, Commissioners. Yes. These two cases are exposing us. And in a way, and as I was talking to some of the colleagues back at office, I said, things that this is happening, so that we should reflect, we should go back. At some point, you might go on and on thinking that you are doing things the right way, and you need a moment like this. It had to take IDEC officials to do wrong things, arrest people prematurely, for IDEC for the president to gazette and order that the commission be set up, so that we should find our way. It is that storm that comes and cleans, and after that, I can only hope that everything will run smooth. We're trying our level best as managers. Like I said, the organization does not have a head at the moment. We're trying to talk to employees. One of the guys was saying, Advocate Sirunya, I only joined from Durban in May, and I was intending to relocate my family. Must I go back? And I said, please, 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 we need all of you, hands on deck. This is the moment where the NPA and IDEC needs each and every one of you. This happened for a particular reason. Out of this, we must come out, IDEC must come out, a better organization. We must go back, have our strategic planning as management with the help of experts. If we have to look at our manual again, redraft it, have processes, protocols, like you are saying, Council, know when a person is not doing things in accordance with the rules, what steps should be taken at that moment. We should avoid situations where people are seen to be favored. These ones are untouchable, and so on. We must have a way of operating an organization. And thanks that this commission came up. And we're also looking forward to the recommendations, which will also help as we go forward rebuilding this very important law enforcement component.
Can I follow up on the first question that Ms. Bowe asked, which is, if you recall, about whether people were looking away, choosing not to see, or looking away because they don't want to get into trouble, or it's simply a matter of incompetence. I don't subscribe to incompetence on these facts here, especially for an organization like IDEC. You know, I think one would have to give up on IDEC if one thought you are that incompetent, your office. An issue, and my follow-up is on an issue that I was going to raise with you, and I raise it now because you're going to the conclusion, and I think it's an appropriate time now. And this relates, it's still a similar theme to the first question that Ms. Powe asked, but this relates to the bail issue. Now, Ms. Johnson testified to what happened, what that was all about. And the question asked of her was, who makes the decisions about we are going to oppose bail or we are not opposing? Who makes a decision about we're going to oppose the appeal or we are not opposing? So we had that engagement with her. But of particular interest to me is your role. You were in court when the bail condition, the contentious bail condition was imposed, which is these accused, they must not go to a crime intelligence office anywhere in the country. You were in court. You know that condition was not asked for by the state. But we also know from the appeal record that there was an engagement between the magistrate and Ms. Tlhatswayo about the need to protect witnesses. And Ms. Tlhatswayo's position was, we are not concerned about that because we have not given out names, and so we are not concerned about them going to the office. And yet the magistrate issued that bail condition, that they must not go anywhere into their offices. And if they needed anything, they must speak to Mr. Parayachi, to Colonel Parayachi. Now, Ms. Johnson testified, and I paraphrase very much what she said, that had she was not aware, she was not made aware that bail condition was not requested by the state. Had she been made aware after the fact that the bail condition has been, this bail condition was given, and it wasn't at the request of the state, but also the parties were never given an opportunity to address it, she would have, as any prosecutor should, as a responsibility to the court, and your ethical responsibility is you go back to the magistrate and you say you have to undo this. I don't remember the exact terminology, but you go and seek for it to be set aside because you didn't ask for it. And had she been aware on appeal, when this matter went to appeal, of that fact, that it was never asked for, she would not have supported you opposing the appeal. She depended on briefings from her officials, and she never got a briefing that this bail condition was given in the circumstances in which it was given, and every prosecutor has an ethical duty when something like that has happened, to go back to court. In fairness to the accused, your responsibility to the court, you go back to the court and say, you have to undo this. Now, you were in court. You knew that this bail condition was not asked for. You did not do what she says, what Ms. Johnson says any prosecutor would do, because you have an ethical duty for that. But not only do you not go back to court or tell Ms. Tlhatswayo to go back to court, you in fact prepare and argue the appeal. You actually oppose the appeal on this condition, and you prepare the papers. In court, you do end up conceding because the appeal court is looking at the record, right, and says, but this and that didn't happen. You end up having to concede that because that's only fair to do. And the question is, as Ms. Powe says, but how do you reconcile your position as a prosecutor who must prosecute matters without fear of favor or prejudice, who must be fair to accused as well. And therefore, and as part of your obligations as a prosecutor, is well, if there's material that's favorable to the accused, you have an ethical obligation. And I know your code of conduct says that because I've seen that there. You have an ethical obligation to disclose even matter that is favorable to the accused, even if it's going to help them. Your job as a prosecutor is not to get a conviction or to get an incarceration at all costs. That's not your job. Ms. Johnson, having described what would have happened had she known, that's what she says, had she been briefed about this is what she would have done. Assume for purpose of my question that she wasn't briefed, because she's not my focus now. My focus is your actions in this, that how do you reconcile your role as prosecutor who knows the truth about this bail matter. You don't go back to court, and on appeal, you actively oppose the appeal. And before you comment, let me add something else that she said, had she known. She didn't understand how you would have gotten a condition that they don't go to any office in the country when in fact they're only based in Pretoria. And she didn't understand, and that was wrong for it to be in the bail condition. So that's one of the things that she said. She would have said, go and fix this. Explain how we reconcile your role and your position with what you did with this bail matter.
Okay. Thanks, Commissioner Malloy. Firstly, like I said in the beginning, I was not part of this case. My first involvement is going to court to try and help a junior. I did not know how they had planned. I did not know the facts of the case. I did not know whether we were opposing bail or not. But what I realized was they were not even ready for the bail application, because when I asked for a bail statement from the investigating officer, I realized they don't even have one. So they addressed the court from the bar. So, but what I'm picking up from the evidence of Mr. Parayashi is that the prosecutor had been instructed to ask for that condition. I think Parayashi said that he spoke to the prosecutor on the day to say, ask for the condition, and that the prosecutor did not ask for the condition. Therefore, going to court, their plan, which I think they would have discussed then with the ID head, was we're not going to oppose bail, but these are going to be our conditions. Therefore, I find it difficult when Advocate Johnson says she did not know about the condition, because based on what I hear from Mr. Parayashi, they were supposed to ask for that condition, but it was not asked for. But then the second point is, and I indicated that earlier to the court, I said when I was brought in, it's for two reasons: to oversee the two cases, but most importantly, to prepare for the bail amendment, which is coming on the 13th of August. So Advocate Johnson knows that there's going to be a bail amendment application. So I'm brought in to oppose that. It was not my choice to oppose it. I did not come in and say, give me the part of opposing this. I'm brought in to oppose that because she says the defense has a lawyer who is senior in her own right, and therefore I need you at that level. Now, what happened after the bail application and the first appearance, whether the prosecutor, Tlhatjwayo, did not brief her, that I wouldn't know.
Even allowing for that, sorry to interrupt you, yes. Even allowing for that Ms. Tlhatjwayo did not brief her, you are now in the matter. You know what happened in the lower court at the time of the appeal, as you prepare the appeal. Why do you not at that point say, by the way, ID, you're saying I must deal with the appeal. Yes. But in fact, we did not ask. I was in court. That condition was not asked for. I'm assuming that you don't see anything wrong for purpose of my discussion with you with this wide condition that applies across the country. Forget that, don't deal with that. But you know it's a condition that was not sought by the state. She says to you, prepare for bail, right, for opposing the bail appeal. At that point, why do you not say, because now you're in charge, why do you not say to her, by the way, it's a condition that we did not ask for. The magistrate gave it of his own initiative. We didn't get to address him, the accused did not, and as an ethical prosecutor or prosecuting body that we are, IDEC, we cannot or we should not oppose this appeal. Why do you not do that?
Yeah. Commissioner Baloyi, there was, and this is my personal view, and there was nothing wrong with what the magistrate did. And I said the Criminal Procedure Act allows him to do what he did. Section 60, subsection 12 says the magistrate can impose any conditions which in the interest of justice would make him to come to it. So even though the state did not ask for that condition, even though we did not address him at the time, the prosecutor did not address him, he imposed the condition after listening to the exchanges. There's this thing that comes up about witnesses. We don't want to list them, but we don't want them to be interfered with. There's other investigations that are outstanding that I remember the prosecutor put on record. And having listened to that, the magistrate then gave this condition. Only the magistrate can explain why he gave that, but the law allows him to do that. And when I get instruction, go and defend it, it is on the basis that I know that there's nothing wrong that the magistrate did. And it is on the understanding that the unit wants that condition to stay. And that is why I'm going to defend. I couldn't say, yeah, but why must we defend this condition because we did not ask for it? Yes, we did not ask for it, but we wanted it if one follows the evidence of Padayashi and what he says he told Advocate Tlachwayo. He said he told Tlachwayo, ask for this condition. He's amazed also that it was not asked for. So that means the briefing was asked for the condition. It was given without being asked for. There's nothing wrong, nothing on our side that we did wrong as the prosecution, and therefore to defend it was proper at the time because it is a condition that the team wanted all along. The only problem is that they did not ask for it. But on the side of the magistrate is entitled by law to issue those conditions. Even if we do not address him on, the magistrate can even deny an accused bail where we say we don't oppose him bail. We don't view him as a flight risk. Our investigations are completed. The magistrate, listening and looking at everything that has been presented to him, can do that on reasons, good reasons, lawful reasons.
Yes, but in this case, there were no reasons. That's where I have a problem with what you're saying, that it's a point you had to concede in the appeal court, right? That in the absence of reasons. And the part of the judgment that we are looking at, of the appeal judgment that deals with that bail interaction, there are no reasons, even in the engagement. In fact, your prosecutor keeps saying, and I struggle to understand that you think that was okay, that the prosecutor says, these people don't know the names of witnesses. They don't know who we are going to call. So there's no problem with protecting, which seems reasonable to me in the circumstances that, of course, if I don't know witnesses, how could I ever interfere with them? So the prosecutor, Ms. Tlachwayo, takes that position. The magistrate nonetheless gives her the bail condition. You know, as you sit in court, that the accused have not had a chance to deal with this. That's why you conceded in the court, in the appeal court. And I do have a problem that you defend this on the basis that, well, the magistrate can impose any condition. I don't think that's a correct position of the law, that wide. The magistrate could have said to them, you can't visit your mother because it's a bail condition, you would not struggle if I said to you, but what condition is that? That's an unreasonable condition. You would say to me, yes, of course it is unreasonable. So it's not as wide as he can pick and choose what he wants to do. But we are not even debating that. I'm raising with you what your then boss said about this, which suggests she was misled by the people that went to court, because that's really the essence of her testimony, and that includes you. She was misled by people who went to court in that they did not tell her that the magistrate gave us this condition when we did not ask for it. And she says, and she says they have an ethical, as prosecutors, we have an ethical duty when something like that happens, to go back to court and say the parties were not heard, we didn't ask for this, you have to undo it. And if we have to argue it again, we'll argue it again. I was misled. My people failed me who went to court. So colloquially, she's throwing you under the bus, saying, are you saying you disagree with her that which she said should have happened, that you should have gone back to the magistrate. On appeal, you should have been the one that volunteers to the court, that this is what happened in the lower court. Are you saying she's wrong when she says all of that?
Commissioner, what I'm saying is, indeed, she's throwing me under the bus in that she got me into the case to oppose the 63 bail amendment. But when she comes before the commission, she says something else, that as if I was doing things on my own. If she didn't instruct me to be part of the case, I wouldn't be sitting here today. She involves me in the case. I don't know what the brief to her was by Tlatrayo, but she says specifically, because there's a senior lawyer involved there, I want a senior person to oppose this. And if she was of the view that, no, you were not supposed to benefit from that wrong judgment, and her instructions to me were supposed to be, go back to the court, lodge an application in terms of Section 63. The state, be an applicant yourself, where you ask the court to amend the bail application. 63 allows either the accused or the state can bring that application. But she didn't say to me, or to us at least, go and amend the bail condition because we did not ask for it. She said, oppose the application. We do that. But in the back of my mind, I'm not following, I can't follow, I'm not going to follow a wrong or an irregular or an unlawful instruction. I'll have never done that, I'll never do that. In the back of my mind is, the magistrate was not wrong. The magistrate has powers to do that, but we're going to oppose. That is why, even when it went on appeal, again, with her blessing, we went and opposed it still. I engaged the High Court judge, took me to pieces. I tried arguing for my case. I did not get the first thing considered. I tried, and I said, this is what the law says, this is what the magistrate said, and these are case laws where I even referred the High Court to a case in Bloemfontein where an official of the NPA committed fraud against the NPA at the DPP's office, and one of the conditions there by the magistrate court was that he's barred from entering the NPA offices in the Free State. I raised that in our heads of arguments in the High Court, and that was confirmed in the High Court, where the High Court said those conditions must remain, and the magistrate must just add other conditions. So it happens. The powers are with the magistrate. It appears the IDEC wanted that condition. The head says to me, go and defend this. I can't say to them, no, why? And so I did that, and the amendment was abandoned, the application was abandoned. The Section 55 is brought in. Again, I'm giving instructions to oppose the Section 55 bail appeal. So I'm very sorry for the head to come before this commission and say, portray me as having acted on my own without consulting. It's just not true, and I do not take kindly to that, because she brought me into the case for a specific purpose, to oppose the application and to oppose the bail appeal. That is why when I wrote a memo to her to say I'm recusing myself from the case for the reason I gave, she said, yes, it's fine, but please proceed and finalize these bail amendment and bail appeal. Take this one through. Did she know what she was setting me up for? I don't know. I thought at the time I'm just doing my job. I cannot sit here and say I was acting unethically. I did not. I did my job to the best of my abilities.
Yeah. Can I just say lastly from me on this, and I've heard your answer. As my recollection of Colonel Padachi's evidence is that he says he doesn't know where this bail condition comes from. He left court while Ms. Tlajwayo was still on her feet. And at that time he left, they said not come up. So maybe it happened after he left. That's what he has told us. But you have said earlier that he stayed for the whole time and left only when judgment, he missed just the judgment, so I'm mindful of your answer. But I must say that at best, it's a coincidence at best that a condition, on your version, a condition that was not asked for by the state, in fact, gets, and is not raised in open court, gets given by a magistrate, and a condition of this type, which is these accused are prohibited going to any crime intelligence office across the country, but two, the consequence of that condition is effectively they get suspended from their offices, from employment. It's quite a coincidence.
It is a very strange coincidence. I agree.
You accept that?
And if one looks at the evidence that is now before court, really one cannot rule out anything. But unfortunately enough, the prosecutor on the day, fortunately enough, she did not ask for the condition, but then it's given. But for me, who was an outsider, I'm thinking, well, the magistrate has powers too. That is why we innocent prosecutors who are just doing their job. And if there was any thing sinister going behind the scenes, it's something that we didn't know.
Thank you. Thank you,
Is
Mr.
it possible that this condition could have been discussed with the magistrate before the hearing started? Is it possible that the prosecutors went to the magistrate chambers and said, look, this is what we are going to ask for? The reason I'm asking you this is you have just confirmed that it is a condition that Mr. Padiaki and the prosecutor had discussed before. So on their way there, that's what they wanted. It was just not discussed in open court. And then it becomes a coincidence that the very condition that they wanted, but they did not ask for in open court, is a condition that is attached to the granting of bail. So where else could the magistrate have got it from? And a condition that is so specific, if they had not discussed it with the magistrate, either during the hearing or prior to?
Yeah. Yes, Commissioner Kumal, one thing for sure, it was not discussed, at least in court, no, not in my presence in court. If it happened in some passages, in some corners there in court, I wouldn't know because, like I say, I was back at the office when they're rushing me and my two other colleagues to go and help. And yes, it's strange. It's strange. But, and again, like, because no reasons are given, and that is why I understand what Commissioner Baloyi is saying, and which is what ultimately said by the High Court. The two parties are not engaged. It's like already the magistrate has made his own decision that I'm going to grant this. But I didn't suspect anything. I'm sitting here even today. I don't know. If things happened in those offices in court, again, it speaks to what we're hearing now. Things that we didn't know of, and it will be a sad thing for justice in this country if cases were discussed in offices, especially conditions of this nature, which will have a very critical impact on people's livelihood and their freedom of movement and freedom to go to work and fend for their families. If that was discussed before coming to court, it would really be
And
very
just
sad,
to be
sad,
clear,
sad.
I'm not suggesting that that's how it happened, because it would be unfair to the magistrate. No witness has said there was a discussion with the magistrate before the hearing. I'm simply asking because, you know, we are on a fact-finding mission. We are exploring all possibilities. And if you know anything, we want you to get the opportunity to comment on it. Because it may be that when other witnesses come here, we will ask them the same thing. So it's only in that context that I'm raising it. I'm not suggesting that there was a discussion with the magistrate. I'm not even suspecting that there was one. I'm simply asking because it is possible.
Yes, I hear that, commissioners. In my presence in court, that condition was not discussed or asked for by the prosecutors or by anyone. What happened outside court, I do not know.
Commissioner Baloyi, during your engagement with the witness, the issue of the instruction to appeal from Advocate Johnson came up. I've been advised that Advocate Ramsamy will testify that Advocate Johnson gave instructions approving the appeal based on Mr. Pariachi's affidavit, and she then sent a WhatsApp to Advocate Ramsamy instructing her to then inform Advocate Serunye and Advocate Shajwayo that will come out in evidence tomorrow, including that this was something that was discussed, but Advocate Shajwayo didn't ask for that condition in court.
Thank you, Ms. Ball.
Advocate Serunye, you can then deal with your concluding remarks at paragraph 71.
Yeah, no, thanks, commissioners. I think the only thing there by paragraph 71 is what I've been saying throughout the day, that, and it reads, I would like to state that my involvement in this matter, which was after the accused's appearance in court as aforesaid, was for good intentions and part of my daily duties. I deposed to this affidavit in order to place my account for these matters on record before the commission. I then signed the affidavit, and I stand by the contents of this affidavit.
All right.
See, yours is signed in Pretoria and stamped in Pretoria.
Mine is signed in Pretoria, Commissioner Baloyi.
Commissioner Baloyi, I can say when the Commissioner of Oaths was here, he called me to the office and said, you double check, I don't want to be called by your commission. Chair, I don't have any further questions for this witness.
Advocate Serunye, thank you very much. You are excused. We adjourn and resume at 9:30 tomorrow. We would like to see counsel outside. Now, please, let's adjourn.